one extra line has been issued, and day after tomorrow, my bid will not be considered. Yesterday, I have received this letter.
What letter?
From the tendering authority that the banker, the certificate issued by the banker provides one additional line as to what is the amount written in my account as credit facilities. And that line tendering authority should not have been there. That is what they are asked for in the tender document. Now, day after tomorrow, the tender will be open without my bid. I have filed, I have served everything I have done, Lordship. Kindly keeps it tomorrow, Lordship. Otherwise,
Tomorrow within 5 minutes.
May I have your Lordship's kind leave to mention on requisition urgent basis. Lordship, I am the L1 bidder in a tender process. Now, since the letter of intent was not issued or work order was not issued, I prefer a repetition before this honorable court. Your Lordship was pleased to dispose of the repetition on 18th of December 2025, holding that the action of the Howrah Jilla Parishad is bad in law and directed to take steps within 8th of January 2026 in furtherance of the contract. What they have done is now they have cancelled the entire tender process, which they cannot do. Lordship will kindly just see paragraph 6 of your Lordship's last order. It's very urgent, your Lordship. I am the L1 bidder. Paragraph 6 and 7. What was your Lordship's direction in the last writ petition? And the order impugn is, Lordship, the next flag, Lordship, the one-liner that we have cancelled the tender process, which is totally contrary to your Lordship's directions. Just a one-liner, we have cancelled the tender process. Lordship kindly grants me leave to move this on an urgent basis tomorrow, your Lordship.
No, they have cancelled when they have not published. No, you file the writ challenging this cancellation.
Yes, I challenge the Lordship kindly grants me leave to
challenge it. If in the meantime they are publishing any tender notice, you mention.
This 5th February is under challenge. In this petition, that is under challenge. Lordship kindly grants me leave to move it on urgent basis tomorrow or any day subject to
urgency.
Urgency is I am the L1.
See, that's why this court passed and they have rejected.
Yes.
Correct. Now, if it is rejected, they have to publish a fresh tender.
Yes.
You have already already challenged. You're going to challenge that cancellation order.
I have challenged the cancellation.
Cancellation order. If you challenge the cancellation order, in the meantime they are publishing any tender notice, you mention it. I will take the matter. Let come through. All the matter cannot.
I will file. I will serve.
You file, yes.
Just let it appear on a particular date, your Lordship. Kind.
I can't. That's why if they're publishing a tender notice, you come to them. Or please wait a week. If it is not published, I will take them.
I shall file and hand over the number to your Lordship.
Correct. Yes. Today is not the mentioning day.
Night, one notice has been published by your Lordship's passed an order in earlier occasion as regards to the correction of update. Lordship passed an order directing the UTI, Unique Identification Authority, to rectify the name of the minor. They have rejected on the ground of same plea that the gadget notification is required. So far the West Bengal party is concerned, a minor cannot publish a gadget notification. That I have annexed. Your Lordship's order is also annexed. I mean, 8th night, the National Testing Agency published a notification. By 8th March, it will be end.
8th March. 8th March is the last day.
By this time, only 15 working days I will get.
Otherwise, when the order was passed?
Your Lordship's order was passed on
No, the rejection.
Rejection order I have received on 8th. Only 8th I have received. Yesterday the petition was made ready. That's why I could not mention. Next week, any date as per your Lordship's convenience.
List the matter on 19th February within 5 matters.
Within
yes,
the Lordships.
I think I have come on a wrong day to mention. Sorry, but we are given the mentioning notice. Looking at the urgency, I should be candid. This is paralyzed, octogenarian, and plastic surgeon who has purchased a flat in Kolpak, Mubawa. That flat is being it's a KMDA property. Now, the deed is not being registered. Now, while pursuing them, while going to the Salt Lake office, he has met with an accident. He has two beings have also now become he cannot move. Now, he even could not sign and affirm. His wife has come and signed and affirm. my lord, on a humanitarian ground, my lord, I should not be urgency, my lord, like this. Any day, my
What
lord,
you have prayed?
my lord, I have prayed for
I think
registration.
yesterday it was moved.
No, no, no. My lord,
Yesterday.
it was due to be late reasonable on third. My lord, it-
No, and anybody's mentioned this matter. Mentioning list? Hmm.
I'm mentioning Millard. I took the chance because Millard, I saw him. Millard, we wanted to Millard get the deed registered. Millard, his wife is 18 also, she is also 70.
Who will register the deed?
Millard, the
Property dealer?
paralyzed person who has suffered.
No, they want to sold the property, want
No,
to
they have to
purchase
get the deed registered in their name.
in
So
their
that in
name.
future they can take steps.
Hmm.
Millard, they are only Millard, the petition is counting days.
Who is the seller?
No, nobody is selling. The KMDA is not
Acha, KMD is not registered.
registering, so that in future somebody happens to him that he has a document, his wife has a document with him. That's the only difficulty. Millard, I will not plead urgency so much, but Millard, any day, whichever commences to your lordship, my lord can take up. My lord keep this matter. That's the only request to your lordship.
26th March, 26th February, within 5 minutes.
Okay.
Lordship, may I ask kindly, my lord, to move an urgent motion.
What is the urgency, sir?
Agencies, my lord, I participated in the tender floated by the Birbhum Jila Pollution. This is the toll bridge tender. Now, my lord, I have been disqualified in the tender process without giving an opportunity of hearing.
Toll bridge already, I think one matter is decided.
Brother has filed one matter.
Ah,
I
that
am
is
the second brother.
that is decided with regard to the 2% or 10%.
My lord, that is decided with regard to that I have been disqualified on the ground that the PWD dues are pending. These are alleged dues. I have cleared, I paid all the amounts. My lord, on that ground, without asking me, without seeking an explanation from me, my lord, I have been disqualified. And well, supersonic speed, they have given this tender to the blue-eyed boy. My lord, same day tender opened, same day, my lord, provisional work order issued, same day letter of acknowledgement issued, same day license fees paid, everything has been done, my lord, on supersonic speed. Your lordship may kindly
So
give
what
some-
remains? What remains?
My lord, it is a provisional work order. My lord, it is a provisional work order. My lord, I will be, my lord, I am, and I'm paying much more higher charges than him, my lord. I'm paying much higher charges. But still then, my lord, it has been, my lord, it is completely arbitrary. Lordship may kindly takes it up any day, my lord, subject to your lordship's kind sanction, my lord. Lordship may kindly give some precedence.
17th crore.
Lordship,
With the lordship's,
I'm getting
with the lordship's kind leave, my lord, a writ petition.
17 within 10 matters.
My lord, my building, my lord,
No further. No. Come Thursday.
only one
What is
urgency.
the urgency?
Malad, the tender was bloated. First call, Malad, that without having Malad minimum fee, Malad.
Have you gone through the cause list? Have you gone through the cause list? Then
On third, it was mentioned to your lordship.
yes.
Malad, it was mentioned to your lordship directed Malad to file the matter and mention. On sixth, it was Malad filed. It was given sixth, and it was filed on third. But it is not being listed. Malad, they, Malad, in spite of having three eligible Malad technical eligible bidder, they have cancelled the second call. Only on the Malad background administrative reason. Nothing has been disclosed. Only two-liner order Malad.
What, the tender cancelled?
Tender cancelled and they have floated the subsequent Malad fresh tender.
So you go and participate. What is the
If the second tender is Malad, they have changed the criteria. They have changed the criteria. Malad, I will satisfy your lordship Malad. They are Malad going.
where is the urgency? There is no urgency.
The 9th Malad is the date for the opening the Malad technical bid.
When?
9th was there. Now, Malad, I mentioned on 3rd. But if you lordship direction, I filed giving the date on 6th. But if the matter is not hard, Malad, immediately, Malad, this matter will impact you.
Okay, you do one thing. Fix the matter tomorrow as urgent motion. I will see whether it will taken up or not.
Lordship, may I be
As a normal, huh? No, urgent matter, normal.
Lordship, may I be permitted to mention one matter for inclusion?
नीचे जाना.
Lordship, may I be permitted to mention
No further mention.
My
Yes,
lord,
call the list.
my lord, my
Call
lord,
the list.
I am in person, my lord.
Come Thursday in person or in or advocate.
not regarding the inclusion or anything, but the item that is fixed at provisional side at 3 o'clock. I'm told that there is a possibility of a secret that I have been in some difficulty. My engineer will be there.
My lord, I'm objecting. I'm appeared for the respondent matter, objecting to this adjournment, my lord. It has been since 1 year.
Okay, come at 3, I will see.
My lord, I have already prayed for adjournment in the title suit that is there in the Alipur court, my lord.
Okay, I will see. Come at 3.
My lord.
My lord.
Come at 3.
May I mention for
Let them complete the required, my lord.
inclusion in the list, my lord?
Today is not the mentioning date, my lord. Considering the facts and circumstances, this court is of the view that without submitting any reply, without requesting the respondent to supply the document, the forensic audit report after the receipt of the so-called notice, the petitioner have invoked the writ jurisdiction, according writ petition dismissed. However, the dismissal of writ petition will not prevent the petitioner to give reply to the so-called notices. Call next.
Lordship, I beg to appear for the respondent in this matter.
1, 2, 3.
What you are doing? How it can be?
Considering therefore that this court finds the petitioner has specified the document which the petitioners are required to give the proper reply to the so-called notice, but without any reason and without considering the request of the petitioner, respondents have passed the impugn order. The impugn order is set aside. The respondent directed to supply the documents as requested by the petitioners in their reply dated so and so within 2 weeks from the date. And if the documents are voluminous, the respondent shall allow the petitioner to inspect the document within 2 weeks from date, and the petitioner shall complete the inspection within 2 weeks thereafter. On receipt of the documents or completion of the inspection, the petitioner shall liberty to file their supplementary reply within 2 weeks. On receipt of the supplementary reply, if any, the respondent shall pass necessary order within 2 weeks thereafter. Call the third. 3 is dismissed because you have not given the so-called reply. 4th is set aside. Supply of the document, inspection of the document, and file. 1 and 3 is dismissed. 2 and 4 are allowed. Yes.
My lord, this is restoration application.
Lordship, I beg to appear for the respondent in this matter. In all probability, Lordship, this is a SARFAESI related Group 9 matter.
It is not SARFAESI, my lord. It was dismissed for default on 22nd September.
Let me see.
Yes, yes, yes. And my lord, within 4 days, my lord, it has been, my lord, restoration has been filed. My lord, I am not aggrieved by the SARFAESI action.
What is the prayer in the main writ petition?
Yes, my lord. It is, my lord, prayer at page 13.
Assign the petition, main agent, ground floor of the premise situated
To take out my property. The property, my lord, was leased out to me. The property was, my lord, physical possession was taken under the SARFAESI Act. I am not aggrieved by the SARFAESI Act. What I am on, my lord, the properties, those belongs to me, that is tenants, my lord, those may be directed to be authorities to, my lord, open the padlock and let me take out those property. This is my innocuous prayer. My lord, will find the tenancy agreement, my MSME registration and everything are there, my lord.
What you have prayed for? Respond number 2 and 3. 1
Yes.
and 2. What are the respond number 1 and 2?
My lord, they are
Lordship,
the authorized officer
Aditya
under the
Birla Finance
SARFAESI Act.
Limited.
Then,
I'm not aggrieved by the SARFAESI action.
so?
I'm not aggrieved by the because, my lord, the properties belongs to me. Those who are not mortgaged, the immovable property was mortgaged. That can be taken, my lord, care of by the, my lord, secured creditor. But the property of the tenant, that is my client's, my client was a tenant in respect of the property in question, which has been, my lord, mortgaged in SARFAESI under the SARFAESI Act.
Who is the owner of this property?
Yes, my lord.
Lordship, respondent number 3.
Three.
Respondent number 3, Lordship.
I'm not.
Respond number 3.
Yes, Lordship.
Authorized officer.
Lordship.
Oh,
No,
no,
Sonali Bera.
Sonali Bera.
Yes.
I am
And
only.
who are you?
I'm the tenant.
So, how the writ petition, the owner and tenant?
No. I am the physical possession was taken by the under the SARFAESI action.
Correct.
And
who has taken the possession of the premises in
1 and 2.
1 and 2.
One
That
and
is
two.
the authorized officer of the bank.
Under the Act.
Under the SARFAESI Act. and you are the tenant in the premises in
Yes.
question.
Yes.
Now the bank has taken the premises. Now what you are praying for? You have been allowed to allow.
No, 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 no. I want, my lord, to take out my immovable properties which are lying in the
Only taking out.
taking out. My lord,
Taking out.
kindly see that they are innocuous.
Lordship, the only problem is I am not aware about any tenancy. Since I have not been made aware about any tenancy, I can't allow any third party to come and claim tenancy and remove properties. Then the original owners themselves will say who has
Who is
given
the
you the right.
original owner?
Three.
Boris, 3 is not appearing here.
And my lord will
And Lordship,
find.
this is an action taken under the SARFAESI Act.
Yes.
That's
Even
correct.
if I have
He is
to
not.
allow him to remove the properties,
My
he
lord,
has
my
to
lord,
come up with
kindly visualize the situation. My lord,
That's correct. But once it is in the surface property, so it is the bank to take decision. If they auction, you approach the bank.
Lordship,
I have applied.
they have never
have
come
applied.
before the bank. They have
My lord,
never
kindly have a look to
represented
order
to
of
me.
the learned my lord Chief Judicial Magistrate, page 31. By under this order, my lord, they have taken the physical possession. My lord, from 1, 2, 3, fourth paragraph, my lord. My lord, go to the page 31, fourth paragraph. The gist of the fact is that in course of the availing the financial assistance by of securing and mortgaging the immovable house property. I am not agreed with this. The bank under the SARFAESI Act can sell whatever they want to, like, my lord, they can do. But my property, those who are not mortgaged, that is movable property, movable assets, my machineries, my lord, are specifically mentioned. Because, my lord, on that day, my lord, they have put padlock and not allowed me to enter into.
Correct. So
I
under the SARFAESI Act, they have taken the possession.
I am not agreed on that.
Correct. So what now you want?
I am taking out. I am only
what
taking
are
out.
what are the furnitures and all these things? It is of you being your tenant.
But it is, my lord, it was a factory, my lord. It was a factory.
Factory.
My lord, I have mentioned.
So I don't know what is the schedule of property in the SARFAESI at the time
That's
of
the
the
thing, Lordship.
possession.
Well,
And Lordship,
SARFAESI Act, my lord, from the order, it
look at the
appears.
order.
Let me, please. Under the order passed by the CJM, it appears that the immovable properties were mortgaged. They can say, because someone's other's property cannot they mortgage. And the order of the CJM specifically says, my lord, the immovable property. Kindly come to page 31 once again, my lord. And my lord, page
from the documents filed by the applicant. You are the applicant. You are the applicant before the author.
Bank secured creditor.
Secured creditor. Applicant is appear the scheduled property have been given equitable mortgage. Respondent for the applicant that took the loan amount.
And the property
filed in physical possession of secured assets. With the affidavit filed with.
And my lord, these properties are mentioned in next page, page 32 and 33. I am not agreed on this. My innocuous prayer is all these are landed property and structure, building, everything. Immovable property. Para 2 and para 2 in page 33, my lord.
Para 2
of page 33. All these are immovable properties, my lord. Got the padlock or the padlock office unit question mentioned.
GL 50.
Yes. And they, my lord, put padlock of their own, my lord. I am unable to take out this my properties. Whatever is lying there, I would take out. This is my lord innocuous prayer. It has nothing to do with my lord SARFAESI action.
So you had been to them before the magistrate?
No. I was not there.
So kindly come to the 33. The head clerk CGM court order is directed to take possession of property, and after taking possession will be handed over to the authorized officer. It has been handed over. It has been, you have taken possession?
Yes, Lordship.
Yes.
If the settled property is under lock,
Now the possession is with them.
Under certain terms and conditions. The petition applicant remain present. Connected document, padlock fee of the flat unit.
In the main gate, my lord, they have, yes, sir.
In presence of the authorized officer, the person or locality may be present. So, at the inventory has been made.
Yes, Lordship. Inventory is there also, Lordship.
In respect of the property of the.
Just a minute.
Yes, my lord.
Where is the
Page 35, Lordship.
35 is the inventory of the, my lord, the other, my lord, the owners. Actually, it is the inventory of the owners. My inventory is not there because my property was in my under my lord the padlock.
Padlock
Lordship, the
But
inventory
in the
has been
in the main gate, in the main gate, the premises, in the main premises, padlock has been put by them. And my lord, in the ground floor, my lord, my factory was there. I specifically mentioned under my lord
No, kindly
para
see
6.
the order 33.
Yes,
The head clerk CGM order is directed to physical possession of the property
yes.
after taking.
I have not
place-
agreed on that.
Then
I want to, my lord, take out my immovable assets.
where is the proof?
Lord-
Already the court's order, it has been handed over. Where is the inventory of your property situated?
It was not done by
Lordship?
them. My lord, I
It
have
is
mentioned.
not the
My
case
lord,
of the bank that the other properties are
kindly
under lock and
appreciate.
key.
Kindly appreciate page 6 under my lord third paragraph. I have
You are
mentioned.
preparing for?
Well, let the padlock be opened if anything is
How
available.
it can be?
They
Under
can.
jurisdiction.
They can.
Yes.
My lord,
Lordship,
the
if I may
difficulty
kindly
is.
make my submission.
Yes.
Just one point, Lordship. They are aware that there is an essay that is pending before the learned DRT, Lordship.
Huh?
They are aware that there is an essay pending before the learned DRT. Now, Lordship, if kindly comes to section 17 of the SARFAESI Act, it clearly says any person aggrieved.
Correct.
I'm not
Any
agreed with the
person
my lord
being-
SARFAESI Act, sir.
Any action that I have taken, even if I put it under padlock after taking possession, that is also an action that has been taken by me under SARFAESI, Lordship. He can just make an application before the DRT and get any order that he
My lord,
wants.
may-
This order is not.
No,
this
no,
writ is not
after
mentioned
taking
itself, Lordship.
possession, whether the matter is pending before the DRT.
Yes, Lordship.
How?
I am there. I am also the advocate in record before the learned DRT,
What
Lordship.
is the stage of the DRT before the DRT? Once the possession has already been taken, what remains? Auction has been done of the
Auction has
property.
been done, Lordship, but learned DRT also has the power, Lordship, to return
No,
the
what is the
possession.
stage? Whether you have taken
It is,
possession. So whether you have published the auction notice.
yes, Lordship.
So what is the stage now?
Lordship, sale has been conducted, but I'm
Sale has been conducted.
yes, Lordship, but sale has failed with respect to this property as far as I am aware,
So
Lordship,
you do one
in
thing.
October.
You do one thing. You file a report. What he is claiming?
But Lordship, I have just one problem, Lordship. If Lordship goes through the writ petition itself, Lordship, the property which he is claiming to be his under tenancy, I am not made aware of this. I can bring up my mortgage documents and everything where I am told specifically that it is without encumbrance. So how can I hand over to a third party without any proof and without the borrower himself coming up and saying that yes?
Sir, I am
My lord,
dismissing.
my lord,
I
my
am
lord, my
disposing
lord.
of
Kind,
the-
yes, yes.
Please, I am disposing of this writ application, allowing you to approach before the DRT.
My lord, my lord, my
And
lord,
if you any claim before the DRT, DRT will
my lord,
consider.
kindly appreciate. Kindly appreciate.
Lord.
My lord, kindly
Please
let me, my lord, kindly allow me for a moment, my lord.
Yes.
My lord, it is from the documents, my lord, orders. It is specifically case of the my lord secured creditor that the immobile properties have been mortgaged.
Hmm.
Yes, let them whatever they want to do with the immobile property, they can do, my lord. I have no objection on that. My lord will find since my lord prior to granting
Sir,
the loan, my lord,
once the property has been handed over to a particular authority,
that is immobile property.
record and
My lord, kindly.
the petitioner has filed the present writ application praying for a direction upon the respondent number 1 and 2. 1 and 2
My lord, one thing, my lord,
to
may I indicate?
allow the petitioner or his men and agents to take out his belongings lying in Muaza Cantilia jail number 50, Khatian number 1384, 1378, 1151 and 660, Dag number 766 and 790 under police station Domjur, district Howrah. Police counsel for the petition submit that the petitioner is a tenant in respect of the property in question and he was running the business of.
My lord, kindly come to page 20. It is the MSME certificate.
What is the business? Business
My
of
lord, galvanizing and my lord, fabrication.
business of galvanizing and fabrication. He submit that the bank, the owner of the property had mortgaged the said property and not paid the amount. Accordingly, bank has initiated the proceeding under the SARFAESI Act. Subsequently, in terms of the order passed by the magistrate passed by the learned, which magistrate?
This is my lord,
Passed by the
CJ.
learned Chief Judicial Magistrate Howrah in Miss Case number 621 of 2022, comma, the head clerk, comma, CJM Court Howrah has taken possession of the whole immovable property of the owner and has handed over the same to the bank. But the tenanted portion where the petitioner was running his business is under lock and key, and all the belongings of the petitioner is lying in the said premises. And as such, he prayed for a direction upon the author or upon the bank for allow the petitioner to take back the belongings.
But as per Article 300A of the Constitution.
Full stop. Full stop. Learned counsel appearing for the bank submit that.
Lordship, it's an NBFC, Lordship. It's not a bank. So it's not. So respond numbers 1 and 2. It's an NBFC. It's not a bank, Lordship.
NBFC, that is a respond number 1 and 2.
Lordship, one more thing. I have not taken the point. I have taken the point of maintainability, but I also want to make that point that writ petition is not maintainable against NBFC.
Full stop. Full stop. The counsel for the respondent number 1 and 2 submit that the owner of the property, that is the respondent number 3, has obtained loan from the respondent number 1 and 2, but she failed to pay the said amount. Accordingly, the respondent number 1 and 2 has initiated the proceeding under the SARFAESI Act, and as per the order of the DRT and the order passed by the learned magistrate, comma, the property has been taken over by the respondent number 1 and 2. Full stop. See, further submit that there is no document brought on record before the SARFAESI proceedings that the owner has let out the said property to the petitioner, or petitioner is running the business. See, further submitted that the petitioner is having grievance with regard to his any properties lying in the property in question. Being a tenant, comma, he can very well approach before the DRT under section 17A of the SARFAESI Act. SARFAESI Act. Full stop. Full stop. Heard the learned counsel for the respective parties peruse the material on record. This court find that the petitioner is claiming that his belongings is lying in the property lying in the property in question under lock and key, but the respondent number 1 and 2 have taken the possession in terms of the order passed by the DRT and the order passed by the learned magistrate, and as such the petitioner is not in a position to take out his belongings from the premises in question. This court find that the respondent number 1 and 2 being the NBS, respondent number 2 have initiated the proceeding against the respondent number 3, who is the owner of the property. The owner of the property has not made any averment, has not intimated to the authority, to the respondent number 1 and 2 or before the SARFAESI that the petitioner is a tenant and belonging of the petitioner is lying in the premises in question. And as such, it is a full stop. The respondent number 2 are denying with regard to the property of the petitioner lying in the premises in question. This is a disputed question of fact whether the petitioner is a tenant of the respondent number 3 or whether any belongings of the petitioner is lying in the premises in question. That cannot be decided in the writ jurisdiction. It is further submit when learned counsel for the respondent number 1 and 2 further submit that after taking possession, comma, the bank has already initiated the proceeding for auction of the property in question. In view of the above, this court find that the writ petition is not maintainable. Accordingly, writ petition dismissed. However, the dismissal of the present writ application will not prevent the petitioner to approach before the DRT to make his claim before the DRT. And if any claim is made by the petitioner before the DRT will consider the same and pass appropriate order in accordance with law. इससे पहले ना CAN 1 का करो. The petitioner has filed an application being CAN 1 of 2025, praying for recalling of the order dated so and so, order dated 22nd September 2025, wherein the writ petition was dismissed for default for non-appearance of the petitioner. This court finds that the petitioner has shown sufficient cause for non-appearance of the petitioner before this court on 22nd September 2025. Accordingly, order dated 22nd September 2025 is recalled. WPA 15089 of 2025 is restored in its original file. Can 1 of 2025 is disposed of. With the consent of both the parties, the writ petition is taken off hearing. Then वो कर देना.
Obliged, Lordship.
Sorry.
My lord, I have annexed all the documents regarding my lord.
Oh, you go to the
But
appropriate
it was my
office.
innocuous
Yes,
fear,
next.
to put open the padlock so that I can take out.
Who will identify? Yes, call.
This is under my possession.
Lord, 9, I appear for the petitioner.
Yes.
My lord was hearing this writ petition, my lord. State was arguing, my lord. Issue was whether, my lord, deed of assignment of copyright would require, my lord,
Deed of?
registration. Deed of assignment of copyright, whether it would require registration, because my principal
Okay,
argument,
that one.
yes, my argument was that the assumption of jurisdiction by the authority to say that there has been an undervaluation was not correct, because the deeds set forth the value. They also in their order recorded that value itself.
Yes.
Now, last day, my lord had passed an order on, my lord, 22nd of January 2026, my lord, permitting my client to disclose, my lord, the certificates, my lord, copyright registration certificates. My lord, I have, my lord, served them. I was 3 days beyond time, my lord. I am filing the affidavit, my lord, in court today. To state?
No, I mean, respondent number 4.
Because their only contention is that you have not disclosed any certificate with regard to the copyright. Whether so you have
Although, my lord, the order on the challenge, the appellate authority's order does not really record that. I was, my lord, required to, my lord, disclose this, my lord, to satisfy lordship's conscience, because I have to, my lord, satisfy that it was registered. Now, my lord, the order of the appellate authority proceeded on a complete different premise, that because it was not done by entry in the copyright register, therefore I will not give you the
that's why that is
concession which I am otherwise allowed to.
that is continuation of this.
Yes, so now I have produced it. My lord,
Yes,
there
have
are
you
3
gone through?
certificates.
Lordship, I am appearing on behalf of respondent number 4.
Who is for the state? Mr. Sen.
Mr. Sen was, yes. I had served them.
Nobody is here. What can be done? Not today.
My lord can keep it some other day. I'll inform him once again that lordship may fix it any other day convenient.
The petition, the land counsel for the petition for the state are present. No, land counsel for the petition is present. None appears on behalf of the respondents. Petition has filed the supplementary affidavit in terms of the order dated 22nd January 2026, after serving the copy to the land counsel for the respondent. Let the same be kept with the record. As none appears on behalf of the respondents, for the ends of justice, the case is adjourned. Let the matter appear on 10th February under the same heading.
My lord, today is 10th.
Acha, today is 10th.
Today is 10th.
17th February.
My lord, may it appear at the top, because this can be
At
disposed.
the top. Correct.
Great.
Top আছে কি?
Yes, previous
17
order
top
also.
আছে কি? Okay, तो 2 number करी दें अगर top है तो.
Last order said top under the heading urgent motion. So we were very happy with it.
Motion at the top. Next.
Lordship, in this.
I appeal for the state respondent, Lordship.
ये तो हमारा अर्थ लिखा ना बेच दिसंबर में बेच. Yes.
Lordship, at the outset, I beg to draw the kind attention of this honorable court that I have already given the written notes
Yes.
in this matter, and I have highlighted the entire aspect. So, at first, I would like to draw the kind attention of this honorable court that the decision.
Premature release.
Yes,
Lordship.
Lordship. The decision taken by the SRB's sentence review board is arbitrary and not in accordance with the law. Lordship, in my written notes in para 4, I have already stated the annexure given by the state learned advocate, annexure A2, I have annexed at page number 12. In this annexure, he has already specifically held the superintendent of police shall not act mechanically and oppose the premature release of the prisoner on untenable and hypothetical grounds. And in the report, Lordship, jail superintendent having no objection, and he stated that his character and behavior is good during the entire incarceration of 26 years. Another point is, Lordship, the report given by the at page number 30, I have annexed in my written notes. That report has been given by the jail authorities, wherein at page number 31, in para 31, overall conduct during incarceration, overall development, a specific view of the superintendent. So, jail superintendent, jail authority
Lordship, I
categorically
think,
held that.
Lordship, first-
1 minute, 1 minute.
Your
sir.
Lordship first sees the
1 minute,
order of rejection by the review
I
board.
have already stated. Lordship, so entire tenure of 26 years, my character and behavior is good, and I have no any adverse reporting. And the PACO report dated 9/9/24 specifically held that now I am informed remit in the incarceration. And in this regard, I have given the list of authorities of the law passed by the Honorable Apex Court of India. And number one, authorities of law, police strategy for grant of bail, suo motu writ petition 2025, SCC online, SC 349, relevant para 8 and 11. In this landmark judgment, the Honorable Supreme Court categorically held in para 8, Lordship, in para 8 and 11. The Honorable Supreme Court at page number,
Whether this matter you have rejected, you have not, you have taken the decision, premature release cannot be granted. Whether this matter has been sent to the High Court Remission Committee before taking the decision.
Lordship,
You are appearing for the state.
state, perhaps not.
If anything, whatever, how many persons are in languishing in the custody and suffering the life imprisonment.
Lordship.
So you have to take a decision, has to send to the High Court Remission Committee for recommendation. If you are recommended release, that is how many cases, then it has to be sent to the High Court with all these things. Then the High Court Remission Committee, there is a committee, they will consider and they will refer to the administration for consideration whether this case you have rejected.
Rejected by the board, Your Lordship.
Rejected before rejecting the board, whether it has been sent to the High Court Committee.
Lordship, perhaps not.
So that's why last occasion I also
I have no
indicated the same
instruction,
thing.
but how far my information is, there is no such happens, Lordship. This.
That is the problem. You state advocates are not getting any information, taking the brief and coming to the court.
In terms of the last occasion, Lordship, my Lord Justice Ghosh directed the review board to consider the the application of the petitioner, and that was placed before the review board on 11th, on 28 August 2025, and on that date, the review board rejected the application of the petitioner, given several reasons, Your Lordship. Last occasion, I filed my report. Perhaps Your Lordship,
yes,
that is on in the report. Can Your Lordship consider that rejection order?
No, that is correct. But whether it was sent to the High Court Remission Committee?
Lordship, there is no such order
then
sent, but my Lord Justice Ghosh directed the review board to consider. And he considered and rejected the application. I'm not going to the...
Because you are rejected, when you are rejected?
On August 22nd August, Your Lordship.
22nd August?
2025.
Where is that?
That is, Lordship...
that is under challenge?
That is not under challenge, Lordship. That order is not under challenge.
Where is the rejection?
I have placed that report, my Lord. No, Konta.
rejection. That is your rejection. If you are not
You are disclosing your report?
Yes, I have submitted.
Which page?
That is report dated, Your Lordship, 19 November 2025. 19 November 2025. That is separate report, Your Lordship. Not in the Your Lordship will find in
I have
the
given, Lordship.
petition, Your Lordship.
I have given.
Report dated 19/11 and review board considered on 22nd.
Which serial number?
Which serial number is Your Lordship? Kind Lordship comes at page 2, paragraph 3, serial number 1, Uttam Das. Inquisitive report under section suspension for committing heinous murder of a private tutor in September 2020 along within his associate extraordinary Uttam Das and his associate slashed the victim's throat, hacked the body into 7 pieces on Kalyani Express. Thereafter, though the superintendent of correctional home recommended his premature release, considering his conduct during incarceration, and the convicting landlord could also appoint favorably, premature release of Uttam Das has been vehemently opposed by the police authorities. The victim of the case refused to pay their demand. The life convict Uttam Das has a bad repute in the locality. The local people try to refrain
So
from
you
their
got this report.
Yes, Lordship.
You challenge this report.
Yes.
No, he has not challenged.
Lordship, 1 minute, 1 minute. The earlier honorable bench of this honorable High Court directed the SRB to reconsider the matter.
Correct.
And he's mechanically reject.
Correct.
In para 5 of my written notes, I have given the reply.
In the writ petition, you challenge this report.
That writ petition is pending.
So now it has come. It has been rejected.
That writ petition is pending, Lordship.
Which writ petition is pending?
The 24209 since 2024.
24209 is this writ petition.
Yes, yes.
Present writ petition.
Since 2024.
Correct.
So many direction has been given.
Correct.
And now this matter has.
Where is the order? In this writ petition, the direction was given.
Yes, Lordship.
Where is the which order?
Order is here. Order is here, Lordship.
Which order?
I am showing, Lordship.
That order was passed perhaps in the month of July.
Yes, dated 12th August 2025.
Yes, Lordship.
So have you got this report?
Yes, Lordship.
So you have to challenge this.
Lordship.
You have to challenge this.
Lordship, Lordship.
He has not taken exception of this report also.
Please.
I beg to draw the kind attention of this honorable court.
Sir, I am only asking one question to you.
Yes, Lordship.
During the pendency of the court has directed to consider.
Yes.
Considered. Rejected. So this is a new cause of action. Have you incorporated challenging this?
Not yet.
Then why you're not understanding the simple thing?
Lordship,
Tomorrow can I bring you the pleadings to you?
Lordship, we have already understood, but each and every time he's
That is
rejecting.
correct. That is correct. But you have, there is one cause of action arose. So either you have to come to either to take exception to this or have to challenge this, whatever it may be, as per your advice. If you will not challenge this, remain on the dock, remain in the file. How the court will go about this?
So, Lordship, give me the liberty to challenge this.
In terms of the order passed by this court dated 12th of August 2025, the review board, the state sentence review board has considered the case of the petitioner for premature release and rejected the same by a meeting dated 22nd of August 2025. Full stop. The proceedings of the special meeting dated 22nd August 2025 were served to the learned counsel for the petitioner. Counsel for the petitioner prays for time to take exception to the said report. Let the exception be filed by?
By Lordship?
He is wanting only to file a fresh.
By exception, how much time you want?
2 weeks.
By 2 weeks, reply if any there to be filed within a week thereafter. List the matter on 9th March 2020.
Lordship deeply appreciate.
Next.
11 আমাদের না?
Yes.
And although the matter is appearing under the heading urgent motions, but there is a final disposal, your lordships. I met the submission, your lordships pleasure was let it appear under heading motion so that it can be disposed of. Matter is whether the already been decided by the apex courts.
What is the prayer?
Yes, my lord, I am coming.
20 decide and
My
withdraw
lord,
the consideration annexed
Page
direct response.
25 is the challenge.
Page 25.
Page 25 is the challenge. It is recovery after retirement. To show when I retired, my lord, on 30th September 2023.
30th September 23.
30th September 2023.
Yes.
Objection raised on 31st October 2023. After 1 month after retirement.
Okay.
Now, my lord, the objection, page 25.
Page
25.
Yes.
Now, my lord, the observation portions and bottom portions. Fixation of the pay on 1/8/2003 appears to be incorrect and not in tune with the order 185 SCB, such and such. It may be please be clarified.
Yes.
And the pay and first objection top, the pay should have been rupees 8,275 in lieu of 8,550. The concerned authorities are requested to review and clarify the present pay statement. Overdrawal of pay may be calculated to take a further necessary action. All other relevant part may be corrected accordingly. Question is, my lord, whether this overdrawal at all permissible after retirement, whether my entitlement was there at the point of time. My lord, twofold submission I am making. I was entitled and my lord, accordingly, page
23.
No,
Order of the DI.
the page 23, your lordships kindly have a look.
Yes.
Page 23. This is the order of the district inspector schools. On 23rd May 2027, it was passed. With reference to the above, undersigned has to inform that the Simanto Karari MBA drawing pay as assistant teacher such and such, the scale of pay such and such. His last date of working assistant teacher, his pay fixed headmistress 8,550 with effect from 1/8/2003 in the scale of pay 13,500 is now allowed to enjoy 2 additional increment in the same scale of pay as per GO number 185 dated 8/4/2000 with effect from 25/7/2006 due to upgradation of the higher secondary schools, and his pay has been fixed 9,650 from the date. His next increment will fall due on 1/8/2004. So, my lord, if the school is upgraded in the higher secondary schools, then, my lord, I am entitled to have that 2 additional increment. That was given, and district inspector schools allowed this when it was allowed in 2007. Now, my lord, I have received this amount till date of my superannuations and the last date of my working day.
What
And
was
I
the last
got
date? 30th September 23. You
30th
are retired.
September 2023.
You retired.
Yes. And
After the retirement, when they have started.
And objection was read on 31st October 2023.
Where is that objection?
This is a page 25.
Yeah, that is with regard to the fixation.
Yes, fixation and recovery. Yes, fixation and recovery.
Okay.
As this is pending, nothing has been paid, not a single funding has been released on account of my retired dues. Unless I pay, that will not be given. Now, my lord, the question is, this aspect of the matter was considered. I had the occasion to argue before the Honorable Division Bench. It is also good. Page 5 onwards, if your lordships kindly, that is my submissions and
Site codes need to go.
लिखा ना
Yes.
FMA 777 of 2023. Mr. Bali, the learned advocate appearing for the appellant submits that the issue concerning the recovery of the overdone amount from the retirement benefit is recurring features prevailing in the country and the apex court in certain of the decisions have rejected the contention of the respondent authority that it is within their competence to recover as and when the mistakes and discrepancy is detected. In support of the aforesaid submission, Mr. Bari relies upon the state of Punjab versus Roving Masi, when the apex court has illustrated a few eventualities which retired such recovery impossible. According to Mr. Bari, the instant case comes within the ambit of the one of such eventualities. Thereafter, these authorities cannot take a contrary stand to the decision of the Supreme Court, which is law declared by its exercise power under Article 141 of the Constitution of India. Mr. Bari further submits that the ratio laid down of the rupees must is further reiterate in subsequent decision in the Supreme Court rendered in Thomas Daniel versus State of Kerala, reported 2022 SEC online. Mr. Bari vociferously submits that the aforesaid judgment in the apex court was considered by the division bench comprising one of us, for respondent J. The in Union of India versus Somar Kumar Bandyopadhyay, WPCT reported 2023 SEC online, wherein an argument was advanced that the situation computed under.
Who is for the authority? And you are appearing?
Yes.
My lord, in one matter, my lord, I am appearing, that is Mihir Kumar Acharya. In this matter, my lord, I am not appearing.
What is your instruction?
My lord, in Mihir Kumar, my lord, next matter, my lord, I am appearing, my lord.
What is your instruction?
My lord, my lord, there was a direction to file affidavit, my lord. I am ready, I am opposing this.
So for 11 is concerns that in spite of service of the notice, earlier notice wise service, thereafter your lordship fix of the date, notice wise service, twice or thrice notice wise service. So my lord, the last portion, concluding portion, if your lordship kindly text page 12. In view of the law enunciated in the above reports, we are unable to concur with the judgment of the single bench. The order impugned in the instant appeal is hereby set aside. As a consequence whereof the writ petition is allowed, the responding authorities are directed to issue a pensionary payment order on the basis of the scale of the pay lastly drawn without deducting any amount therefrom on account of the alleged excess payment due to wrongful and mistaken fixation of the pay. The entire exercise shall be completed within a period of 4 weeks from the date of computation of this order.
Yes.
Now, my lord, the point was taken and a single judge was of the view the roping mercy was passed under 142. And that's why, my lord, the prayer or writ petition was dismissed. I had a occasion to, my lord, argue before the division bench. Division bench say no, roping mercy was declared under 141. So, my lord, this now this law is settled. After retirement, you cannot recover or cannot
Yes, that's all.
the pay. Yes.
So he was working as headmaster.
Yes.
And 2007 the pay was fixed.
Yeah, right.
And he retired on 23. Now they wanted to
the objection was raised on 23 October.
Okay.
Which is not permissible in the IOM. And in this matter, as the matter is pending, I have been deprived from getting my pension benefit. Nothing has been paid on account by taxes.
All are the same?
No, see, these are the different. I shall make.
So this is a different.
Little bit. When I recovery after that is same, but the factual aspect I will 1-2 lines that will be.
Nobody. Mr. Sen, you are appearing?
No,
The petitioner has filed the present writ application. Praying for. Recalling and withdrawing the impugned observation made in Annexure P2 and a direction upon the respondents to disburse the due pensionary benefit of the petitioner, including arrear, pension, gratuity in terms of the last pay actually drawn by the petitioner. Concept of the petitioner submitted. The petitioner was working as headmaster. Working as headmaster.
তাহলে আপনারটা আপনি দিয়েছেন থাকলো
না না আমাকে না একদম দিয়ে তো কারেকশন করেছি
Which school he was working?
no my lord the
Your Gauri?
I retired from the in Joduberia Vidyapit Joduberia Vidyapit
Your Gauri Vidyapit. Okay.
oh Joduberia
Vidyapit. Full stop. In the year 2000.
respond number 8
Added for the
added respondent 8
In the year 2007, the additional district inspector of a school within bracket SE, Skuluberia subdivision Hora, has fixed the pay of the petitioner at rupees 9,650. 9,050.
For the next page, same was corrected by the
Subsequently, by an order dated 20th August 2007, the order dated 31st of 23rd of May 2007 was corrected by holding that the petitioner shall draw the pay at rupees 8050 till 31st of July 2003 in the scale of pay of 6,000-12,000. That is the last day of working at as assistant teacher. In the approval of refixation of pay dated 23rd of May, by way of an order dated 20th August 2007, the order dated 23rd of May 2007 was corrected by holding that the petitioner drawing the pay as headmaster of junior high school at rupees 8050 till 31st of July 2003 in the scale of pay of rupees 6,000-12,000. That is the last date of working as headmaster of junior high school. Instead of drawing the pay as assistant teacher as rupees 8050 till 31st of July 2003. ठीक है? Full stop. Concept: the petitioner retired on 30th September 2023. After the retirement of the petitioner, the authorities have started proceeding for a release of the pension, and on 31st of October 2023, it was observed that the pay of the petitioner should have been rupees 8275 in lieu of rupees 8550. It was further observed the concerned authorities are requested to review and clarify the present pay statement. Overdraw of pay may be calculated to take further necessary action. All other relevant parts may be corrected accordingly. The petitioner agreed with the said observation on the ground that the petitioner have been granted the scale of pay in the year 2007, and till the date of retirement the petitioner was getting the said scale. After the retirement of the petitioner, now the respondent authorities are intending to have observed that the pay of the petitioner should be rupees 8275 in lieu of rupees 8550, and overall pay may be calculated for taking further necessary action. Mr. Ari, an advocate appearing for the petitioner, submit that the petitioner has retired on 30th September 2023. After the retirement, the respondents cannot recover any excess payment made by the authorities to the petitioner. Mr. Bari submit that it is not the case of the authority that the petitioner has drawn the higher pay by misrepresenting the respondent authorities. He further submitted the petitioner have been paid the pay scale as per the order passed by the competent authority. Full stop. He has relied upon, he further submitted that the similar question was arose before this court in the case of before the Honorable Division Bench in the case of Srimati Kalpita Moitra within bracket Chakaldar versus State of West Bengal and others, passed in FMA 777 of 2023 within bracket dated 14th of November 2024, wherein the Honorable Division Bench of this court, relying upon the case of State of Punjab and others versus Rafi Mashi within bracket Whitewasher and others, reported in 2015 volume 4 SCC 334, the Honorable Division Bench has directed the respondent authorities to issue the pension order on the basis of the scale of pay lastly drawn without deducting any amount therefrom on account of the alleged excess payment due to wrongful and or mistaken fixation of pay. Police Learned Counsel for Mr. Bari submitted the case of the petitioner is also covered with the judgment passed by the Honorable Division Bench of this court and the case referred by the Honorable Division Bench in the case of Rafi Marsi. Heard the learned full stop. In spite of service of notice, none appears on behalf of the respondent authorities. Lastly, also the petitioner has served a notice to the respondent authorities on 9/2/2026, but none appears on behalf of the respondent authorities. This could find that by an order dated 23rd of May 2007, the authorities have passed the following order. This order, page 23, set out. Subsequently, by an order dated 20th August 2007, the authorities have corrected the said order, which reads as follows. Page 24. The pay scale has been, the respondent authorities have fixed the pay scale of the petitioner in 2007. And subsequently, the petitioner was drawing a particular pay scale. There was no objection from any authority for drawing the salary by the petitioner in a particular pay scale. The petitioner retired from the service on 30th September 2023. Till the retirement, there was no allegation that the petitioner has misrepresented represent the authority and draw the excess payment. Full stop. From the impugned letter dated 30th October 2023, it is found that at the time of calculation of the pension after the retirement of the petitioner, it was found that the pay scale of the petitioner has been wrongly fixed as 8,550 instead of 8,002. Pay has been fixed to be 8,550 instead of 8,275. Accordingly, it was observed that the overdrawal of pay may be calculated to take further necessary action. Full stop. In the case of Rafi Marsi Supra, the Honorable Supreme Court held as follows. Okay. In the present case, the petitioner was the headmaster of the school. And the authorities have fixed the scale of the pay in the year 2007. The petitioner has retired on 30th September 2023. After the retirement, when the respondent authorities when at the time of calculating the pensionary benefit have observed that the pay scale of the petitioner has been wrongly fixed as rupees pay of the petitioner has been wrongly fixed as rupees 8550 instead of 82750. Considering the above, this court find that there is no fault on the part of the petitioner for fixing of the pay scale. Fixing of the pay scale. There is no misrepresentation by the petitioner for drawing the higher pay scale. Now the petitioner has been retired and he as headmaster of the school. Thus, the judgment passed by the Honorable Division Bench of this court in the case of Kalpita Mohitra Supra and the Rafi Masi passed by the Honorable Supreme Court Supra is squarely applicable in the present case. It is settled law that after the retirement of the government servant, if the government servant has drawn the high salary without any misrepresentation of fraud committed upon the authority, the authorities have fixed the pay scale inadvertently, no amount can be recovered from the retired person. Considering the above, this court find that the observation in the impugn order dated 30th October 2023, wherein there is an observation for overall of pay may be calculated to take further necessary action, and all other relevant parts action is against the settled position of law. Accordingly, the said observation is set aside and quashed. Full stop. The respondent or full stop. The petitioner is submitted and they are not withdrawn the have not been given
nothing.
counsel for the petitioner submit that though in the month of September on 30th September 2023 the petitioner has
No, my lord, I'm sorry. At the time of admission of the writ petition, the court directed admissible retirement benefit should be given. Accordingly, he is receiving. So not entire, but there.
30th, but only after filing of the writ petition and as per
It
the
is
order,
required to be refixation of
as
pay.
per the order passed by the
Revised
court,
pension
the
payment order.
authorities have issued the provisional pension to you. Provisional.
No, admissible
Admissible
retirement
pension.
dues it was given. Now,
Admis-
madam, the refixation is
Admissible
required to.
pension has been given to the petitioner. In view of the above, the respondent authority is directed to issue the pension paper order on revised pension paper order on the basis of the scale of pay lastly drawn without deducting any amount therefrom on the account of on account of alleged excess payment due to wrong and mistaken fixation of pay by the authority. The respondent authority is directed to complete this exercise within a period of 6 weeks from the date of communication of the writ petition is disposed of. Next.
The three matters a little bit different. What has happened? Less than 1 year on the threat of the district inspector schools that you make payment of the withdrawn amount. Thereafter, the pension payment order will be given. I paid the same, but less than 1 year. That is the only difference. After retirement, it was not. Before less than 1 year, I was asked to refund the entire amount which has been overdrawn. It is done. So, this aspect of the matter is also considered by the another learned single judge. They say the issue has already been decided by the division bench. Whatever amount you have extracted from the petitioner, you should refund the same, and refund is required to be made.
When you retired?
My lord, I retired from the service.
What was the post?
Headmaster, same post.
My lord, in one matter, my lord, last matter, my lord, I appear, my lord, in 14, and I want to oppose, my lord, that by filing, my lord, my affidavit in opposition. My lord, I have served.
Not you are not appearing in the other matters.
My lord,
All are same.
I am appearing, my lord, only 14. But my lord, what the allegations are putting, my lord, I am opposing.
What is the opposing? You're opposing, it's okay. It's good for opposing. What is the ground of opposing?
He is saying, my lord, under threat, my lord, can he show any letter, my lord, that DI has given him threat? Any letter from the petition?
That is correct. Okay, that.
My lord, nothing has been stated.
But how?
The order, my lord, kindly see my my opposition.
Leave aside that they are not given any letter. Whether you can detect the
my lord, kindly see my opposition, my lord.
Yes.
And thereafter, my lord,
দাঁড়াও না,
And my lord, what happened, what will happen, my lord? Your lordship will pass the order in other matters, my lord. In this matter, my lord, he will say similar matter.
Yes.
I will not
All are
get,
similar.
I will not get chance to oppose, my lord.
That's why I am hearing you.
Yes, my lord, that's why.
That's why I am hearing you because the
My
other
lord,
party is
kindly-
not here.
My lord, kindly see,
Show
my
me,
lord,
show me why. What is
my
the
lord,
objection?
paragraph 4A, my lord. Kindly
Yes.
allow me to read.
Yes.
My lord, the said writ petition was filed on 8 September 2025.
Paragraph?
My lord, page 3, my lord, paragraph 4B.
Yes.
My lord, the said writ petition was filed on 8 September 2025. The writ petition is frivolous, malicious, and vexatious. He
Correct.
retired from his service, my lord, on 31st August 2024.
Correct.
As a headmaster, my lord, his last pay was 90,000, my lord. He made his first representation on 10th July 2025, my lord, after 1 year, which is an afterthought, my lord. That is my point, my lord. He made his representation, my lord, after 1 year, and it is an afterthought. And thereafter, my lord, kindly see, my lord, there is next, my lord, C. There is no violation of any statutory provision or due to any malafide reason, the petitioner has not suffered any wrong, my lord.
Correct.
Thereafter, my lord, kindly see, my lord, paragraph B. With effect from, he was appointed, my lord, as headmaster of Maheshpur Jashoda Vidyapith with effect from 8th July 2011, and his appointment was duly approved by the DI. Thereafter, my lord, kindly see, my lord, the West Bengal Council of Higher Secondary renewed the recognition of this school and introduced higher secondary unit from academic session 2013 to 2014, my lord. Write me such memo, my lord. Then, my lord, it is very important, my lord. The petitioner allowed one additional 3% increment with effect from
Where from you are reading?
my lord, paragraph F, page 4. After upgradation of the
Yes, the petition was allowed 3% increment with effect from
increment with effect
fixation,
from
it's
July 2011,
correct.
and fixation was made.
Yes.
Thereafter, my lord, paragraph G, my lord, in terms of government order such and such, my lord, it has been inter alia mentioned. It is, my lord, I want to read it full, my lord. In connection with memo number such and such, this is to clarify that ROPA 2009 and other related orders issued by this department with the concurrence of other departments have not proposed any additional increment in favor of the headmaster of higher secondary school upgraded after 27th February 2009. Only additional grade pay of rupees 200 has been allowed to the headmaster of higher secondary school upgraded after 27th February 2009. Hence, I am directed to inform that no additional increment can be allowed as per ROPA 2009 and according to Memo 1003, my lord, stands withdrawn. So the petitioner was not entitled to get 3% additional increment. My lord, that is the case, my lord. He is not, my case is, my lord, he is not entitled. And
When you have issued the notice for recovery,
my lord, kindly see, my lord, he returned. I have placed.
I am asking one question, sir. When you have issued the notice for recovery of the excess payment, which he is not entitled,
He himself returned. There is
I am
no
asking
threat, nothing.
I am asking you when you have issued the notice for recovery.
My lord, kindly see, I have just now placed. He, my lord, he returned, my lord. My lord, he returned. It will be found, my lord, from his writ petition, my lord. He retired on 31st August 2024, and he returned on his own. কোথায় গেল রিটার্নটা? My lord, return, my lord, page 28.
28 of?
My lord, P6, writ petition P6, page 28, 11th October 2023.
11th October
2023.
Page 28.
Yes, my lord. P6.
Item number.
P6, my lord.
The writ petition is
11th October 2023. He returned. And thereafter, my lord, he retired from his service, my lord, 31st August 2024.
Page 28.
Yes, my lord, he
Ah.
returned on his own.
Hmm.
Is there anything, my lord, written that I have been?
What is the amount he had returned?
1,26,090.
What is the date of the return?
My lord, 11th October
11th October
2023. At the bottom, your lordship will find, my
2023.
lord, right side. There is a seal.
11th October 2023 returned.
Returned.
Then when he retired?
He retired, my lord, from his service, my lord, on 31st August 2024.
31st August 24.
There was nothing at that moment, my lord. There was nothing. No allegation was there. And afterthought, it's an afterthought allegation making in the writ petition.
Yes. So this is only your their objection.
Objection, my lord. Not only that, I have not finished, my lord. This paragraph G, I have told, I have placed, my lord. Thereafter, my lord, kindly see. Paragraph 8, my lord, kindly see, in terms of order number such and such, it has been inter alia mentioned. Then on appointment to the post of headmaster, no additional increment for fixation.
That's correct. That is your case. So this is your case. Yes, sir, Mr. Bari.
Yes.
And my lord, another thing, my lord, with regard to judgment, my lord, with regard to judgment, kindly allow.
Yes, he has not placed the judgment. You are having the judgment.
No, he
He has not placed the judgment. Let me hear.
pleaded in this and other matter, my lord, he was cited.
Let me hear what is the judgment.
I'm
Yes.
grateful, my lord.
Now, well, the question is, one thing it is clear that less than 1 year after retirement, there is no persons in the world who will voluntarily give their money. And I retired and I categorically made a statement in paragraph 8 that I have been asked to refund that, whatever it may be. Now, well, after retirement, admittedly, I retired, and after retirement, the money was accepted, I have given. Now, my lord, what is the issue? Issue was, if the school is upgraded from secondary to higher secondary, then headmaster is entitled to have additional incremental benefit 3%. Now, this aspect of the matter was, initially it was given, later on it was withdrawn. Now, it was tested before the coordinator bench. Coordinator bench says, no, you cannot that. The decision of the government, which my learned friend was relying, was set aside. This was tested before the appeal court. Appeal court confirmed the judgment of the single bench. So division minister দিয়ে দাও
এটা কোনটা বলছেন একটু বলুন
এটা ডিভিশন বেঞ্চ কেন আচ্ছা তুমি ডিভিশন বেঞ্চটা দিয়েছো and relying the division bench, single bench passed an order that after depositing the refunded amount, I am entitled to have that.
এটা কোনটা পড়ছেন একটু নাম্বারটা আমাকে একটা কপি দিন
দিচ্ছি তুমি নাম্বারটা লিখে নাও
আমাকে কপি দিন একটা অন্তত কপি তো দিন আনরিপোর্টেড তারপরে একটা কপি তো দিতে হবে তাহলে আমাকে I may come back, my lord, after getting the copy, my lord.
You are appearing for the authority. The just a minute. 2017 ROPA and the order has been caused by this court by an order, and you are relying on file an affidavit. Who is the authority? File the affidavit. Let he come here.
My lord,
Sir, you are the court officer. You are the court officer, and you are relying upon a particular notification, a particular order, which has already been January 2025. It has been set aside. And you are relying upon and filing an affidavit before this court.
This affidavit, my lord, already affirmed before that.
When?
28 November 2025.
Then January 25 is after. November come first and January come later.
Sorry, 1st December 2025.
Then this is January 2025.
I have to take instruction with regard
No,
to
I will call your person who has affirmed this affidavit. What is this position?
My lord, what he is
what is the position? Who has affirmed this affidavit? Assistant Inspector of School, and he has not having the knowledge that the notification has been cancelled by the court, and you are relying upon filing an affidavit before the High Court. Very good.
কোনটা কোয়াস করেছে
এই নোটিফিকেশন যেটা তুমি দেখালে সেটা কোয়াস হয়ে গেছে অলরেডি যে সাবমিশনটা তুমি করছো
My lord, what notification? কোন নোটিফিকেশনটা বলছেন আপনি?
What notification you are relying upon?
22 মার্চ।
যেটা জিতে বলেছো জি অ্যানেক্সার করেছো R3
Yes, additional increment withdrawn, that I have stated. What he is saying?
So what he
My lord, let me go through this and come back with instruction, my lord. Right now he is handing over. Let me go through this and come back with instruction,
Go through.
my lord.
The 14. Learned counsel for the respondent. The petitioner has relied upon the unreported judgment in the case of Samindranath Adak versus the state of West Bengal and others. Passed in FMA number 981 of 2022 dated 7 January 2025 and WPA number 22230 of 2025. Pankaj Kumar Biswas versus State of West Bengal dated 4th November 2025. Wherein the Honorable Division Bench of this court had set aside the notification, set aside the memo number 292-SL-5S-294-12 dated 22nd of March 2017 issued by the School Education Department withdrawing the additional increment of 3%. Full stop. As grade pay of the headmaster of the higher secondary school. Full stop. Learned counsel for the respondents pressed for time to take instruction. According case adjourned, let the matter appear. How?
My lord, 1 week after, my lord, in that
Let the
event,
matter
my lord, I
appear.
am not filing the affidavit today, my
Let the
lord.
matter appear on 18th February 2026 on
My
the
lord,
same heading.
My lord, may I take back the affidavit?
Let the affidavit continue here. Let it be remain here. You file and submit.
On the next day.
No. Once you file, court has gone through, it can't be. Sorry. Next.
March.
12, 13, 14, same.
all matters are
Taken to
let them come
because other not appearing is appearing. Let's decide all these things.
My lord, I am appearing for the item number 13 for the state.
Oh, you are appearing. So what is your submission?
My lord, yet we have not received any instructions regarding this.
Okay, come
due to
on
fire in the
18. Come
office.
on 18 with proper instruction. Come on 18.
My lord, kindly record my appearance, my lord.
Give your name in the chat box.
My lord,
Yes,
my lord,
copy,
grateful,
copy.
my lord.
18th or same position
सेम तो रहने दे, हाँ? वही श्लोक है, वही सेम पोजीशन में रहने दे. Yes, so you are the petitioner.
Yes.
Yes.
I beg to appear on behalf of the Union of India.
Yes. What do you
Lordship,
have
this is that matter.
Mr. Sabyasachi Chaudhary had mentioned it, and your lordship was
LOC.
pleased to LOC.
LOC. Lordship,
Yes.
in terms of your lordship's previous order direction, may I hand over the copy of the report, lordship?
Colin. It's a good exercise. That's a morning hour. Give.
হ্যাঁ 12 ছিল বলে এই ওখানে আছে কপি পাবো কপি ইউজ করো That means 20 seconds and এই affidavit দিয়ে দিন এখান থেকে পড়ুন ওই রিপোর্ট
Before they can submit it to SIM card.
এইটা করতে রে হ্যাঁ 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 জিজ্ঞেস করবো
He himself bought those step down subsidiaries.
Yes.
But you have seen that, man. The three
assuming, my lord, what they are saying is correct, three reasons have been given. One is lordship will find, my lord, economic interest of. Lordship will kindly come to para 5, because, my lord, other than up to para 4, there is no allegation so far as my client is concerned. Para 5, it's economic interest.
Paragraph 11 and 13.
Yes. Because para 4 elder group is of 2006-7. Post 2009, he has no connection with that. So
He has.
economic interest, my lord, law is well settled. It can't be on the quantum and that. Now, kindly see, investigation report has been submitted in 212 and in terms thereof 212-14 is awaited. So, my lord, central government may decide or may not decide. Lordship already knows, my lord, the statute, my lord, 212. Investigation, if submitted, central government, if it decides, it will ask them that you initiate prosecution. So on the basis of the report, no prosecution as of now has been initiated. It was incorrect, my lord. Incorrect impression was given to your lordship that prosecution has been initiated. 6 is clear in terms of 212-14 of the Companies Act are awaited as on date. Lord, we'll have a look at 212-14 once. Lord, 212, Lordship recalls, my lord, 2 stages are there. Well, this is of the 13 Act.
Yes.
On receipt of investigation report, the central government may, after examination of the report and after taking such legal advice, direct the serious fraud to initiate prosecution against the company and its officers or employees. So first, my lord, initiation against the company, then employee, then ex-employee who had left in 2009. As of now, no direction. So it doesn't fall at all within the meaning of assuming everything is correct.
Yes.
Now, my lord, this is what, my lord, para 7 is what they are saying the result of their investigation.
Yes.
Lordship will not find my name other than, my lord, at page 6, where they say that the step-down subsidiaries were sold to Devanjan and ex of the promoter for negligible value. This is not correct.
Yes.
We will file our affidavit to this. And in any event, my lord, I am not shying away. I am undertaking. I will come whenever it is. It is not correct. And it's a vague allegation. Elder International has written off loans and investment based on step-down subsidiaries so-and-so, revealed that subsidiaries were sold to Deva. He doesn't own, he is here. And I'll show the circular, my lord. And then, kindly see para 8. Petitioner claimed he was not employed in CUI after 2009. However, email has found petitioner continue advising, communicating. But I have myself admitted in the writ petition, I am an expert in cancer and drugs.
Yes.
Investigation revealed petitioner held no official position. However, his active connivance led to wrongful loss in EPL.
Yes.
An oncology expert, he is being consulted all over the world. And on he is admitting he is consulted all over the world. And then, my lord, kindly see several charges against several individuals. My lord, nothing is specified, all vague. 447 has been recommended against petitioner. So no charge sheet as of yet. Incorrect submission was made on the last occasion. The charge sheet has been filed. And then, my lord, conduct of the petitioner.
Yes.
Only thing, summons has been served in the registered email, my lord. We have indicated in China, my lord, and that, my lord, they can also verify.
No, that person is over because he has already investigation.
Correct. Investigation, my lord, now investigation is over. I am willing to give my undertaking 15 days notice. We will give our advocates mail whenever they want. We will come back. And then, my lord, this is grossly incorrect.
Only the problem is that he is going with the family settled in China.
Yes.
How you can justify to that?
My lord, his parents are here, his sister. He comes, my lord, we have given the passport. My lord, from 2009 till 2024, he is coming 4 to 5 times every year.
No, that's correct. But once the person came to know something
No,
is hanging on his head.
Lordship will see, we are giving the undertaking, his parents are here, my lord. Otherwise, my lord, it has to, my lord, let us, mere apprehension will not do. My lord, Lordship visualizes the situation. The mere fact from 2009, only because you find reference in email, you will issue an LOC. Which of the criteria of the circular does it? Lord, kindly take the office memorandum once.
Page 27.
Have been enclosed here?
Yes, page, my lord, page 27, it starts. Kindly come to page 32.
Yes.
Kindly see G first. The legal liability of action taken by the immigration authorities in pursuance of the LOC rests with the originating agency. Then, my lord, H. Recourse to LOC is to be taken in cognizable offence under IPC or other penal laws. The details in column 4 in the enclosed proforma reason for opening LOC must invariably be provided, without which the subject of an LOC will not be arrested or detained. Well, today also, what is the cognizable offence? And the test is when they had given the requisition. Well, this is what repeatedly we are setting, my lord, we are coming and getting this set aside, my lord. They are taking it as a tool to terrorize at the time of investigation. Nowhere in the circular, my lord, permit, kindly see I. In cases where there is no cognizable offence under IPC or other penal law, the LOC cannot be detained or arrested or prevented from leaving the country. The originating agency can only request that they be informed about their arrival, departure of the subject in such cases. I am willing to comply with that.
Yes.
And Lordship sees, well, this clause also Lordship has considered time and again, clause L at page 33. In exceptional cases, LOCs can be issued even in such cases as may not be covered under the guideline, where departure of a person from India may be declined at the request of any authorities mentioned in clause B above. If it appears to such authority, based on inputs received, that the departure of such person is detrimental to the sovereignty or security or integrity of India, or that the same is detrimental to the bilateral relation with any country or strategic and economic interest, so and so. My lord, economic interest of India, my lord, only on this, in a private company.
Yes.
And my lord, this also has been, when Lordship had the occasion to consider 2021 SCC online, my lord, the Vishamba Saran case. Kindly see, my lord, para 51 onwards, 50 onwards.
Which, nothing. 2021 SCC.
না না ধনী লাগালে বলে রেফার করা। At para 50, the limited ground as it stands amended as mentioned in the relevant office memorandum are as follows, and then clause L has been quoted. None of the above criteria are satisfied in the present case. The mere quantum of default cannot be a basis for extreme measure of restricting the personal liberty of the petitioner to travel inside or outside India. Absence of such ground, the LOC was ex facie vitiated. In the event authorities seek to resort to the quantum of alleged default for restricting citizens' departure outside the country, it is obvious that the quantum is relative and amount of 350 crores can be exorbitant or meager, depending merely on the whims of the authorities or perspective of the judge. As such, in the absence of any stipulation in that regard in the relevant office memorandum, no cut-off line can be drawn between an amount which is detrimental to the sovereignty or security or integrity of India or to the economic interest and which one is not. in the pursuance. This squarely applies. And Millard, I had placed that, Millard, kindly take that judgment of Millard, Justice Narula of the Delhi High Court for the interim stage. If Lordship wants, Millard, the matter to go into, because Millard, now that the report is here, I am saying even if Lordship takes the entire content to be correct, Millard, it does not satisfy any of the grounds.
Okay. Yes.
Millard, just a minute, Millard. In terms of Justice Narula's judgment, Millard, Lordship will find, Millard, the undertakings requirement is there. One more judgment, Millard, it's covered by my Lord's judgment in Sunil Agarwal, which Lordship had the occasion to deliver a month back. Let kindly see para 33. Because Lordship had the occasion to analyze, my Lord, it will be the similar. I don't know whether the reported judgment, and I am looking at the, is it starting with lookout circular issued in? Yes. Lookout circular issued in terms of order of Ministry of Corporate Affairs dated 19 July 2022. Admittedly, investigation is still going on. My Lord, here let us say investigation is complete, but my Lord, no
cognizance taken.
Yes. No report from the central government. Respondents are not sure whether offence alleged is fraud under 447 as per 212(11). SFIO must submit an interim report to central government. Its SFIO is directed to do so by the central government. Well, here I don't think that question arose because nothing is there in that. 212(12) requires SFIO to submit an investigation report to central government only upon completion of investigation. Therefore, an investigation report cannot be submitted at any time prior to, whereas an interim report can be submitted at any stage. Neither interim investigation nor investigation report is submitted to the government under 12(12)(14). Central government has been empowered to direct SFIO to initiate prosecution against the company or its officers if the central government considers it necessary after examination of only investigation report. Well, that stage has not yet arisen. And Millard, the test is when you are issuing the lookout circular. That is why the pro forma is saying what is the cognizable offence. And all these are happening as if it's a tool for that. And para 36, Millard, Lordship has considered Vishamba Saran. Contention of the respondent that the present case involves the interest of public at large and involves huge outstanding. Millard, Vishamba Saran has been quoted by your Lordship.
Yes.
And Millard, only one, kindly go back to that, Millard, the report which they have given. They say, I am trying to leave India through Bangladesh via road. Millard, this already covered in the petition. I said, Millard, flight tickets are expensive. I had a client to attend in the Bangladesh. I've given the hospital name also. Bangladesh Cancer Hospital, I had given the two names I had there. So, Millard, I had bought it. In case I am stuck, Millard, the bus tickets are, Millard, less costly. Millard, para 27. I am just reading out. Inasmuch as there was no response from the respondent number 1, petitioner was carrying an impression that there was no further embargo for petitioner to travel to Bangladesh. Petitioner was required to meet a customer at Bangladesh on 23rd January. For such purpose, the petitioner visited Gojadanga land port on 22nd and tried to reason with the officer, only to be informed lookout circular at the instance of SFIO has not been revoked or recalled. I had gone there after meeting the SFIOs and saying whatever I had to. And only document is that one email which they sent that there is a summon. Other than that, there is nothing against me.
Yes. That's all?
That's all.
Yes.
The affidavit of service.
Your Lordship will not kindly consider two things. Someone issued under section 217 to the petitioner on 14th of January 2025. The LOC was issued. Subsequently, it is petitioner's case that he came to know about the summon on 22nd of January 2025. The 2 days are very important. First of all, summon issued under section 217 on 14th of January 2025.
Summons issued on
14th of January 2025.
14 January 25.
Yes.
Yes.
Now, my lord, it is petitioner's case, my lord, the Yahoo was not, the server was not operating in China, my lord. That's why he was not aware of this.
But the
No, my lord, just two.
no,
Yes.
only with regard to this notice, someone now it is your specific case investigation is completed.
Yes.
Once investigation, this question with regard to someone or not, because it is not the allegation in your report due to he is not cooperating with the investigating agency, so that's why you could not complete the investigation. That is the not the report you have submitted.
No, my lord, two things, my lord. My lord, why I am pointing out this, my lord, on 14 January, someone was issued.
Correct.
22nd January, my lord, he came to know about this summon.
22nd January.
22nd January.
Yes.
Now, my lord, he came to India on 15th of December 2025. My lord, 15th of December, paragraph 11, his admission, 15th of December 2025. Now, my lord, from 15th of December 2025 to till, my lord, he is trying to, but he did not meet the concerned SOIO, concerned officer. He had the knowledge that someone was issued and all these things. He may not have the knowledge, my lord, regarding the LOC. LOC was issued, my lord, in the month of February, my lord, 2025. But he had the knowledge. After receiving the knowledge, he had the knowledge. Well, he avoided the SFIO, my lord, till, my lord, date of departure. That is of 22nd of 23rd of 21st of December 2025. Now, my lord, subsequently, my lord, after that, my lord, he wrote a letter that is at page 56. Can you turn, my lord, page 56 once?
Yes.
Well, this is the letter, my lord, written to the inspector, my lord, investigating officer, my lord, by the petitioner in respect of, my lord, someone notice such and such and such. Where he is submitting, my lord, I am a permanent resident and all these things. Ultimately, my lord, he has stated that he made a detailed representation and subsequently he stated that I am going to leave on 28th of December 2025. So kindly do all the needful. Now, in response to that, my lord, subsequently, your lordship, my lord, straightway comes, my lord, another representation made by him, that is at page 61.
Yes.
Now, page 61, my lord, his prayer to the, my lord, inspector or investigating officer, the prayer to revoke, remove lookout circular issued in the name of such and such.
Correct.
Now, my lord, in response to that, this, my lord, investigating officer, my lord, wrote a letter to him, page 76.
Page 76.
Page 76.
Yes.
Page 76, my lord, it is said, my lord, I just place it. This is with reference to your letter dated 30th of December 2025, wherein you have sought revocation or removal of the LOC issued against you in connection with the investigation into the affairs of Elder Pharmaceutical Limited. In this regard, it is pertinent to note that your statement dated 22nd of December 2025, recorded on oath, you had undertaken to submit all relevant supporting documents substantiating your replies and submissions made during the course of settlement within a reasonable time, and to extend all full cooperation to the investigation process. The further, by your email dated 23rd of December 2025, addressed to SFIO, you had specifically assured that you would collect all requisite documents as referred in your statement dated such and such and such. However, till date, no such document have been received from your end to substantiate the replies furnished by you during the statement. In view of the, you are once again requested to submit all requisite documents at the earliest so as to duly validate and support the submissions made by you during the statement to enable further progress in the investigation. But he has not replied to this till date.
Sir, one thing you tell me, you are telling that he has not submitted the document.
Yes.
Correct. Now come to your report. Come to your report. As per your report, kindly come to the paragraph 6. The investigation into the affairs stands completed.
Yes.
On 6th May.
6th
If you
May.
are completed the 6th May, what is the requirement of the further document?
Requirement of further document is this, my lord. It is his case, my lord. He tendered resignation in the year 2009. Now, my lord, investigation shows that there was a complete connection. There was an email, thousands of email and all this.
That I am not on.
Till
I am
2016. Till
I am
2016.
what you have collected. Because at this stage I cannot go But you are relying upon this, he is stating that he has given an undertaking that he will submit all the documents.
Yes.
Once you have in the May 2025 already stated that the investigation is completed and it is pending.
But so far as his part is concerned, my lord, so far as that
there
part
is
is
a report. Can you
report that was submitted, investigation report
in
submitted.
the report you
Yes, yes, and
that he has not come to the office,
No,
not
no, no, my lord.
submitted the investigation
Kindly,
is pending due to his
kindly come to paragraph 11.
paragraph 11. Yes.
Conduct of the petitioner.
Yes. Conduct. Yes.
Well, kindly see paragraph 11, last 4 lines.
The petitioner sought to justify
The
non-compliance.
petitioner neither contacted the inspector nor appeared before the office of SFIO. His conduct therefore demonstrated the deliberate disregard to the of the summons and the investigation progress. Now, my lord, he was, this page 76, my lord, there is no reply to page 76. And my lord, this has been stated, my lord, in the report also. In paragraph 11, I have said that kindly see. May I just place it? However, summons remain undelivered as the petitioners was not found at the last known address available in such record. In addition, summons was also served though the
Paragraph where from you reading?
paragraph 11 of the report.
Yes.
Paragraph 11 of the report. May I just place it, my lord? The summons were duly issued by the inspector for recording the statement of the petitioner during the course of investigation. The said summons were dispatched to the petitioner's Indian address as reflected in the statutory records. However, the summons remained undelivered as the petitioners was not found at the last known address available in such record. In addition, the summons were also observed upon the petitioner through his registered email address on 14/1/2025 as per the statutory records. The petitioners failed to respond thereto as well. The petitioner has sought to justify his non-compliance by contending that he was unable to access the said email account owing to the restriction in China on Yahoo server. The explanation is untenable in view of the petitioner's own admission that he traveled to India on multiple occasions on such and such to such and such. Moreover, the petitioner has himself acknowledged that he became aware of the issuance of the summons when he accessed his Yahoo Mail account while in Bangkok in February 2025. Despite such knowledge and notwithstanding the fact that he had been duly summoned by the inspector, the petitioner neither contacted the inspector nor appeared before the office of the SFIO. His conduct therefore demonstrated the deliberate disregard to the summon and the investigation process. Now, next, the petitioner would also be mentioned that the petitioner's detention in Calcutta airport pursuant to the LOC in force. His statement on oath was recorded on 23rd of December 2025. And during this process, the petitioners agreed to submit certain documents as required by the inspector, but the same documents have not been furnished till date. And lastly, the petitioner, it is pertinent to mention that the intimation was received from the Immigration Department Calcutta informing that the petitioners attempted to leave India through Bangladesh border via road. But these are my, so far as the investigation is concerned, my lord, your lordship was absolutely correct. The investigation was completed, my lord, on 6/5/2025. Now it is waiting for the central government, not in view of 212/14, subsection 14. Now, my lord, your lordship, my lord, kindly consider two things. Today, my lord, if this person is absolutely settled in China, now there is an absolute flight risk. Now, my lord, despite having knowledge, my lord, about the summons, despite coming to India, he did not voluntarily meet the SFIO. No, he did not meet the SFIO voluntarily. Once he was intercepted, then my lord, statement was recorded. Thereafter, he tried to flee through border by road. So, my lord, as on considering the conduct, my lord, today, my lord, kindly consider another aspect. Today, my lord, if the central government report is an investigation report is accepted, then my lord, it will be coming, my lord, it will be an cognizable offense.
Special court.
Special court. Now, my lord, in that case,
it will take the cognizance and the summons will be issued.
It will go to the special court and it becomes a cognizable offense.
Correct.
It becomes a cognizable in view of 212/6.
Correct.
Now, my lord, how could I catch this person?
So that's why.
How would I catch this person?
In that case, if you say I am fixing after 2 months.
No, my lord, your lordship cannot kindly consider one thing. My lord, kindly allow me to place the investigation report before your lordships. My lord, keep the matter, my lord. After some time, my lord, I will put the investigation report before your lordships.
What I
propose, you just go through it.
Propose subject
in seal cover, my lord. Your lordship go through it, my lord. Thereafter, take the decision. In the meantime, my lord, let me also clarify the situation, my lord. Whether, my lord, the investigation, what is the actual stand as of date?
If suppose I will keep, and your government has taken the accent has been given, sanction has been permanent, it will go to this special court. So what further remains?
Like if it go to the special court, then the special court will be in session of the matter. Then in that case, special court will grant necessary permissions if
That is
required.
the problem here, because you till that your authority have not sanctioned the, have not taken the decision.
So far as till date,
May, now we are
May.
One
Your
year is
lordship
going
knows how government functions. I don't want
No,
to.
no, that cannot you say the government function. Government will function with 1 hour also.
Specifically says that he was the one who.
And so far as report is concerned, his involvement, he is not so innocent. His involvement is very much there. Kindly have a look, paragraph 7 once.
Yeah, I gone through.
Yeah, paragraph 7, it says, investigation revealed that subsidiaries of the step-down subsidiaries were sold to petitioner on ex-employee and close associate of the promoter of company under investigation for negligible value. Let me place investigation report in seal cover. Kindly go through it, and thereafter, your lordship,
215 crores has been.
and 215 crores involvement is there as far as this case is concerned.
Yes.
Well, 3 paragraphs, Lordship will make a note. 17 and 18, my learned friend repeated the mail. I have said that. I have myself said that. What is the situation? And whether it is accessible in China or not, that is there. And I have
What is the undertaking given by him in the before the authority?
Yes, I am coming to that. And para 25, para 21, I'm sorry, para 21, Lordship will see. I'll read that out. I come to India on 15. They had a lookout circular, my lord. They knew I have come to India. I am such a fugitive, my lord. They would have sent the police to get me arrested. My lord, they do nothing. When I am going back again, and my lord, kindly note in para 2 of the report, investigation started in 2019. In between 2019 to 2026, I have come to India, my lord, 6 to 7 times every year. Kindly see page 77 once. I have given a schedule of entry and exit. And my lord, the first summon is, my lord, in January 2025. And I am, my lord, I have left this elder in 2009. How will there has to be a logical or even a semblance of, my lord, sense in what they are saying. And let us assume everything is correct. My lord, kindly see para 25. Para 21. I'm sorry, my lord, para 21. My lord, the first 2 times I met them, I volunteered, I gave my father's number over there. You require any further thing. My learned friend is not saying what documents they require from me. But they, when I go there, usually in SFIO, you have to deposit your mobile in the locker room and then you can enter. I have mentioned the officer's name. This is what he said. Para 21, 4th line. Petitioner received a call on 23rd December at around 11:55. Sri Gautam Kumar informed the petitioner there were some formalities left and therefore the presence of the petitioner was necessary. Petitioner complied with the request, visited the office of respondent number 1 when the petitioner was requested by SFIO's officer to send a communication to the officer superior in rank to the investigation officer. IO is trying to protect his shield. Investigator with the assurance, petitioner shall provide all required documents to the respondent number 1. I asked the question, what is the document required by them? I gave them the assurance that whatever documents you require, I will provide. You let me know. Even in this, there is nothing. And in May, if the investigation has been complete, what more document? That means either this is a sham.
Yes.
And you are getting an omnibus declaration. Anybody who is in such a situation is going to write whatever documents you want. But what even my learned friend is not saying, I wanted these documents and he is not produced. So this is a general, and this undertaking I'm giving to court also. If it is in my custody, they say, all right, this is the document you produce. I can produce. Not a single letter that you produce this document. And an undertaking, I have explained the circumstances in which, they made me write this mail. I had to write it in front of the officer after my mobile was called, from the email. This was my plight.
Okay. Hearing concluded, the record and order. And the CIFO has submitted the report after serving the counsel for the petitioner. Hearing concluded.
Deeply obliged.
Deeply obliged.
Next matter, my lord, it will not take 1 minute, 10 minutes.
But item 16, I want to withdraw the application.
Item number
16, the next one.
Hmm.
I want to withdraw the application. So if
criminal
you're
case, criminal matter, criminal CRR.
criminal.
Give.
My lord, what happened? This is a criminal revision against an order of acquittal. My lord, the petitioner has died. So therefore, my lord, we have filed a substitution application being CRAN 1 of 2024. My lord, kindly allows the CRAN and the person who is being substituted has filed a, given an instruction to me not to proceed. So kindly allows, substitutes the
When he
person.
died, when the complainant died, is the complainant.
Is the complaint.
Complainant has filed the revisional application.
She is a file. I have annexed the death certificate.
He died on 11 September.
Yes, 11 September 2024.
You kitchen report ache LOC 9.
11 September 2024.
11 September 2024.
I have annexed the
When he
death
filed
certificate.
an application. December.
Yes. Because unless she is substituted, she cannot withdraw the.
Who has filed
The daughter.
Revision application?
A revision application was filed by the widow of the deceased.
Mother.
Oh, the mother. Mother, no? Mother of the deceased.
Sumitra Panja. No.
No.
Mother of the person.
Mother of the
Person
mother of the person will be substituted. No.
Who filed the revisional application?
The revisional application was filed by the
Sumitra Panja.
Sumitra Panja is the widow of the deceased.
Widow of the deceased.
Yes.
No, she is the complainant.
She is the complainant.
She is the complainant in the FIR.
In the criminal
She is
case.
the defective. The complaint case.
Complaint case. Against, because it was against police officers.
Where is the complaint?
Complaint doesn't be part of the revisional application.
You are having the copy.
The lordship will be able to, from the first page of the judgment, the lordship sees her. The main revisional application.
She is the complainant. Yes, record and note.
May I hand over the instruction?
Initially, one Srimati Sumitra Panja, wife of late Kamal Panja, has filed the present revisional application against the judgment and order dated 20. The petitioner has, the applicant has filed the present application, being CRAN 1 of 2024, praying for substitution of the petitioner of the original petitioner. We submit that the petitioner Srimati Sumitra Panja died on 11th of September 2024. And who is the petitioner here? Who is the applicant herein?
The daughter.
The applicant is the daughter of the de facto the complainant, and as such, she intend to substitute it in place of her mother. The petitioner has disclosed the death certificate of the petitioner complainant who died on Itna. At the land counsel for the petitioner peruse the materials on record. The recording and the death of the petitioner Srimati Panja is recorded. Department is directed to correct the cause status, and the petitioner, the applicant. What is her name?
Her name is Rima Panja.
Rima Panja,
Daughter
of late Kamal Panja, is substituted in place of the petitioner. Accordingly, the department is directed to correct the cause title, CRAN number so and so disposed of. Full stop. The petitioner has handed over a communication dated 15th of January, Learned Counsel appearing for the substituted petitioner, Rima Panja, has handed over a communication dated 5th of January 2026, wherein The substituted petition has informed the learned advocate on record of the petitioner that the substituted defendant is not intending to proceed with the present case. Accordingly, present case. In view of full stop. On the basis of the communication dated 5th January 2026, learned counsel for the petitioner prayed for withdrawal of the present revisional application. At the learned counsel for the petitioner and the state, as the petitioner is not intending to proceed with the present revisional application, accordingly, CRR number 1045/2022 is dismissed as withdrawn. Communication be kept with the record.
Grateful, my lord.
আমাদের নামগুলো তো দিয়ে দাও।
Next.
I beg to appear on behalf of the petitioner. My lord, relating to appointment by the Public Service Commission, my lord, this is a, my lord, keeper post in Archaeological Museum maintained by the state authority. My lord, the advertisement published, and my lord, they have invited 39%. My lord, 1:39, one post only, keeper.
What is the post?
My lord,
what is the post?
Post keeper, Archaeological Museum,
Archaeological,
keeper.
okay.
Lordship, kindly come to page 24, the advertisement published by the Public Service Commission.
Yes.
Kindly see, my lord, name of the post, keeper,
Keeper, State
Archaeological Museum, West Bengal General Service. Then, my lord, kindly come to pay, and thereafter vacancy, one post unreserved. Then, my lord, qualification which is essential.
Now, what is the total post? How many posts?
One post, my lord.
Only one post.
Yes, my lord. Kindly see vacancies, one unreserved.
Where is that?
My lord, in that, that name of the post, service, department, directorate, pay scale.
Vacancy, one post unreserved.
One.
Yani general.
Yes, my lord, general, unreserved.
Yes.
Then, my lord, the qualification is essential, a postgraduate degree and recognized university in museology or archaeology or ancient Indian history and culture, or Islamic history and culture, or any classical language with specialization in any branch of archaeology.
Correct.
At least 3 years experience in a reputed museum or a comparable institution. Then, my lord, what is desirable? Training in museology, a recognized museum, training in the conservation and preservation. Then, my lord, the age and all these criteria. Then kindly come to page 25, middle portion, information. My lord, I am reading, my lord, 4. The prescribed qualification at the bare minimum and mere possession of the same does not entitle the applicant to be called for interview. Then, my lord, the commission may restrict the number of candidates to be called for the interview, reasonable limit, so and so, my lord. Then, my lord, what happened? My lord, lordship, kindly come to, my lord, page.
So what is the method of selection?
Method of collection, my lord, they have initially screening taken place and they have invited, my lord. Kindly come to, my lord, page 166. Second volume, my lord. Second volume.
166.
166.
Then,
lord, you got it. Kindly see, my lord, 39 persons are being invited.
Yes.
For the interview. Then, my lord, our humble
have been shortlisted.
Shortlisted.
Yes.
My lord, not only shortlisted, my lord, important announcement scheduled for the interview of the recruit.
All have been called for.
Yes, my lord.
39 persons have been called for the interview. Yes.
My lord, 1:39, our humble submission before this honorable court. This is to some extent, my lord, excess, my lord, to the expected norms. In case of, my lord, inviting person in the interview, normally 1:3, 1:5, 1:10, my lord, number of candidates are there. He has 39.
So what can be done if the 39% of one post is there?
No, true, my lord. They have screening. Screening has taken place, and thereafter, lordship, kindly see, 36 name of Sayantan Mukherjee is appearing.
36, you are there.
Yes.
Name is item number
Sayantan Mukherjee.
You are the Asayanto.
No, I am not the Sayantan. Sayantan is a selected candidate.
Okay.
We are raising objection against his qualification. We are raising objection against his, my lord.
What is your name?
My name is, my lord, Bonani. And, my lord, we have 5%, my lord, all together.
Your name is not appearing in the list.
Yes, my lord. My name is
the serial number.
I'm showing. My name is that is 8. Serial number 8, lordship will find. And, my lord, some other person also all together filed this writ application. All are invited. My lord, number of petitioner over here, my lord, after paying, my lord, the court fees and all this. My lord, 5 persons are before this honorable court. The cause title, lordship will find, my lord.
5%.
5%. Dr. Bonani Bandobad Bhattacharjee, Dr. Aurobindo Sinarai, Dr. Sajol Dolui, Dr. Shilpi Maulik, Dr.
Where is-
Shubhasri Bonik.
Where is the Arvindo Sinaroy?
My lord,
Arvindo Sinaroy, which serial number?
serial number 2 in the
Serial
cost
number-
title.
Serial number 2?
In the cost title, lordship.
No, here.
Here, my lord, I'm
Page-
sure.
page
I'm sure. I'm sure. Aurobind Sinarai, my lord, is there. My lord, lordship will find 21. 21.
Then Sajal Doli?
Sajol Dholi, I am showing, my lord. Then, my lord, 20.
20.
20.
Yes, P3. Then
My lord, all are, my lord, they have completed their PhD degree from the, my lord, the appropriate, my lord, the system, maintaining the system, and my lord, all these things, my lord, they have completed their PhD degree. Whereas, lordship kindly see page 167, the person who was selected, my lord, it's a lack of qualification. This is our first bold argument before this honorable court. My lord, now,
7.
yes, my lord, 167.
Yes.
31st July
Periodic
2025.
nominate for one.
Shayantan Mukherjee.
Shayantan Mukherjee.
His name is appearing in the 36, serial number 36 of the list,
Yes.
page 166.
Yes.
So, my lord,
So he has
my
been
lord,
made a party in the
yes,
deputation.
yes, my lord, yes.
Private
He
respondent.
appeared at the outset, my lord, he appeared when the matter was taken up for hearing.
Appeared for the respondent number 7.
7. My lord, no affidavit from their end, my lord. But the affidavit of the PSC, my lord, is there.
My lord, I am filing the affidavit.
And this is our reply, my lord.
Hmm.
Now, lordship, kindly see.
Reply copy. Reply will copy to
Reply আপনাকে কি করে দেবো আপনি আপনাকে
Yes, then.
দিয়েছে তো আপনাকে copy.
So how you are telling that he is not qualified?
Yes, madam, coming to receive Urmila ke etake. But they have received. Now, my lord,
Okay,
why?
whatever it is.
Lordship,
How you
kindly
are
come.
telling? How you are telling? What is the ground?
My lord, wrong is there, my lord. Kindly see, my lord, my educational qualification. Now I am discharging a duty, my lord, in the Haryana government. My lord, I am the deputy director of their museum. Though, my lord, that post is, my lord, against substantive post, confirmation and other details are there. My lord, I am doing work for a considerable period of time. I am a PhD degree holder. I have been invited by the different university on different occasions to deliver lecture. Lordship, kindly come to page 28. My qualifications from 28 to, my lord, from 28 to, my lord, lordship will find up to, my lord, page 70.
70.
My lord, kindly see at the very outset, my lord, I have been awarded, my lord, Professor Sudhir Ranjan Das Memorial Prize on different occasions. Vishwabharati University appointed me for some work, my lord. And work experience, my lord, kindly come to, my lord, page 29. First column is award, number of award I have received, fellowship grants and achievement. Then, my lord, work experience. Then, lordship will find, my lord, my publication, excavation and exploration. My lord, I had the experience, my lord, to be in the Ajodhya also. So far, my lord, this particular spot was excavated.
Okay, then what has happened?
Then, my lord, kindly see. Lordship will find, my lord, kindly come to, my lord, page 51. Page 51, my lord. This is the government of Haryana, Department of Archaeology and Museum. Page 51.
Yes.
Lord, here lordship will find, my lord, Monani Bhattacharjee. Designation, lordship will find deputy director. And, my lord, I am discharging that particular duty, though, my lord, it is in my own state, home state. My lord, I intend to come here. Apart from myself, my lord, other 4 candidates are equally qualified. They are also PhD degree holder. Whereas, my lord, this gentleman is yet to, my lord, get that particular, my lord, the PhD degree. My lord, the qualification, my lord, whatever information we have received, my lord, he was, my lord, under the Indian Museum for 11 months. My lord, what happened, my lord, the essential qualification, which is 3 months in a reputed museum. So, my lord, that being the situation. Now, my lord, what happened? They have filed their affidavit, my lord, affidavit without enclosing any document. My lord, is the Public Service Commission. They should come forward with, my lord, in all transparency to show and substantiate that this selection process was, my lord, is a clear, is a transparent method was adopted. And I'm reading, my lord, what they have raised, only raising the question of maintainability, since it is relating to, my lord, state administrative tribunal matter. My lord, the tribunal is not functioning. Lordship knows. At that point of time, it was taken up for hearing. And, my lord, Honorable Reed Court was kind enough to, my lord, the first order, Madam, may I be permitted to read? Madam, so far their maintainability question is concerned. It is made clear that in the event at the time of final hearing of the writ petition, if the jurisdictional state tribunal resume its functioning and it is operative.
Order dated?
Order dated, my lord, 26/9/2025. This was, my lord, ventilated by them, my lord. Once again, they have repeated the same stand in their affidavit. 26/9/2025. Internal page number 3 at the bottom, my lord.
Yes.
What is more, my lord, very recently, Honorable Justice Shogato Bhattacharya Judge passed one order whether this type of application shall lie in the division bench or single bench. My lord referred several division bench judgment and come to a conclusion. I will rely upon that judgment. Yes, since the tribunal is not functioning, it is the writ court jurisdiction to entertain such type of application. That being the situation. Now, my lord, kindly see their affidavit. Here, my lord, they have raised this question, page 4E, before the Honorable Court, 4th line, having jurisdiction to hear the matter relating to tribunal under sections under Article 323A and 323B. Then, my lord, at the bottom, as such, the instant writ petition is not at all maintainable in the present fact and circumstances. Now, my lord, kindly come to page 5. They have considered him as a suitable candidate. Actually, why he is suitable compared to other candidate whose details we have enclosed with the writ application? They are not coming forward. The document which lying with them, they are the custodian of all document to, my lord, refute our, my lord, the allegation. This was not a fair and transparent mode of, my lord, selection was not there.
Yes.
Then, my lord, kindly come to, my lord, said, only said, repeated and reiterated, my lord, the suitable candidate. My lord, without enclosing any scrap of paper from their, my lord, custody. My lord, that being the situation, my lord, since they are the custodian of all record, my lord, the record should be produced before this honorable court. And respondent number 7, for the reason based on to them, my lord, did not file any affidavit. My lord, if this honorable court kindly direct me, I can, my lord, kindly allow me, my lord, then I can rely upon certain judgment and, my lord, conclude my argument. My humble submission, the mode is not transparent. My lord, this is, my lord, AIR 1980, 3 Supreme Court cases, 418.
AIR 1980.
My lord, I'm sorry, 1983 SCC, my lord, 418. Here, my lord, I am drawing lordship attention, paragraph 10. This is volume 3, Supreme Court cases, 418.
Volume 3 na 4?
3. Yeah, no. 1983 SCC 418.
Yes.
But I'm reading, my lord, kindly see paragraph 10. My lord, last 3-4 line, my lord, to cut short time. If the court is skeptical, the record of selection proceeding, including the notes regarding the interview, may have to be made available. Interviews as such are not bad, but polluting it to attain illegitimate ends is bad. Then, my lord, quoted from Dr. Martin Luther King, and, my lord, I am relying upon, my lord, para 17 of the same judgment. Ruling of this court are cited before us to hammer home the point that the court should not substitute its judgment for the academicians when the dispute relate to educational affairs. While there is no absolute ban, it is a rule of prudence that court should hesitate to dislodge decision of the academic body. Certainly, my lord, expert, they have taken decision, but university organ, for that matters, any authority in our system is bound by the rule of law and cannot be law unto itself. Then, my lord, if the chancellor or any other authority lesser in level decides an academic matter and educational question, my lord, so, my lord, our humble submission, my lord, definitely the expert decision are required to be taken. Public Service Commission, my lord, under Article 320 is operating. We have no doubt, but at the same time, when the question is being, my lord, ventilated by us, transparency question is required to be, my lord, meted by them, my lord, in an appropriate manner, which, my lord, the here Public Service Commission is not doing. Then, my lord, next judgment is Justice Shogato Bhattacharya's judgment, my lord, paragraph 20. Here the question which my learned friend was intended to raise, that is WPA number 27327 of 2025.
Paragraph?
Paragraph, my lord, 20, my lord. The discussions are there, only I'm referring 20, internal page 15, my lord. In view of the aforesaid discussion, as tribunal is not functioning, writ petition is found to be maintainable before this court. So, my lord, there was a dispute whether in the division bench or single bench. Lordship was of the opinion it should be before the single bench, which we are pursuing, my lord. Then, my lord, we have enclosed here with West Bengal Public Service Commission rules and procedures. Here, my lord, Lordship will find, my lord, page 2, by examination, recruitment examination. Rule 3, my lord. Rule 3, Roman 7. That is also appearing from the page 3, internal page 3. Arrange the candidate in the order of merit on the result of the examination. So, my lord, this is their duty in terms.
Where from you are reading?
My lord, I'm reading, my lord.
An examination is for the purpose of recruitment.
Yes, my lord.
Yes.
West Bengal Public Service Commission, page 1, 2, 3. Lordship, kindly come to 3. At the top, Roman 7. This is a duty, my lord. Recruitment examination. Arrange the candidate in the order of merit on the result of the examination. We are not aware, my lord, how the examination was taken place, what was the basis, how many marks was awarded to the different candidate, what is the exact marks, and all these things, my lord. Then, lordship, kindly see, my lord.
That's why I put a specific question to you. What is the method of selection?
My lord,
by interview, by written examination, what
It
is
was
the
specified, my lord, subject to your lordship's query. I am appearing on behalf of the Public Service Commission.
My lord,
it was already depicted in our advertisement, my lord.
Okay.
Once again, my lord, my learned friend will show, my lord, it was twofold, my lord. One is eligibility criteria. The other is, my lord, the additional qualification someone possessed. Now, my lord, as far as eligibility qualification is concerned, myself, my lord,
that is with regard to the qualification.
Yes,
I
my
am not on the qualification.
So, my lord,
I am with,
how much marks and all this?
I am with regard to the
method, my lord, they have adopted.
Method of recruitment.
So, my lord, that to be disclosed by them, my lord, in the affidavit, 4 corners, they have taken this plea, it is not maintainable. Other is, my lord, the appropriate, and my lord, the candidates who is selected, he is suitable. How he is suitable compared to other candidate, he was not even a doctorate.
Okay.
Then, my lord, then, my lord, I am referring one judgment, lordship will find, my lord, 2010, 10 SCC 707. My lord, this is paragraph 24. Paragraph 26, my lord.
Yes.
From this fact, it can be concluded that the alleged participation of the near relative in the selection process was not such a factor as to vitiate the entire selection process. Even if there are some illegal beneficiaries from the selection process, they should be weeded out instead of dragging down the entire selection process. Our humble submission, we are qualified, my lord. Lordship will consider. And, my lord, they have taken one another plea. My lord, I am the unsuccessful candidate. I am turning around. My lord, next judgment, lordship will find, my lord. 2007 SCC online, Calcutta 651.
Yes.
This is the reported judgment that is in the 2008 1 CHN Calcutta 140. I am referring, my lord, paragraph 13. Para 13 and 14. Although the writ petitioner himself had no requisite qualification. Supposing I have no qualification. Here the case is different. I have superior qualification. For the post concerned, he is, however, entitled to maintain a writ application on the ground that the person selected is also not entitled to be selected to such a post, as his position is no better than that of the writ petitioner, and if he knew that the qualification mentioned in the advertisement would not be strictly followed, he could apply for the job. Then, my lord, that being the situation, these are the judgment. Only one thing I intend to show, my lord, before concluding my argument. That is, my lord, but I have got, my lord, one document from which I come to know, that is page 169. My lord, the volume 2.
169.
169.
Yes.
The middle portion, Department of History. My lord, his name is appearing 6. Name of the faculty, published by one Prabhu Jagobandhu College. Here his name is there. 6. Professor Sayantan Mukherjee, visiting faculty. But nowadays in visiting.
169.
169. Middle portion, lots of Department of History, and then, my lord, at the bottom, kindly see. 6. Professor Sayantan Mukherjee.
Okay.
Yes, you got it?
Hmm.
So he is a visiting faculty. Nowadays, who are the visiting faculty? Who are not in permanent service? Who are, my lord, imparting education in different college and different occasion, possibly in lieu of a, my lord, fees or honorarium and all these things, my lord. That to be clarified by my learned friend who was selected. But since there is no such affidavit on behalf of them, it is rather difficult for us, and we are making a submission which is to some extent as per our best realization and all these things.
Okay.
So, my lord, that being the situation, considering that aspect, my lord,
Thank you.
deeply.
Yes.
My lord, I have twofold submission, my lord, with regard to the maintainability and with regard to the merit of the case. With regard to the maintainability point, lordship, whatever I raise in
You are
my
appearing for respondent number
respondent number 345.
345. Yes.
5 and 6. I am appearing on behalf of Public Service Commission.
Yes.
My lord, with regard to the maintainability, my lord, the order which my learned friend placed, that was passed in 13th January 2026, where the learned single bench of the coordinate bench said that writ petition is maintainable. But my lord, kindly see my opposition. It was affirmed on first day of December 2025. That time that order was not there. That is why we have raised the maintainability point, lordship. That is the point, and I seek leave to file further opposition with regard to the maintainability point. And
Why maintainability? For the what maintainability?
To substantiate the case that writ petition is maintainable after that judgment. And my lord,
Not
kindly
proceed. If you are satisfied with the judgment, not proceed. Not required to file further. You're conceiving that yes, the judgment is available and then there's nothing on.
Yes, lordship.
Yes, next
Next, my lord, with regard to the with regard to the merit of the case, my lord, kindly come to page 25, my lord. The internal page 2 of the advertisement.
25.
25, lordship.
Yes.
My lord, subparagraph information, lordship.
Yes.
My
You
lord,
tell
kindly-
me one thing before going. You are having the recruitment rules for this
My lord,
post.
yes, recruitment rules was framed by the state government. We have recruitment rules, but that
Recruitment rule for the
rules-
post of keeper in the State Archaeology Museum. There is a
Yes,
recruitment
that
rule.
we have recruitment rules, but that recruitment rules was not framed by the Public Service Commission. That recruitment rules was framed by the state government. After framing that recruitment rules and after the state government informed us the vacancy position, then we are the recommending body only. We after getting all the requirement from the state government, thereafter we start the process of recruiting the best suitable candidate for the subject post. That is by this process we are working. We are only the recommending body.
Correct. You are the recommending body.
Yes.
So some institution intends that they require so and so post. Correct.
Yes.
So they will, and this is the Public Service Commission post.
Yes.
So you are the recruitment body.
Yes.
So they will give the requisition to you
Yes.
for the
Subject post.
for the subject post
With
for
the rules.
recruitment.
With
But
the rules and syllabus, everything.
But with regard to the recruitment will govern by the state government, the department who wanted to recruit the person for the said post.
Yes.
Correct. So this advertisement might have been issued by the Public Service Commission.
Yes. Based on the recruitment rules by the state
That's why
government.
where is the recruitment rule?
My lord, just now it is not
Okay,
available with
which
me.
information it's okay because in the recruitment rule all the things are there with
Yes.
regard and the method of recruitment.
Yes.
Either written or interview
Yes.
and the consisting of the committee members that would be there. So
Yes.
where is that?
My lord, just now it is not available with me. If your lordship so desire, I will produce on the next date of hearing, lordship.
Yes. Yes. What is the contention? Further contention?
Further contention, my lord, kindly come.
How this petition the private respondent is selected?
My lord, through interview. The post.
Where is the interview? Where you mentioned that here the private respondent has obtained the much more mark in the interview. Where is that? Where
My
is
lord,
that?
kindly come to page 25, lordship.
25
Page
of?
25 of writ petition.
I am there only.
My lord, kindly come to paragraph 4, information.
Correct.
My lord, the prescribed qualification, the
Mhm.
prescribed qualification are the bare minimum and mere possession of the same
Correct.
does not entitle applicants
admitted.
to be
There
called
is
for the interview. Where
admitted.
the
No
number
problem.
of applicants received the response to the advertisement is large and it is conveniently possible for the commission to interview all the applicants. The
Correct.
commission may restrict the number of candidates to be called for interview to a reasonable limit on the basis of either higher qualification, higher marks, grade obtained in the essential qualification, or experience in the field higher than the minimum prescribed in the advertisement, or on the basis of screening test.
Correct.
Here no screening test was done.
Correct.
Only based on the document verification, all the 39 candidates were called for interview.
Correct.
And in interview, that respondent number 7, private respondent number 7 got 73, and the petitioner Bonani, Dr. Bonani got
Very, very,
70.
very the
My lord,
content-
that is why that it was not written in my opposition. That is why I am seeking your lordship's leave to file further.
I am asking you, place the interview, that interview board marking list on the
Yes,
seat
Lord,
cover.
I will annex in my opposition the
Not annex, sir. I want the original, the interview boards awarding the mark in the original in the seal cover.
Okay.
That's all. That will solve the
That will
purpose.
sub-
Nothing will. How soon you will produce?
Lord, give me 2 weeks time.
Where it is?
No, that is not the case, but we have our process that we have to take the permission from the secretary. They have their own process. That is why.
Yes. What about the private respondent?
Kindly see in the page 20,
Five.
25
Correct.
and 24 for the eligibility criteria, my lord, my client is eligible because it nowhere says
There is no
that, yes,
dispute.
nowhere says-
Only with regard to the now, it is only on the basis of the interview.
Yes.
Now,
that-
you are not, neither you disclose nor they disclose, you can't disclose,
Yes.
but they have to
It's based-
disclose, they have to
based on the-
interview.
Based on the
So, okay, you produce how the 39 persons, you produce the interview sheet.
Yes, Lordship. Yes, Lordship. Then
And
What are the members of the interview? Two things you have to produce. One is the recruitment, this recruitment rule.
Okay.
Who will be the committee? Then only they will conduct the interview.
Okay.
Otherwise, the third person cannot conduct the interview. So in the recruitment rule, there might be a column method of
Yes.
selection. If only by a interview, then then there will be a column who are the members of the recruitment committee.
Yes, absolutely.
Or by a special order, your authority might have been constituted a committee for the recruitment.
Also, my lord, at this, what information I have gathered that the medical examination has been conducted based, since he is the selected candidate, and also the police verification procedure are also done. So if
That's the regular
yes,
process. So how soon? So there is a stay, no?
No, my lord.
There's no stay.
Since they are going slow, well, that is why we are not asking.
Also, no.
My lord,
Within a week?
deficit, I might be
Within a week?
raising the point of deficit court fees.
But we have paid that.
They have paid.
Paid. Well, for 5% we have paid.
They have paid. Learned counsel for the petition has concluded his argument. Learned counsel for the respondent private and the respondent number 3 to 6 submit that the selection was made only on the basis of the marks obtained in the interview. But the respondent number 3 to 6 have filed their affidavit in opposition, but they have not disclosed this. They have not disclosed the said fact in the affidavit in opposition. Thus, full stop. This court also thus the respondent number 3 to 6. Who will produce?
Well, the chairman, my lord, of Public Service Commission.
The respondent number 3 to 6 are directed to produce the original interview sheets in a sealed cover of all the candidates who have appeared in the interview board, who have appeared before the interview board within 2 weeks from date. Police of the petition, the respondents are also directed to produce the copy of the recruitment rule for the post of
keeper,
State Archaeological Museum on the next date fix. Let the matter appear.
And my lord, the composition of the interview board, who are they, my lord? And the composition of interview
That
and their qualification and all
full stuff.
this.
The authorities are also directed to produce
results
whether any committee was constituted for conducting the interview of this. If there is any committee has been constituted, comma, the constitution on the order of constitution committee be constituted for conducting interview, and if a committee is constituted, the order of constitution of the committee may also be placed before this court.
Any decision taken by them subject to the result of writ application.
Earlier you're not taken, how you can take? What is the matter? 2 weeks bola na? Aaj kitne? On 26th February 2026.
Cheaply applied. But specify time, my lord.
Not time, at the within 5 matters.
5 minutes. একটু লিখে রাখেন। Cheaply.
এটা লো। Now we declare an affidavit in opposition and affidavit reply. Affidavit in opposition filed with respondent number 326 and reply filed by the petition be kept in the. Yes, next.
Please, your lordship. my lord.
Yes.
What has heard this previously?
Item 18.
Yes.
18 and 19 matters.
I'll run very briefly through the facts of the case. Now, the private respondent, who is the petitioner in item 19 now, by virtue of using an OBC certificate, she has assumed the post of my lord Pradhan of a particular Gram Panchayat. Now, there was, in the previous round of litigation, my lord, there was a direction to consider my representation by the Honorable Justice Amrita Sinha. On the basis thereof, an order was passed that yes, the OBC certificate seems to be genuine. Thereafter, that was challenged, and her ladyship returned to the finding that no, it is not about genuineness of the certificate, but as to whether at all the candidate herself is a genuine candidate or not. Pursuant thereupon, my lord, that particular reasoned order was quashed, and pursuant to the further direction, now, my lord, an order has been passed that the private respondent, my lord, will find the order at page 44. This is based on an inquiry report. 42, the inquiry report is there. Here, the subdivisional officer.
Not belong to OBC.
Yes. Facts is, my lord, she claimed herself to be
OBC.
belonging to the
OBC
hair processing community, my lord. But it was substantiated by, on the basis of the inquiry, my lord, at page 42. That no, she belongs to the Mahisho community. Her clan is, my lord, Shandilo. And in terms of the inquiry, they belong to the Weaver community, which is not, my lord, an OBC in West Bengal. Multiple opportunities were granted to her, despite which, my lord, he failed to produce any records. But now, my lord, I am alleging, my lord, the state inaction, peculiarly in the order at page 44, dated 23rd of July 2025.
Yes.
The issuing authority, the certificate issuing authority has returned to the finding that yes, she does not belong to the OBC community.
Yes.
And has stopped there.
Yes.
No steps have been taken to cancel the OBC certificate. So we had made a representation thereafter. But despite that, my lord, the representation remains, my lord, not acted upon. On the last occasion, there was query, my lord, and the learned advocate for the state informed that no, they are about to initiate action for cancellation. So cancellation, my lord, will find section 9 of the West Bengal Scheduled Caste and Scheduled Tribe Identification Act 1994 that deals with, my lord, cancellation. It states that if the certificate issuing authority is satisfied that a certificate under this act has been obtained by any person by furnishing any false information or by misrepresenting any fact or by suppressing any material information or by producing any document which is an act of forgery, it may cancel, impound or revoke such certificate in such manner as may be prescribed. Now, my lord, will find the prescription. Rule my lord, in rule 3 of the SC/ST rules, my lord.
Yes. If my lord kindly turns overleaf, my lord, it is the rules, my lord, follows the act.
Yes, rule
Yep.
3,
Rule 3, my lord. So whenever it appears,
Yes.
whenever it appears to a certificate issuing authority on complaints by any person or suo motu that a person in whose favor scheduled caste or scheduled tribe certificate has been issued does not belong to such caste or tribe, certificate issuing authority shall hold a preliminary inquiry by itself or by any officer above the rank of Inspector of Scheduled Caste and Scheduled Tribes Welfare Department as may be authorized by it in this behalf, and shall prima facie satisfy itself as to the truth or otherwise of the complaints, and if necessary, start proceedings for cancellation, impounding or revocation of certificate as the case may be. So inquiry, my lord, was already done. On the basis thereof, my lord, a finding has been returned at my lord, the order that I had placed, my lord, that she does not belong to the community, despite which, my lord, she is being favored for, my lord, I say for, my lord, political reasons, my lord, by no action initiated for cancellation thereof. Now, where sub-rule 2, where any proceedings have been started under sub-rule 1, certificate issuing authority shall by written notice ask the person holding the certificate to deposit the same in original in its office, and when a certificate has been so deposited, a receipt in favor of the person depositing the certificate shall be issued, and thereafter, my lord, to show cause, etc. But nothing has been done since everything is in limbo, my lord, since July 2025. And on the last occasion, my lord, the my lord, state apprised your lordship that they are in the process of initiating action.
Yes.
Yes.
My lord, I am for the private respondent number 7. This is a long history. My lord, I will take some time.
I am here.
Mandal Commission issue in Bengal, not a political party help in the issue the Mandal Commission in Bengal. So after the struggle of the backward class communities people.
Have you challenged this order?
No, actually, I am saying this.
No, have you challenged? Have you challenged?
I am. This is a totally political motivated.
Sir, I am putting only one.
What did you go through?
I am putting only one question, then I will go to your document. Have you challenged the page 44?
Yes, you already challenged it, and the case is filed.
Okay.
And this case is 19.
Item number 19, my lord, is their challenge thrown.
Yes, what the state?
No, my lord,
I will hear you, don't. Yes, what about the state?
My lord, the last occasion, my lord, we have appraised the court how we have taken. Thank you. How we have taken steps in this matter. Thereafter, my lord, the direction followed from your lordship, my lord, because there is a contest between the petitioner and the private respondent, and both the writ petitions are before your lordship. These will be heard together, my lord. The state stands to, my lord, act in terms of the law, my lord. There is nothing else for us to say, my lord.
No, but the SDO has passed an order. If the authority find that this one certificate is not entitled,
yes,
either he has to pass an order to surrender.
Yes.
Or to
issued by the SDO, concerned
is either he has to pass an order to surrender or to direct the competent authority to take appropriate step for cancellation of the. These are the two things is to be.
Yes.
Who is the authority for issuing the OBC?
SDO.
He is the competent authority. So if it is done, so why he has not taken further steps?
My lord, the report probably, my lord, if I am not wrong, my lord, this was placed before your lordship on the previous occasion.
Give me the copy.
No report is here.
My lord, may I hand over a copy here and now to your lordship? কিভাবে এসেছে রিপোর্টটা?
Get a copy here.
14th of November, it was possibly read out, my lord.
My lord, this was, yes, probably then I stand corrected, my lord, I was under the wrong impression. My lord will kindly look at, my lord, the last paragraph, which is the step taken just after, my lord, the order of 23rd.
Yes, after final order.
Yes.
The process of cancellation of backward classes so-and-so has been initiated. In this regard, a letter has been sent to so-and-so by Tamluk so-and-so, in which he has been directed to submit the OBC certificate. What is the date?
My lord, when it has been
no date.
My lord, this was sent just before the last, my lord, hearing to my, my lord, learned junior through WhatsApp, and the printouts have been taken on that date only. Now, my lord, we had showed that after the, my lord, prima facie, my lord, satisfaction, which is there on record, my lord, the next step is to ask this, to submit your report. However, my lord, on that day, I have been very candid
And my lord, I remember Mr. Bhattacharya over here thanking me that I have been so candid that since these competing parties are before your lordship, my lord, we have not pressed on this anymore. But my lord, subject to my lord, what falls from your lordship, my lord, the state will proceed.
Okay. Okay. Yes, sir.
As per the recommendation of the Mandal Commission, the state government already issued how the OBC certificate issued by the competent authority. This is a lot of issued on 30th April 2010. This is just for your information, my lord. On that basis, the concerned SDO office through video, the inspector already visited the clause. Not only this case, but all over West Bengal. After inquiry, they will take the local evidence to the neighbors in Calcutta city. We don't know the next track, which community, but in the rural or native place, lot of 5-6 villages know which community that person. And on that basis, the local evidence are taken, and the organization issued the certificate on the verification of the and satisfied by the inspector of the backward class department. He submitted the report to the BDO. BDO submitted that report to the subdivision officer. Actually, as per notification, subdivision officer is the competent authority in that district. In Calcutta, only additional commissioner, they are entitled. So on that basis, original certificate was issued, and she is the originally backward class community, Tuntubai community, and that picture come into the fair. My lord, go to the petition page 30.
Your petition?
Your
writ petition?
Yes, my lord.
Or this which writ petition?
This petition, Ranjit Rokit.
Oh, there, item number 18.
Ranjit Lakhi, yes.
Annex, page 30.
Page 30.
Surani Mondal. Surani and Ranjit Rokit.
Page 30.
Page 30.
Yes.
Page 30.
Yes.
The political party, they already defeated by the, my respondent numbers, let me say.
Yes, yes.
This is the social organization, socially, those who are backward classes, people, they will get the justice, not in the fact in the social organization. So this is the total picture, it will be clear. This is a political motivated way. They have already filed this suit. And accordingly, that before getting the issue report, they filed for the challenging that report. So if the documentary evidence, all the file lying with the SDO office, my prayer, all the files should be submitted here on the basis of a lot of incidents and lot of documents.
So what you want to argue page 30?
No, there's a
What is the contention on page 30?
Political. Ranjit Rokhi is one of the Padma Phul, and second a full Ghas Phul. That is a political revenge. If I succeed the case,
If there is any bar, if a political person came to know something,
no problem.
just a minute. If a political party came to know something is wrong, and he has made a representation, there is something wrong with regard to the political party.
No, my lord, I am not objecting that, but this is the social scenario. He is originally backward class community. His father was that community, and that was a couple people were taking. Tuntubai Samaj, they were manufacturing the cloths. And from that level, they already spotted it, and it was successful, and that was the issue. This is my case. And if any complaint laws against them, then there is a provision that matter will be sent to the Cultural Institute of State Government Authority. Those were social and political and IAS, IPS officers there. SDO has no right to cancel that certificate. That is
Where from you got the certificate? Who has issued the certificate?
SDO, subdivision officer.
So if you have relying upon the certificate issued by the SDO, and once it is coming to the cancellation of the certificate, the SDO has no authority. SDO has the authority for issuance of certificate.
There is a true judgment in this matter. Lots of cases there.
Sure.
True judgment I am submitting for your kind information, my lord.
Can you give us the citation, please? Citation. Is it a reported decision?
Unreported না reported? একটা reported নাম।
আচ্ছা, unreported এর একটা কপি দিন।
But so far as the 19 is concerned, Lord, only I can submit.
No, let it completing. I will come to you.
Because 19 is the main matter because he has challenged the he has prayed for review or recall the order of the so and so. The SDO.
Yes.
But my humble submission, Lord, but I have no book today, Lord, but it is this appeal provision is there. If that statutory provision is there, Lord, whether I am not questioning the Lord, the power of the court. But Lord, the appeal.
Correct. If it appellate provision, show me.
Issue the ex parte order.
Show me. Show me. Yes, which paragraph? I cannot read the whole judgment here. Which paragraph you are relying upon? Which judgment you are relying upon?
দুজনেই হ্যাঁ আইটেম নাম্বার 19 এ উনি পিটিশনার আপনার ম্যাটার আমার তো দুইটা পিটিশনার বলছে যে যখন ফাইন্ডিং আছে প্রাইমারি ভাষায় যে হি ডাজ নট বিলং টু দি তাহলে নেক্সট স্টেপ ছিল হচ্ছে ক্যান্সেল করা কমপ্লেনেন্টের হয়ে যে কমপ্লেনটা লজ করেছিল আর উনি আছেন হচ্ছে যার এগেইনস্টে কমপ্লেন্ট লজ হচ্ছে
ক্যান্সেল করতে হবে ভাই ইয়ে করতে হবে অ্যাপিল করতে হবে
Yes, come to paragraph 4, page 14. Paragraph 3.
হ্যাঁ বিলের প্রভিশনটা দেখতে দাও ভাই
Paragraph 3 subject to any general or special order of the state government.
Which judgment you are relying upon? Kindly come to the writ petition number 24655. 24655.
It is your to dinner.
Krishna Padda Sarda.
Page 16.
Yes.
The left hand side, Lord.
Page 14. Yes, I got it.
There is a provision, Lord.
Page 14. Got it? Paragraph 3. Yes.
That the limited power of the certificate issuing authority for cancellation, impounding or recursion of care cost operate where the person holding the certificate or committed an act of the representation of fact, suppressed any material information which was in act of forgery. While dealing with such cases and only such cases, a certificate issuing authority can cancel, impound or revoke such certificate subject to the provision of Rule 3 of the 1995 rule. Provision of sections of Rule 1 or Rule 3 of the holding preliminary inquiry by the issuing authority itself or by an officer above the rank of inspector of the civil court and Tribes Welfare Department cannot be constructed to mean that the same preliminary inquiry sectors, the inquiry held by such an officer or the certificate issuing authority itself have to be on the same footing as to legal and the report given by such officer above the rank of inspector cannot be held in any manner to be of higher authority than that prepared by the certificate issuing authority itself. However, a condemned reading section 9 and section 8A of 1994 Act makes it evident that such inquiry can only pertain to a case of false information, misrepresentation, suppression of forgery as per 9(1) that above subsection 3 of the section 8A categorically enumerated the power vested in a state scrutiny committee in this regard.
Correct.
This court accordingly total and substantially with the view expressed by the coordinate bench in the Darwell Investment Leasing Private Limited, in such as the state scrutiny committee has the authority to look into the any irregularity or illegality committed in performing, functioning any act under the 1994 Act and to make an inquiry with regard to contravention of
Yes.
this Act.
Anything further?
Page number 16, The Cultural Research Institute, backward class welfare department, government of West Bengal cannot be held on a higher footing merely on the basis of which a report of the subdivision officer would have passed the impugned order. Thus, an inquiry could be based on the circumstances, value in the matter, but not that non-equivalent of the reference of the state scrutiny committee. This court interpreted the judgment of Davil Investment within Private Limited 6 to go one step further and hold that the power conferred on the state scrutiny committee do not amount to the powers of an appellate authority. Since an appeal is case of the status and has to be statutorily provided, this court has jurisdiction under Article 56 of the Constitution of India to enter into the merit of the grievances raised in the present jurisdiction, since there is no provision of 1994 Act creating a right appeal.
Yes, okay.
It is the
That's
base-
all. Anything
based
you
on the social status.
anything you further want to submit? That's all.
But only I'll be referring to a division bench decision.
My lord,
Uh,
lot of documents already
2017 volume
submitted to
5
the-
Calcutta High Court note Calcutta page 497.
This copy already.
4, 25 and 29.
17.5 CH.
My lord, at the time of hearing, this documentary evidence handed over to the inquiry officer.
75 CH in Calcutta 497.
That's why I'm demanding that original file should be submitted, your lordship.
Paragraph?
Well, paragraph 24, 25 and 29. There is no obligation on the issuing authority, certificate issuing authority to obtain any views of committee, my lord, as has been wrongly suggested by my learned friend, my lord.
Judgment. During this issue.
Yes, give the copy to this.
My lord?
Give the copy of this.
Yes, my lord. My lord can keep the book on it.
Para 24 and?
My lord, 24, 25 and 29.
Yes.
My lord, I'll just place my lord for my lord satisfaction, my lord. 29, law is well settled that when a person who is not a member of scheduled caste or tribe obtains a false certificate with a view to gain an undue advantage to which he was otherwise not entitled, that would amount to commission of fraud, calling for immediate corrective action so as to prevent subversion of the constitutional purpose, and no leniency can be shown.
Yes.
These are my humble submissions, my lord, insofar as my lord, my writ petition is concerned, as well as my lord, the writ petition filed by the private respondent in my writ application is also concerned. My lord, humbly beseeching your lordship for a mandatory direction on the state to immediately, within a time frame, my lord, complete the remaining action. Will follow thereafter.
That's all.
The documents already submitted at the time of actually inquiry officer. That copy with us.
Okay, no problem.
But it is denied by the SD office.
You have mentioned your writ petition, na?
Yes, yes. The document evidence.
You are not disclosing in a writ petition. So what writ petition you filed? If you are not disclosed there in the writ petition.
Supplement affidavit will be submitted.
No, final hearing is completed. How the supplementary affidavit? Hearing concluded, both the matter.
Grateful to you.
Both matter, huh?
My lord, the report, my lord, it is only just my duty to indicate it is a copy of the report because it was sent through WhatsApp. On record দিয়ে দেবেন।
একসাথে বাঁধ।
18-19 নাম পেয়ে গেছেন তো আলাদা আলাদা।
Yes, that is very important.
না নামটা না দেখলে
You are saying
তাই-
that
আরে
18
না
and
না
19 there are different set of lawyers.
না
for the state.
different-
I think that is
তাহলে
also very
গন্ডগোল হয়ে
important.
যাবে না
Give the different names
Yeah,
also.
name we have given. But if it is exchanged by this time, then it will be difficult. বলবে যে আমি ওখানে দাঁড়ালাম এইখানে।
Yes, anything? What has happened?
Now I think কি বলছে আপনাদের কি বলছে জজ সাহেব কি বলছেন and now I think Dr. Mulligar is there. Yes, finally.
Yes, Mr. Mutlida.
Unmute host.
Unmute. Please unmute.
I have already unmuted, my lord.
Yes.
Yes. So in this writ petition, we're seeking the quashing of 2 assessment orders of stamp duty in respect of 2 sale deeds.
Yes.
The facts are like this, my lords. 2 parcels of apartments were purchased by us, 2 separate apartments. On September 2003. The first relevant date is 9 September 2003.
Yes.
And there are 2 sale deeds, registered sale deeds, executed.
Yes.
My learned friend will hand over a binder which has copies of those sale deeds. I'm requesting him to hand over those copies of those sale deeds.
Yes.
If your lordship sees the binder. So that first document, which starts at page 1,
Yes.
pertains to a flat at measuring 2288 square feet.
Yes.
The second document is the second sale deed of the same date, that is 9 September 2003.
Yes.
This pertains to a flat of 1712 square feet. Both are in the same building. It's in a commercial property in Park Street.
Yes.
As it turned out, my lords, once we executed the sale deeds, we deposited at the collector's office because the execution happened there only. My lord will have to come back to the main writ petition. We have enclosed the 2 IGRs issued, IGR receipts. That is Inspector General of Registration Receipts. Those are at pages 26 and 28 of the main paper book.
Yes.
The lordships will notice from that they have received certain amounts towards registration charges. 1909 at page 26 and 2536 at page 28.
Yes.
As your lordships are aware, normally when we execute sale deeds, we leave it at the registrar's office. They ask us to come back after some time to collect it if there are objections and all of that. So even under the West Bengal Stamp Act, the procedure is more or less similar, and I'll take your lordship to the provisions of the West Bengal Stamp Act. Your lordships will have to come back to that binder. We have given an extract of section 47 capital A of the Stamp Act as amended by West Bengal. So, my lord will see the bottom in document 4, the bottom of page 156. Running page 156 on the left-hand top corner. West Bengal new section 47A inserted, it says, no?
Yes.
So 47A says instruments of conveyance undervalued, how to be dealt with. I must make it clear, my lords, it is not our case that it is undervalued, it is the department's case. So the department says it is undervalued and I have therefore kept it back because according to me, the value shown, that is the set forth value, they call it the set forth value. They say the set forth value is not reflective of the market value and therefore I'm keeping it back. Now, the relevant provision is subsection 3 of 47A. That is, actually, I should read subsection 2 first, my lords. Let me read 2 first. Where the market value of the property, which is the subject matter of an instrument, has been ascertained, and
Yes. I think there is some problem in the.
My lords, I think we are facing some network issues. Just give us a second.
I'm sorry, my lord.
Yes.
There was a break. So, my lord, that procedure was not followed. Now, if we come back to subsection 3, it says where the concerned person does not make payment of the stamp duty as required. So that provision does not apply to us because there was no notice to us saying this is the stamp duty. Now, the other relevant portion is the reference being made under subsection 3 by the officer for an inquiry as to the correct stamp duty to be paid. On receipt of a reference under subsection 3, the authority specified under that subsection shall, after giving parties concerned in respect of the instrument referred to in subsection 1,
That page 154 of this compiling.
Looking at the book, there is inserted 47A of the West Bengal Amendment.
Yes.
So, your lordships will see subsection 5 on receipt of a reference under subsection 3. The authority specified under that subsection shall, after giving parties concerned in respect of the instrument referred to in subsection 1, a reasonable opportunity of being heard, and after holding an inquiry in such manner as may be prescribed, determine the market value of the property which is subject matter of the instrument and proper stamp duty payable thereon, and shall thereafter issue notice in the manner prescribed, directing the concerned person to make payment of such deficit amount of stamp duty within such time as may be prescribed. Now, this was also not done.
Yes.
Now, my lords, relevant thing is subsection 8, A and B.
Yes.
The authority referred to in subsection 3 may, on receipt of any information or otherwise, suo motu within 5 years from the date of the registration of any instrument, where such instrument was registered on the basis of the market value which was set forth in the instrument, or which was ascertained by the registering officer referred to in subsection 1, call for and examine any such instrument and any other document relating thereto for the purposes of satisfying himself as to the correctness of the market value of the property, which is the subject matter of such instrument and which was set forth in the instrument, or which was ascertained under subsection 2 and the stamp duty payable thereon. I will now pause here for a minute. So, my lords, the options with the authority was, once I deposited the sale deeds on 9 September 2003, they should have intimated me that this is undervalued. Please, this is the correct value that we have determined. We have recomputed the stamp duty. You better make good the deficit. They don't do that. They don't even invoke subsection 8, which gave them a 5-year limitation period, saying anytime within 5 years from the date of that instrument, registered instrument, you can reopen, you can say, no, this is undervalued. So that 5-year period also came to an end in 2008. So neither was anything done in 2003 September, nor anything done before 5 years from that date, that is 9 September 2008. Now, admittedly, if we go by the counter affidavit, they did nothing till 2021, and this is very important, my lords. Till 15th July 2021, they virtually sat on the two sale deeds. And we are talking of a period of 18 years. I kept running around in circles. I would go to their office. They first said, we are still examining it. Then they said it's misplaced. So all this I have averred in my writ petition. Now I'll take my lords to the exact sequence of events in July 2021. If my lords turns to my petition.
Yes.
In my petition, if my lords will refer to para 19, para 18. No, sorry. I'm sorry, my lords. I'm sorry. Para 16, if my lords will come to. Para 16. Your petitioners state repeated demand justices and reminders notices were issued to the respondents on 7th May 2021 and 20th May 2021, requesting the respondents to consider the market price of the premises in question during the year 2003 and to release the sale deeds executed in favor of the petitioners forthwith. Copies of the representations we have enclosed. Para 17. Your petitioners state that the representatives of your petitioners was asked to be present at the office of the respondent number 3, that is the Deputy Commissioner of Stamps, on 15 July 2021. And as per such verbal instruction, the representatives of your petitioners presented himself before the office of the respondent number 3 on 15 July 2021 at 1:30 p.m., wherein for the first time, to his utter shock and surprise, he was handed over with an alleged notice dated 9th July 2021. This date is important, my lords. Yes. The 9th July 2021 date. This is the notice under subsection 5 of section, I read section 5 of section 47A of the Indian Stamp Act. Copies of such notice are enclosed. Now, para 18, your petitioners state that it is pertinent to mention herein that no such notice under subsection 5 was ever issued by the respondent at any point of time during the last 18 years. And such alleged notice dated 9 July 21 was only forced upon to receive by the representatives of the petitioners on 15 July. Now, para 19, I'm reading these paras because I will take my lord to the reply that they have filed, will become clear. Your petitioners state that upon receipt of such alleged notice under subsection 5 of 47A of the Indian Stamp Act on 15 July 2021, the representatives of the petitioners were forced to appear before respondent number 3. Copies of declarations and haziras filed with the petitioners before the respondent number 3 are annexed here too. Your petitioners state that your petitioners are shocked and surprised to receive the order dated 22nd July as passed by the office of the respondent 2 and 3 under subsection 5 of subsection 8 of section 47A of the Stamp Act for determining the market value and discovered that the alleged sum of 14,28,505 and 10,80,589 were ordered to be paid for alleged deficit stamp duty payable for the two separate sale deeds. So, my lords, what they have done is, without following any procedure, taken the market value of 2021 and determined the stamp duty payable on these two as of 2021, as if the sale took place in 2021.
Yes.
So, well, this was completely contrary to the procedure. What should have happened in 2003 or latest by 2008 is sought to be done in 2021. Yeah. Now, my lords will see the reply that they have filed. They have filed a very short counter affidavit, and this too after my lords were pleased to grant them repeated adjournments for that purpose. They make an omnibus reply. First, my lords will see para 8 of their reply, internal page 4. Yes.
Yes.
So, internal page 4, para 8. With reference to the allegations made in paras 12 to 14, I deny and dispute the same. I say that the queries being so and so and so and so were generated from the system. Market value of the properties being comprised in such documents was assessed, and thereafter stamp duty chargeability on such documents was determined, accordingly serving notices. Well, they are admitting here that till 2021, they in fact did not generate from the system any market value.
Yes.
I must also take my lord to para 6, 2 paras earlier, middle of that paragraph. Admittedly, my lords will find that word. Admittedly, these two documents were presented for registration at the office of respondent number 5 after their formal completion. Thereafter, they were admitted to registration. Accordingly, serial number so-and-so of 2003 and so-and-so of 2003 were generated. So they admit that in September 2003, they received these documents, issued me the IGR receipts, and my lord saw in para 8, for the first time in 2021, they generated from the computer system the market value.
Yes.
They also say that they directed us, they made references, please see admittedly, see second part of para 8. Admittedly, the office of respondent number 4 received such demand notices from the petitioners and duly acted upon it by directing respondent number 5 to make references under 47A3. This completely ignores 47A8, which says the time period for doing it was only 5 years. Now, para 9. This is an omnibus reply to all those paras I read out. They in 28. I deny and dispute the allegation. I said the representation was acted strongly act. They did nothing. And you
Mr. Muralidhar,
21 market value to
there is a problem in the, there's some problem, I think.
My lords. It's connected. It's connected.
Is it better now, Mela?
Yes, now, yes. Now you continue.
It's working. So now I'm asking.
Yes, I'm sorry, my lords.
Yes.
Am I clear now?
Yes.
Yes, I'm so sorry. Well, so in para 9, they do not dispute the fact that they sat on the sale deeds for 18 years. They do not dispute the fact that they did not take the 2003 market value. They admit they took the 2021 market value. My respectful submission is this is completely dehorsed section 47 capital A, which they are themselves referring to.
Yes.
So my submission is very simple, my lords. That determination of the deficit stamp duty could have been, if at all, only with reference to the 2003 market value, not the 2021 market value. That's point number 1.
Yes.
Point number 2 is under section 47 capital A, in any event, the time period for undertaking this exercise was long crossed. The statute does not permit you to sit on a sale deed for 18 years.
Correct.
So even under subsection 8, the maximum time period was 5 years from 2003, and you have crossed that time limit.
So why you
So
are not
by
approached?
any
2003 to 2021, why you are not approached?
No, I have repeatedly approached, which is why I read the writ petition paragraphs. I have said, let me again read those relevant paragraphs. In my petition, I have repeatedly said that. Para 3 is 1. Para 5, para 6.
What is the reply to the paragraph 3?
Let me just see that, Malas. Para 5 of the reply, Malas. With reference to the allegation made in para 3 of the writ petition, I deny and dispute the same allegations are strongly denied and disputed. as though iota of evidence preserved with this office to support the fact that the party the documents had been denied by this office in handing over. Well, these sale deeds were ultimately handed over to us by the orders of your lordships.
Yes.
Your lordship had to pass an interim order because they actually came and said it's misplaced in our office. So the actual handing over of the sale deeds happened in 2025.
Yes.
So this reply doesn't take us anywhere.
Correct.
They are admitting that they sat on these sale deeds.
Yes.
So, well, this is an undisputed fact that it remained in their office. It's an undisputed fact that I have already mentioned that your lordship's interim order, if I just refresh your lordship's memory, your lordships will recall that a detailed order had been passed on 6th August 2025, where without prejudice to our rights and contentions, we agreed to pay the excess stamp duty as determined by them, and we got this. Your lordship says if I deposit that amount, they should hand over the sale deeds.
Yes.
So pursuant to this, I did pay that under protest without prejudice to my rights and contentions. And finally, well, it's after repeated adjournments, they have handed over that sale deed to me. And then they took time to file a reply. Your lordships gave them that extra time, and that's how we have come for final hearing. So my point is this, there is no dispute at all that they issued me that IGR, that is the Inspector General of Registration number, way back in 2003. They're not disputing it in their reply. They're also not disputing that they did nothing for 18 years.
Yes.
They're not disputing I made those representations in May 2021. They're not disputing that before that, I in fact kept running to their offices. What they say, there is no iota of evidence that they had retained the sale deeds. In fact, they have themselves now handed over the sale deeds to me. So it was nowhere else, it was in their office. And in 2021, they suddenly seem to have awoken after my representations and said, Acha, let us now take the market value for 2021. Let us now somehow determine the stamp duty and ask them to pay.
Yes.
So whatever procedure they have followed is completely dehorsed the Stamp Act, not permissible under it. On the face of it, well, these two assessment orders. So the two assessment orders we have enclosed with a writ petition. If my lords will see that. Annexure P9. That's at page 108. And that order sheet is 109. For one sale deed. And for the other sale deed, the order sheet is at 114. The order is at 113. So these are the two orders we're seeking the quashing of.
Yes.
So the case is quite straightforward, therefore, my lords, that these excessive stamp duties can't be determined from me at this stage, 18 years later. By all means, they could have collected the actual stamp duty, which I deposited.
Yes.
So now that I have made these payments under protest, this should be refunded to me after your lordships quash these two assessment orders.
Okay. Thank you.
And then I have a short compilation of case law. I'm not going to take too much of your lordship's time. If your lordship sees the binder, because this is like carrying coals to Newcastle, that if a statute is silent on within which time you should perform an exercise, it should be within a reasonable time. So that proposition is too well settled. But in that binder, your lordships will find these judgments. One is at page 190, document number 9. Yes. Santosh Kumar Shivagonda Patil versus Bala Saheb Tukaram Chevale. The relevant portion para 11. It seems to be fairly settled that if a statute does not prescribe the time limit for the exercise of revisional power, it does not mean that such power can be exercised at any time. Rather, it should be exercised within a reasonable time. It is so because the law does not expect a settled thing to be unsettled after a long lapse of time, where the legislature does not provide any length of time within which the power of revision is to be exercised, by the authorities suo motu or otherwise, it is plain that the exercise of such power within reasonable time is inherent here. This is like a demerer argument, assuming even subsection 8 is not a time limit, which I say is a time limit of 5 years. You will have to exercise that power within a reasonable time.
Yes.
Likewise, the decision in Citadel fine, Government of India versus Citadel fine pharmaceuticals, document number 11, and the relevant is para 6, which says pretty much the same thing.
With judgment,
Government of India versus Citadel fine pharmaceuticals, document number 11.
Starts at page 201.
201. Paragraph 6. And I would not multiply, my lords. I think one more decision is more than enough, which is more recent, which is at page 226. Union of India versus Citibank.
Yes.
2022, 19 SEC, page 188. And the relevant portion is para 19. Well, the last may not be exactly relevant anymore because they failed to exercise their powers.
Particular period, yes.
Yes, well, what they could have done and should have done is take a contemporaneous document to determine what is the market value of 2003.
Correct.
So only for that benefit, I have placed one other additional sale deed that I entered into in that same area that my lords will find in the binder at document number 3. One other sample sale deed of the same Park Street area I have kept, just to show that I have not undervalued. The value stated by me in my sale deed of 9 September is the same value, market value, which was prevalent during that time. Only for that purpose, I've placed one document number 3. Well, if the authority had properly conducted an inquiry, given me a notice, I would have produced this way back in 2003 itself. But all that stages have been crossed.
So this is of 2004.
2004. Some contemporary value could have taken. Even there, I say this, Malats, that exercise you could not perform in 2021. You should have performed it within reasonable time of 2003. Maximum 2008, not beyond that.
Like that, our land acquisition, when it was acquired, what was the value of the adjacent value of the property? Yes.
Absolutely right, Mal. Absolutely right. I am deeply obliged. This is I'll wait for this reply arguments and then rejoin.
No problem. Yes, when Mr. Sen will be available?
I know next week anytime. I know.
Next week anytime.
May I ever hand over the compilation, my lord?
Give. Mr. Sen is not there. I am fixing another date for their reply, and if problem, then you can give the rejoinder, Mr. Today, Mr. Sen is not here.
Well, can lordships give a date? Then
which is the preferred date? Learned counsel for the petitioner has concluded his argument. Full stop. Counsel for the respondents press for time. Recording case is adjourned. Let the matter appear. When Mr. Sen will be available?
My lord's convenience, my lord.
No, can it be 24th February, my lords?
24th February?
Yes.
24 February तो टाइम 12 और 2 फिक्स होगा ना? 12 ही फिक्स है, 12 भी 2 ही फिक्स है।
तो ठीक है।
और 23rd at 2 o'clock, Malats.
24th at 2 p.m. at first matter.
Very well.
Grateful,
very well, Malats.
We've handed over a copy of the compilation to my learned friend.
I am deeply obliged.
Thank you.
Thank you.
Grateful, man.
The book. Yes, call the matter.
No, this your lordship had heard on the last occasion twice. And
I'm
your lordship
appearing on
needs
behalf
to
of the
grant an order of injunction. This was regarding quorum non juris.
And what is
We had cited judgments. Lord, last time they came and showed a decision regarding some notification if it is there. That also your lordship had expressed my lord's mind. But direction was given to come up to see if there was any such
Yes,
notification.
there is a notification, my lord. It is 1st March 2017.
If we could also have a copy of.
Yes.
Yes. This is.
That third bench has passed this, the impugned order.
Under section 16(1)(1)(b). Consumers Protection Act you are having?
Well, at 16(1)(b).
Consumers Protection Act.
Right.
B. 1986. After 2019 amendment.
That is equivalent to the PMLA. Authority, adjudicating authority, whether single or.
But I know there are judgments which say that this can't be done because the statutory mandate can't be overridden. At least 16(1)(1)(b) of the.
That's why. Because now read 16 first. Each state commission shall consist a person who is or has the judge or high court appointed, provided so and so so and so. Now 16(b)(1)(b). The jurisdiction, power, and authority of the state commission may be exercised by the benches
But
thereof.
somehow in the book, in what I have, that is not there. Just bear with me for a minute, no? The latest version of it doesn't have it. I have it from the.
It is amended in the year 2019. It is
Like,
a old 1986.
I'm looking at the 86 Act only. I'm looking at the 86 Act. Rules not Act here. Consumer Protection Act. এখন কোথেকে আনবে আচ্ছা ওটা 90
না 90 আমারটা ছিল
What I have is slightly different, although it's the 86 Act itself. The India Code is something else.
Judgment যেগুলো পাস করেছে অর্ডার ইনক্লেম করতে হবে।
The act that is available on India Code is different from what possibly your lordship is looking at.
This Bear Act.
নেই না এ তো একদম অন্য আইন 16(1)(1)(b) তো নেই
No, but this single member constituted, whether is a judicial member.
Yes, my lord, he is a judicial.
He is the judicial member. What appears from this notification 1st March.
Presiding member.
But his power to override, that's something that I might have to look up to to really come back and address your lordship on it.
See to that.
Yes, my lord,
Because the Supreme Court judgment occurred Tikatar, which in the
yes, the one that I had cited.
no, the
But
Justice
it is
Bhattacharya relied
2024,
upon.
At the same time, it is just like the situation. Well, Ramjan Khan case has been passed 1990. Prior to Ramjan Khan case, what the judgment delivered, that cannot be taken as a nullity, my lord.
No, that's correct. That's correct. But if the latest Supreme Court has what is the latest position of the Supreme Court?
Well, even the state rule is there.
Huh?
State rule is also there.
Huh?
State rule is also there, my lord, which I have last referred. State rules.
That's why state rules are there. That's
The Tikita Industries, if your lordship sees, the one that I cited of the Supreme Court, which was a appeal of 2018.
That's why.
Paragraph 3, if your lordship sees.
Because the paragraph 3 says, attention the court, the impugn judgment was urged, the same has been delivered by the sole non-judicial member.
Yes.
Non-judicial member.
By a sole
Which is not
non-judicial member.
Non-judicial member. Because that's why, because the non-judicial member cannot.
But later it says, the impugned judgment has been passed by a single member of the tribunal.
Single member of the tribunal.
Quorum itself being incomplete. So it has to be 2.
Opinion of order demanded back to the tribunal.
So whether judicial or non-judicial, if it's a single member, because that is the requirement of the Act. Now, by a notification, if the requirement of the Act can be altered, the 16(1) bit of
No, but the Act says different thing. Single bench, a single member. If it is any confusion, it can be referred to the division bench and the majority will decide.
Well, let me just examine this and come back, because there is another Supreme Court judgment which we found saying it actually can't be done by a notification. You can't override with regard to quorum what the law says.
No, that's why 16(2) they kindly read. That's why 16(2) is there.
Lord, I'll be embarrassed, my lord. Your lordship will not read it out for me. Let me just have a look at it. Please forgive me. What we are carrying, it's quite, the 86 Act is quite different from.
And that has been interpreted by our Justice Bhattacharya.
Yes.
In 2017 itself.
No, order 20. Yes.
Yes, no, this doesn't stand in the way. 16(1)(1)(b) is actually in my favor. The jurisdiction, power, authority of State Commission may be exercised by the benches thereof. A bench may be constituted by the president with one or more of the members as the president may deem fit. If the members of a bench differ in opinion on any point, the point shall be decided according to the opinion of the majority, if there is a majority. But if members are equally divided, they shall state the point on the points on which they differ, make a reference to the president who shall. So there is no option to change the statutory prescription under 16(1)(b). It has to be a president with one or more members, which is why Tikitar says the moment it's one, it's quorum non judice. Kindly have a look at 16(1)(b). This notification, I don't know under which section they have the power to issue this notification.
They are upon 16(1)(b).
Kindly have a look at
16(1) and 1(b).
I don't think subject
16(1) is the jurisdiction, power and authority of the State Commission to be exercised by the benches. 1,
yes,
there's no difficulty.
No.
2, a bench may be constituted by the president with one.
That's right.
With one. It is not with the president.
In conjunction.
Has to be read. It is the constitution constituted by the president with one or more. It is not with the president.
True. But there has to be
with one or two members, either one member or two members.
If your lordship looks at the 3 will throw light on 2, the 1(b).
No, that's
because the moment
first we cross. A bench may be constituted by the president with one or more, because the same thing in the PMLA Act.
Yes.
Same thing in the PMLA Act, the adjudicating authority
adjudicating authority constituted by the president with a member, or so with a member means it is not with the president.
Here,
So it has been interpreted by the Supreme Court.
here, I follow. Here, this is the president is bench one. So I can
President is-
understand that. But
President
bench two,
can. President can.
but bench two is presiding with a member. And third is just the presiding. I don't think the law gives them the right to have a one-member bench. Otherwise, three is going to become completely redundant. Three contemplates a situation.
Three, if the member of the bench, if member of a bench differ a opinion on any point, the point shall be decided according to the opinion of the majority.
That's right. So
Correct.
if there is no majority,
No, that's why. If
Okay.
there is, if
but
there
the
is a
members are
majority,
equally, I'll place it. Not, please don't mind. If the members are equally divided, they shall state the points or points on which they differ, and make a reference to the president, who shall either hear the point or points himself, or refer the case for hearing on such points by one or more of the members. And such points or points shall be decided according to the opinion of the majority. So if I now use II to throw light on B1, I mean Roman 3 to light on 2, it never contemplates a situation where there is one. Because the moment the law recognizes a divergence in view, then it goes to a single. Otherwise, my lord, a bench may be constituted by the president with one or more members. So at least one will have to be there. Now, if your lordship looks at the notification, he's constituting one with one member. Then there is a presiding member with a member. And then third bench, even if I take this analogy, president can do it by himself. This is not the president. He's the presiding member.
He's the presiding member.
So the president may be by himself, or he can be with one or more. In fact, that is also covered, that depending on the nature of the matter, your lordships have held recently. Depending on the nature of the matter, he can choose 2 or 3.
Yeah, that is different.
Under
That's why.
that is
Because
different.
That is different, and that is with regard to the Administrative Tribunal Act.
85 Act, that's right.
85 Act, it is constituted of 2 bench, but one bench can be taken, but there is a notification which matter is to be taken by
which bench?
Single bench.
By the single bench. Because 85 Act language is also different. Here, if your lordship looks at 16(1)(b).
Okay, do the homework.
I'll do that.
The Learned Counsel for the respondent has handed over. Yes, respondent number 2 has handed over the order dated 1st of March 2017.
But I'm sorry for the interjection, Lord. May I pray for only one thing? Would your lordship please call upon them to file this by way of an affidavit? Because at least to show that this was invoked from this date till what date? Because the order that is passed is much later.
Who is for the state authority?
Respondent number 2.
You do one thing, you file the report by way of an affidavit disclosing that will be better, because once for all it can be disposed of.
Because this is in supersession of something else. I don't know till what time this order was invoked.
You can क्या बोला? Order dated 1st of March 2017, and some wherein 3 bench has been constituted, wherein the State Commission has the State Consumers Dispute Redressal Commission has constituted 3 benches, out of which 1 bench is consisting of only 1 member. Let the same be kept with the record. This court find that a report is required to be filed by an affidavit. Let the respondent number 2 file the report by way of an affidavit within a period of 2 weeks. Within a period of 2 weeks, exception if any, within a week thereafter. Full stop. List the matter on 6th of March 2026.
6th of
March. Under the heading, urgent motion, urgent motion. One acre.
Wait.
Next. Okay, then 10th March. 10th March. Next.
20. Lordship may kindly recollect me, Lord, it is on my request an embarrassing situation that created that it appeared prima facie to your Lordship that they have given a certificate from Bihar, which your Lordship will recollect it, which according to the other side as well from your Lordship satisfies the criteria.
Correct.
Now, my Lord, kindly take trouble to look to the same document on which your Lordship have seen, my Lord, the clause, it would be only at the stake of repetition. I would just, page 26, your Lordship would be recollecting the words which have been given. Looms that I placed that of the estimated value put to tender through single order in a financial year for the last 3 financial year. My Lord, kindly I am putting one emphasis on FY, that is financial year 22 to 23.
Correct.
Kindly mark this.
3 years, this is 22, 23, 25.
Yes. Now, this in a single work order.
Correct.
For this, they relied on, my Lord, page 160. I
Yes.
straight away take your Lordship to the document which your Lordship have taken already note of.
166.
166.
166 is a tender and the document is the 258.
262%.
262, sorry.
Come to 262.
Yes, 260.
The first 262 will show this is an acknowledgement of supply of different kind. It is recorded. Now, my Lord, if in the body we go on, in the body, in my, it's not so legible, but the tender date is 23/3/2022. Did your Lordship get it, my Lord?
Yes, data 23.
22.
Yes, 23rd March 2022.
23rd March 22.
Correct.
Kindly, my Lord, mark this date.
Yes.
Therefore, this is the date and this relates to this tender.
Yes.
Our requirement is 4 crore, the value has been given.
Correct.
4 crore 35%. They have calculated it and said, my Lord, that
So your value is 5 crore.
calculation of this comes to
Your total tender amount is 5 crore.
5 crore 21,29,989.
Correct.
And 35% of the same comes to 1 crore 82,45,496. This comes to 35.
1 crore.
1 crore, I'm sorry, 1 crore 82 lakhs 45,496. The word has been used, my Lord, single work order.
Correct.
Now, my Lord, kindly turn to the page that is tenders, which are in support of this. This 262 is not a document of completion of a work in a particular year. Our requirement under the clause is a completion certificate of the work. That apart, the other point which comes in that 162, kindly have a look to 166. This is the tender. This 166, my Lord, kindly take trouble to skip to some of the pages. This is tender number, your Lordship will find 30 of 2021.
Which one?
Page 166.
Uh-huh.
In each of the pages that if we go on, that is 169. Kindly have a look to 169.
Yes.
2021.
1973 dated 25/10/22.
Correct.
Now, this is the work order. Thereafter, series of document I have checked up, but some of your Lordship can take note of 25/10/22 172. This is with respect to work order 1972. The again your Lordship will find 74, sorry, 1970. These refers to multiple work order in a tender. Multiple work order will be apparent from the series of document annexed. Therefore, my Lord, yesterday I made a mistake in understanding that when it is written 30/31,
This 30 by 31 at page 166 relates to tender, but not its of work order. Therefore, the work order relates to all series, which shows that in that tender, multiple work orders were issued to him. Our criteria is that once he is not putting the documents of a singular, I state again, may not go to the word that once he is not giving the same to a single work order, page 26,
Yes.
he will be out. Because we can't consider multiple. The terms clearly provides that single order in a financial year. This is one ground that multiple work order he has given. Not of single work order covering this amount, that is 1 crore 82 lakh, which comes to 35%. We have also checked the amount, and the amount does not come to 1 crore 82, that is 35%. That apart, that apart, your lordship will find the financial year for which we have given is page 26, FY 2022 and 2023. The document which
Financial year 2022 to 2025,
Yes,
3 years.
Yes. Now, my lord, going to the said document, which just now I have taken your lordship, 262, that shows a date anterior to that.
Yes.
That is 262.
Yes.
Your lordship will get the date 23/3/2022. Did your
23.
lordship page 262?
Correct.
Where Therefore, 23 March 2022 is not of 3 financial year. It is 1 year anterior. That is financial year ahead. Therefore, on these two grounds,
Okay.
because the date is given 23/3/2022. Therefore, this is not of financial year 22 and 23. This relates to financial year 21/22. That is 1 year anterior. We are asking him to give for last 3 years, which your lordship have got it. This is why, my lord, he has been eliminated from this. And the other points which your lordship yesterday I took, but I made a mistake in understanding, because why, there is an obvious reason that possibly my client was not served with the copy of writ petition. Your lordship may entertain it, there is no dispute. But since the managing director, usually in our court, we have a practice that the petitioner needs to serve a hard copy of this. I have been told by the department that as they did not receive the hard copy, though, so they could not prepare that instruction, but that apart, it goes. So what the last representation, which yesterday I, my lord, pointed out, and your lordship said that they have made a representation. 291.
Yes.
Because your lordship may remember, my lord, that I tried to press this, and this your lordship will find was made by through, I understand, in a email. In a email, it doesn't bear a signed copy of this. Therefore, under the terms of the contract, if I take your lordship to again, the terms of the contract, it stipulates that a complaint is to be made before managing director in case he has page 29. Now, kindly have a look to page 29.
Clause 33.
Clause 33. My lord, your lordship will find page, I will take
Yes.
your lordship to 33.
Yes.
If there is any objection regarding disqualification of any bidder, the same should be lodged online to the managing director. Online to the managing director.
Correct.
WBSIDCL within 48 hours from the date of opening of the technical evaluation. My lord, it does not bear a hard copy and it has been sent in email. Of course, not when the, and there is, kindly come to page clause 35. In the event, the power of the managing director, who is the issuing tender, has been given in the event of any question arising or differences arising between SIDCL and the manufacturer or any matter covered by these terms and condition in any manner, the matter shall be sorted out by Managing Director WB SIDCL. If at this point the dispute is not resolved, then my lord, the procedure for arbitration. Therefore, what it appears that the person who has issued, the authority who have issued the tender will prima facie have a right to adjudge anything which comes on record.
That's all.
Now, this has not been satisfied. In the writ petition, I have checked up, my lord, that his prayer is yesterday. His prayer is in the writ petition that we have page 11, paragraph F, your lordship will find that we owe a duty to consider the complaint being annexer P7 to the application. If I go to the prayer which he has made, kindly turn to page.
Okay,
15.
anything further?
No.
Yes.
Consideration of
Turn to 166.
Yes.
May I read out the top portion, my lord?
Yes.
Online e-tender has been invited by director such and such for implement of supplies for supply of handloom accessories such and such. Handloom cluster in Bihar state under HS National Handloom Development Program guidelines such and such. White tender notice, tender number dated 23rd March 2022. My lord, can you record? From the eligible bidders, the tender schedule program is extended as below. Then, my lord, it comes. Shall you consider it is extended by putting the same into the financial year 2022-23. And my lord, this is a cluster project. If your lordship consider this is a single work order, this is a cluster project. I have to supply the goods from as per the direction of the, because it is under the single need. I cannot make anything which is not, it is a direction that you supply this much of quantity under the same NIT to this cluster. It is a cluster based project. So if my lord, may I hand over a copy? আমি দিচ্ছি তোকে আমি দেখাচ্ছি না ঠিক আছে Your lordship will find the order numbers are mentioned. আমি দিয়ে দিচ্ছি তোকে আমি এক্ষুনি দিয়ে দিচ্ছি
let him place it thereafter.
Because I have only one copy.
It's all right. I need to
up to 25/10/2022 enter works. This was the direction for it comes within more than 1 crore and odd. What my learned friend was submitting that in one financial year did not complete the same, and this is on the basis of which, because my lord will find that eligibility up to my lord 2022-23, and that is why your lordship.
So these are the in the tender notice all together you are having 1, 2, 3, 4.
Up to 1975. Kindly consider up to 1975.
16 work order. Correct.
I have to direct. These are work orders on the cluster basis.
Correct. 16 work order. 16 work order consisting of 4 crore 20 lakhs.
Yes.
Correct. So as per the tender, as per their tender, so you have to be 1 crore 1 lakh 82,000 is the 40%. Is the 40%. So his contention is that now you come to the this is okay. This is a one tender. Tender has been issued, but different 12 or 20 supply order has been issued.
Yes, supply orders.
You supply order. So now you come to the page 29. 20. Now come to the page 29. 26. Page 26. 26, third line. Through single order in a financial year.
Yes.
So
this is single.
It is not a single tender. Single order.
Now, if you logically consider, email.
Not a single tender, it's a single work order.
Same thing is interpreted in this 252.
Single order. So if whether this single tender separate work order includes a work order or single order in that sense. because it appears, my lord.
So that is the only criteria now they are taking with regard to single order, because you are giving the 4 order of the total whatever the
In the financial year, this is a one need, one tender, but separate direction for.
but it is not a single order. It is the
Yes,
order.
some of the amount I have also quoted. My lord will not find in a single order that amount. That is I'm getting. একটা আছে লাস্টেরটা
I have been said that
Yes.
this also relates to other financial.
Huh?
Yes,
No,
actually,
it cannot.
Last one.
It cannot be other financial year. Only come to the 166.
166.
I defer that.
Yes.
166.
But he may
kindly-
give a copy so that my
Yes,
I can.
No, 166. Come to the 166 of the writ petition. It cannot be. Kindly come to 2nd April 2022.
2nd April 22.
And opening is 12th April. So
This
it
is-
will after the 31st of March.
This is bid submission start date.
2nd April and opening 12th April.
But he has to, my lord, satisfy a
Even though-
completion certificate.
Even though then you come to this figure which has given.
Now
Yes.
Given. So you are one single order.
one single
One-
order, one financial year. Sorry.
182. 1,82,000. Now come to the fourth one.
1, 2, 3, 4, 266. Lakh plus lakh, 26 lakhs. 1 crore.
2,66,800. 2,66,000. No, 2 crore 66 lakhs 80,000. No, what is this?
No, 26 lakhs.
23 lakhs.
26 lakhs.
26 lakhs.
26 lakhs.
68,000.
5%
That is
is
I
1
cannot
crore.
improve. What is there I can because our
না কিন্তু আমাদের
because financial bill it appears the person who has got the content quoted more than 6 lakhs.
No, no.
From us. That is I cannot reopen
Okay.
the same, but
Therefore, 1
So that
crore
is no one.
87 in one.
that I cannot argue. That I cannot argue with your lordship. So the concept on the basis of which the initial declaration was that not a financial year, no credential
So
ambition.
I am disposing.
Yes.
Yes.
As your lordship.
Or you are withdrawing.
Withdraw
Same
something else.
thing.
my lord. No, not same thing. I cannot withdraw anything in absence of the instruction of my client. It's the adjudication of what my Mr. Honorable Court will say.
I'm sorry for that.
Thank you. Thank you. The
I needed assistance from the client.
The petitioner has filed the presented application challenging. Where is the rejection order?
And
Challenging
rejection order, my lord,
the-
is fine. And pay.
Challenging the rejection of the technical bid of the petitioner. With the technical bid of the petitioner on the ground that criteria not fulfilled.
72.
Yes, not fulfilled. Full stop.
Yeah, I have a lordship. My lord.
Yes. The West Bengal Small Industries Development Corporation Limited had published a tender. Published a tender. What is the name of the work?
What page 26?
For supply of looms, machines, wooden furniture and accessories. The petitioner has participated in the said tender. But by the impugned communication dated 29th of January 2026, the technical bid of the petitioner has been disqualified. Full stop. The petitioner submit that as per the tender condition, comma, the intending bidder should have credential for completion of wooden furniture or looms, machine and accessories work of minimum value of 35% of the essential estimated amount put in tender through single order in a financial year for the last any 3 financial years starting from 2022-2023. Full stop. The petitioner has relied upon the document, annexed document issued by the Assistant Director, Handloom and Sericulture, Bihar, Patna, dated 18th of December 2025, wherein it is mentioned that it is mentioned that the petitioner company has been one of the impaneled supplier for supply of different kind of handloom within bracket 60 inch, 66 inch, 72 inch and 96. This one, page 262. Iron loom and accessories under the tender notice dated tender notice number HKSS/YO/HSS/E dash tender dash 30/2021 dated 23rd March 2022, invited by the Director of Handloom and Sericulture Bihar through e-tendering mode on e-procurement Bihar portal having work order of amount of rupees 4,02,03,550. By referring the said document, the petitioner submitted the petitioner has the completion certificate of one work which is more than 35% of the estimated amount put in the tender, but without considering the said document, respondent authorities have disqualified the petitioner for disqualified the technical bid of the petitioner. Consider for the petitioner further relied upon further submit that the said document is counsel for the petitioner connecting the aforementioned document has relied upon the tender notice dated 23rd of March 2022, appearing at page 166 of the present in the writ application, which reveals that is for the year 2022, and as such 2022, and as such the financial year of 2022-2023 onwards is and as such this said work is within the financial year of 2022-2023 onwards. Per contra, learned advocate appearing for the respondent authorities have relied upon the terms and conditions of the tender document and submit that as per the terms and conditions of the tender document, the intending bidder should have completed the wooden furniture or looms, machine or accessory works of the minimum value of 35% of the estimate amount put to the tender through a single order in a financial year. He submitted the document which the petitioner has relied upon is not a single order document, it's not the work under the single order. He has relied upon the documents appearing at page number 172 to 186 of the instant writ application and submit that the petitioner has completed the work in different work orders, and as such it cannot be considered the work petitioner has completed the work in a single work order. He further submit that as per the tender notice which the petitioner has relied upon, wherein the petitioner submit that the petitioner has completed the single work, is issued on 23rd of March 2022. And as such, the financial year cannot be taken as 2022-2023. It should be a financial year 2023, 2021 and 2022. Thus, this certificate cannot be taken into consideration. Full stop. Learned counsel for the respondent further submit that after the rejection of the tender of the petitioner, petitioner has made a representation which is appearing at page 290 to 292 and submit that he has also marked the said representation to the managing director, but the said representation has been sent by the petitioner by email to the managing director with the email address wbsidedcltd@gmail.com. But the learned counsel appearing for the respondent has relied upon clause 33 of the clause 33 of the tender of the terms and conditions of tender document, and submits that if there is any objection regarding disqualification of any bidder, the same should be lodged online to the managing director, the WBSIDCL at marketing@wbsidcl.in within 48 hours. But the petitioner has not submitted the said representation in the said email address. He further relied upon clause 35 of the clause 35 terms and conditions, and submit that if the managing director receives any objection, the managing director can resolve the dispute, and if it is not resolved, it will be referred to the arbitrator for final decision. Counsel for the petitioner submit that in all the three counts, the petitioner has not satisfied in the writ petition, and as such the writ petition is liable to be dismissed. Had the learned counsel for the respective parties peruse the materials on record. The petition has relied upon the certificate issued by the Assistant Director, Handloom and Sericulture, Bihar, Patna, wherein it has been satisfied. It has been certified that the petitioner has completed the work for an amount of rupees 4,02,03,550, which is much more than the 35% of the estimated amount put in tender. But the documents which are appearing in support of the said certificate from page number 172 to 179 shows that the said work has been completed by the petitioner in different work orders, not in single work order. As per clause Roman 9 of the terms and conditions of the tender document, the intending bidder should have completed the minimum value of 30% of the estimated amount put to the tender through a single order. Thus, this court find that the petition, the completion certificate which the petitioner has relied upon is not with respect of the single order. As regard the financial year, as regard the question raised by the respondent with regard to the financial year, this court find that the tender notice on the basis of which the completion certificate was issued, that work is to be executed from the month of April 2022 onwards, and thus it cannot be said that this is the financial year should be taken into consideration at 2022. As regard the representation, this court also find that the petitioner has not made the representation to the managing director in the proper way in terms of the terms and condition of the tender document. Considering the above, this court did not find any merit in the present date application. Accordingly, the application is dismissed. However, no order has to pass. Appellate side. 32 what?
My lord,
Sorry for the embarrassment.
No, nothing.
Yesterday I was not in a position.
Item number 52 also, that pharmacy matter entry order is
Just
expiring today.
now, my lord, I have made an application for vacating of this interim order, my lord.
Which order? Which one?
32, my lord, 32.
32.
And in that application, pleadings are complete. So, my lord, any day the matter may be fixed.
What is the matter?
My lord, it is regarding termination of contract, government contract, where arbitration clause is there. So, I have that order, when that order was passed, granting the ad interim order, I failed to appear before this honorable court. Now, my lord, but I have made an application seeking recalling of that order.
Affidavits completed? Main writ application?
No, my lord. In the
Have you filed the
application.
affidavit? How soon you will file the affidavit in the main writ application?
My lord, if we file affidavit in the main writ petition, we may be prejudiced. My lord, if your lordship kindly hears the main this writ application for recalling.
See, application for recalling, then that's why I wanted, if you want to file the writ application without prejudice to the rights and contents, and you file it. Keep them, take the plea in the mental writ of writ petition if you want to take that.
My lord, no,
One day I have to hear the vacating application, another the main application.
My
So
lord-
I don't want all the piecemeal matter.
my lord, this application is for non-disclosure of material facts. So there is an arbitration clause. On that limited ground, this application has been filed.
So, correct. If you say that only you file this is the point of law, you will not use the affidavit. I will require, and I will treat your application, taken the application along with the writ application. The matter can be taken up.
Then, my lord,
Taking as a point of law.
my lord, in that event, without prejudice to our application for recalling, we'll file an affidavit. I need 7 days time to file this
Correct.
affidavit.
You file. I am fixing a date.
My lord.
Within 7 days.
7 days, I'll
file. How much time?
We'll need 7 days, my lord. The client is based out of Bhopal.
So the matter is listed as item number 33.
32, my lord.
32. 32, but due to paucity of time, the matter could not be taken up for hearing. London Council for the petitioner mentioned the matter and praised for action and submitted the interim order still today and paid for extension of interim order. London Council for the respondents raised objection and submitted the respondents already filed an application for vacating the interim order. Vacating the interim order. Full stop. Heard the London Council for the respective parties. This court finds that the respondents already filed an application for vacating the interim order. But if the interim order, but this court is of the view the writ petition itself is to be disposed of on merit after hearing the parties. Accordingly, the counsel for the respondent prays for a week time to file affidavit in opposition.
Instead of week, my lord, 10 days, my lord.
Prayed for 10 days time to file affidavit in opposition. Take 2 weeks. Within 2 weeks. Prays for time to file affidavit in opposition within 2 weeks. Reply, if any, there to be filed
My lord.
within 10 days. Within 10 days. Full stop. Let the matter appear on मार्च में कोई डेट হবে কি হবে না अप्रैल Second April 12 noon.
My lord, I'm deeply obliged.
12 noon. Interim order is extended till 6th of April 2026 or until
My lord, if an advance copy may be served upon us.
2 weeks after serving the copy to the Land Council for the petition.
I'm deeply obliged.
But item number 52, Lordship has,
yes.
Lordship has that pharmacy council matter, my lord. Lordship has, my arguments are complete, my lord. It is, if you want, is expiring today.
52.
52. Pharmacy council.
Who is for the other side?
The other side is not there, my lord. 53 is Devashish Bhattacharya. That is WDF.
So you are 52.
52.
Devashish Bhattacharya.
Landed Council for the, though the matter is listed as item number 52 of the today's list.
Thereafter, again, it was extended.
And submit that the interim order is till today and prayed for extension of interim order. In view of the submission made by the council for the petitioners, interim order is extended till 6th of March 2026 or until further order. Let the matter remain in the list. Yes, call. Close up in let's say.
Keep
Original side matter 126 and 127. This is that matter, that power of attorney matter. We have, for your lordship's convenience, we have prepared a short notes and the compilation of judgment, my lord.
126, 127.
Yes, well, this is the GF4 lastly filed by them with prayers just the opposite, that we should not rely upon the power of attorney. In fact, GA1, which is your lordship deciding, that will dispose of GA4 also. One way or the other, my lord, it will come. So, my lord, I was
But we
you
were to
can-
give the affidavit on reply.
I
Lordship,
have they have filed their notes. I have come with the notes. Your lordship can take the notes and make it CAV for all purposes.
no. My lord, we need to file our reply. It's not with me today. It's ready.
So, my lord, may your lordship place it
My
as
lord,
to be mentioned, and your lordship can take
They
it.
have given,
Where is your reply?
but it's not with, it's with the advocate on
So
record.
when you serve the advance copy,
Yes,
by
we will.
tomorrow,
Yes.
tomorrow, so how much time you will take?
They have made argument.
No, basically, but there are 13 judgments that they have relied upon. This has been given to me just now. But any date, Lordship will fix, but we will do it. No problem. It will be completed.
First few judgments are already cited while we were arguing GA1.
Not all.
This is only for GA4.
4 were cited, other 7 or 9 were not cited.
How many judgments?
13 judgments.
All relating to GA4.
Very well. That I can't.
The lordship will keep.
कोई short date होता क्या? कोई है कभी?
Give us, my lord, any date will your lordship will fix it at
कोई एक तो top में कर दो.
10 minutes for us, my lord, it should be over.
Next week. 17, 18 तारीख. Top में रख कोई. 18th I am fixing at the top.
May I file it today, my lord?
Come on that day.
Very good.
18th को ना top में कर दो. वो दोनों. Yes.
Let it be one line, my lord.
Record and all.
Sorry to.
Though the matter is listed as item number 26, 126 and 127, but the learned counsels for the counsel for the parties submits that this court has heard the matter at length, and on the written notes are yet to be filed, and the counsel for the defendant petitioner applicant in GFO prays for some time to give reply and to distinguish the judgment relied by the respondent in GFO. Considering submission made by the counsel for the party, let the matter appear on 18th of February 2026 at the top.
And my lord, we are supposed to give the affidavit in reply to GF.
I will record that.
Well, as the previous order, lordship was pleased to extend the interim order. My other side has
Watching
come.
the board, I have rushed.
Name be recorded.
Give the name. I don't know.
Yes.
Yes, next.
Item number 1, this is my writ petition, my lord, challenging MSME proceedings. The parties have settled the disputes. The MSME proceeding has also been withdrawn. I have instructions to withdraw the writ petition as well. This is the communication from the client, my lord.
Item number 1.
Item number 1.
Record. You are for the plaintiff.
I am for the petitioner.
I am for the opposite party.
Learned counsel for the petitioner has handed over the communication dated 3rd February 2026, wherein the petitioner has informed the non-advocate that the petitioner is not intending to proceed with the matter, as the matter has already been settled. Learned counsel for the petitioner submitted there was a dispute pending before the MSME that has also been settled between the parties. In view of the submission made by the counsel for the petitioner and the communication dated 3rd February 2026, WPO 687 of 2024 is dismissed as withdrawn. Communication be kept with the record. Interim order, if any, stand vacated.
Wait.
Next.
My lord, this is for the correction. My lordship was pleased to pass an order on 4th of February, my lord. One, my lord. There is in written third line. 26th of September, my lord.
Huh?
Lordship kindly comes to para 1 of your lordship order of
Yes.
that instead of 26th, that should be 25th, my lord.
25th.
My lord. And thereafter, my lord, lordship kindly comes to paragraph 2, your lordship, my lord. The court has further directed defendant to pay the monthly allowance of rupees 20 plaintiff number 1 and 15,000 to the plaintiff number 1 only till November 2018, and thereafter the defendant shall not pay to any monthly. Lordship kindly comes to the petition, my lord, once at page 81, lordship, my lord. Page 81, my lordship kindly comes to last two para, my lord. Page 81, my lord. Page 81, my lord. Para 5, I am reading, my lord. Concept the plaintiff submits that the amount of rupees 14 lakhs is to be duly paid to the plaintiff number 1 being the monthly maintenance, and rupees 11 lakhs is to be paid to the plaintiff number 2 as monthly maintenance till date. Thereafter, my lord, in last paragraph, the defendants are directed to pay the said areas of monthly maintenance to the plaintiff at the rate of rupees 40,000 per month to the plaintiff number 1, and from the month of October 2024, and 30,000 to the plaintiff number 2 till the realization of the aforesaid monthly maintenance, my lord. My lord, I am submitting only this, my lord. The alleged container 1 to 6, they are paid only for the month of October 2024, my lord. And thereafter, they don't pay anything, my lord.
What you want?
My lord, I want lordship, and this is, my lord, the order, my lord. That this court further directed the defendants to pay the monthly allowance. At least that should be corrected, my lord, as observed by lordship order, my lord. In last paragraph 6, my lord. Page 81, your lordship. That should be corrected, my lord. Lordship can come to your own order, my lord. Internal page 6, page 81, my lord.
The matrix list has to be mentioned for correction in the order dated 4th February 2026. Counsel for the petition submit that in the order dated 4th February 2026, in paragraph 3, the date is to be read as 25th of September 2024 instead of 26th of September 2024. He further submit that in paragraph 2, the amount is to be read as as 40,000 and 30,000. No, the paragraph 2. In paragraph 2, line number 2. Line number 2, the amount is to be read as 20,000 and 40,000 and 30,000, and instead of up till November 2018, it should be till the realization of the monthly. Okay. Accordingly, paragraph 2 shall be read as follows. Semicolon, inverted comma. This court further directed the defendants to pay the arrears of monthly maintenance to the plaintiff at the rate of 40,000 per month to the plaintiff number 1 from the month of October 2024, and rupees 30,000 to the plaintiff number 2 till the realization of the aforesaid monthly amount.
And may I submit only, they have paid only for the month of October, my lord, 2024, my lord.
Next.
For the respondent, my lord, this is a contempt application. It may come back to your lordship's mind that, my lord, the son wants to send his father to, my lord.
My lord, led by Mr. Rupak Ghosh, my lord.
Yes.
On
Morning,
occasion,
Rupak. Mr. Ghosh
he's
is
coming, my lord. He's joining, my lord. On last occasion, specifically, my lord, so far as my father and mother is concerned, I don't, my lord. So it was an understanding that day, my lord, we have submitted through our counsel, my lord. But so far as my lord contempt is concerned, my lord, after passing of your lordship's order on 30th July 2024, thereafter, my lord, just I am indicating, my lord, at page 323, my lord, just I am indicating order. Counsel for the defendants.
What you want? What you want now?
My lord, so far as the deed which has been after your lordship's order, that deed should go. Or my lord,
that is to be decided on merit.
They have filed a suit.
Obviously, my so
They
far
have
as
filed
other
a suit.
property,
So nothing remains of the contempt. Well, let them contest the suit.
let my learned friend argue
I have.
And then.
I have concluded my submissions, my lord, in
Was
July.
Corninger has submitted that he has some personal difficulty. He will take time. That's why. Whether he will argue or not.
25th June, my lord, I made my submissions.
Not a week, any day, your lordships kindly keep it, my lord.
My lord, kindly, my lord, this contempt, my lord, I will tell you, lordship. Let him say, my lord, how old is his father?
Not only that, my lord, maybe tomorrow, day after tomorrow.
This threat of contempt, my lord, hanging on an old man, my lord, is creating.
Yeah, right. I'm only seeking, my lord, 1 day indulgence, my lord, 1 day accommodation. Subject to your lordships and my senior.
My lord, I made my submissions on
13 June. 13 June 2025.
Yes. Then, my lord, 18 July. Oh, yes, yes.
I'm thankful, grateful to my friend, and my lord, I tender my apology.
Yes.
My lord remembers the facts of the case are very short. We filed a suit and we moved an injunction application before your lordship. Two orders are very important. Just to recapitulate, kindly takes volume 3 of the petition. Kindly takes volume 3, 322, 323, 324, and 333. Yes. Kindly, I'm just showing these two orders so that it comes back to your lordship. What is the order that we are complaining of? The contempt whereof is complained of. 322. My lord, is that 322, volume 3? Plaint is admitted subject to scrutiny. Counsel of the defendant has appeared and prayed for a copy of the said application. According to the plaint, if he is directed to serve the copy of the said application to the learned counsel of the defendant. Counsel for the plaintiff has already served the copy of the learned counsel for the defendant. Now kindly turns over. Counsel for the defendants, on instruction from the defendants who are present in court, submits that the defendants will not take any steps for transfer of the suit property till 31st July 2024. So, my lord, two things appear, and I have the video recording of that day also. My lord, lordship had in fact passed the order. Your lordship remembers, in my favor of injunction. But then Mr. Chaudhuri appeared, and my lord said that I will argue on the maintainability of the petition, and hence, my lord, on instruction, he submits that the defendant will not take any steps for transfer of the suit property till 31st July 2024. I am saying, now what is their case now that they have made out in the affidavit? That on 18th of July, kindly marks the date, 18th of July 2024, they had gone and executed before the registration authority their signature. So, my lord, first, according to me, and there is no answer to that, that this submission made by the counsel on instruction at page 323 itself is contemptuous. When on 18 July, you have gone to the registration office and executed deeds of transfer or deed of gift, all the defendants were there in court. You should have told the court that, look here, do not pass an order because we have already transferred or at least gone and signed the transfer deeds. Nothing was told to the court, and false assurance was given through the counsel. This itself is contempt. Okay. Number one, there is no answer, no argument in this regard. Now, my lord, kindly turns over 324, the order of 31st July 2024. Kindly straight away after your lordship has discussed, my lord, the entire, my lord, gamut of the case. Kindly, my lord, come to straight away to, my lord, page, my lord, 333, paragraph 24. In view of the above, the defendant number 1 is restrained from alienating or creating any third-party interest with respect of the properties mentioned in paragraph 18A of the suit till 8th September 2024. So 30th is the first order, 31st is the next day. I am saying 30th itself is an act of contempt when, if at all I say that you have done the registration or executed the deed in front of the registrar on 18 July, that undertaking that you have given on instruction through your counsel is contemptuous. And now 333, kindly see paragraph 24, your lordship has categorically, my lord, injuncted them from alienating. Now, this is an order of 31st July. Now, what do they do? My lord, kindly come to 337 and 342. 337, kindly see, 2342 of the same volume.
Yes.
I have taken out the details from the Directorate of Registration and Stamp Revenue. Kindly see, date of registration is 1st August 2024. And date of completion of registration is 2nd August 2024. So I have said that at least it was your duty, even on 31st, when the court has injuncted you, you could have written a letter through your advocates or otherwise to the registrar saying that I had executed a deed on 18th. I have given an undertaking to court not to transfer, and today the court has passed, the next day has passed an order of injunction. Do not give any further effect to my registration. Nothing done. Now, my lord, they further aggravate the contempt during the pendency. How? Just on this fact, and then I will go to the law as distinguished by my learned friend. But kindly takes a supplementary affidavit which had been filed on, my lord, 7th of October 2024. Kindly see, my lord, even after 30th and 31st, my lord, kindly see the letter that has been written at page, my lord, 12 of the supplementary.
Yes.
This is on 30th September 2020, further aggravating the contempt.
Yes.
To the Secretary, Ashoka Flat Owners Association, this is one of the properties that was injuncted by your lordship.
Yes.
In paragraph 18A, kindly see, this is to inform you that my grandparents, Shri Bhawarilal Sanai and Srimati Pushpa Sanai, had gifted their undivided shares in the said property by executing gift deed in my favor on 18 July. You are requested to make necessary changes in your record and ensure that future any kind of correspondence and maintenance will be raised in my name. So, my lord, again trying to give effect.
Yes.
In the teeth of the order of 30th and 31st. And my lord, this has been forwarded to me, page 13, by the association, that this sort of a request is made.
Yes.
Now, my lord, in these circumstances, I had, my lord, cited, the first judgment I had cited was that of, my lord, Ghanoshyam Sharda versus Shashikant Jha, 2017, volume 1 SCC, page 599. Now, my lord, Mr. Mitro has tried to distinguish this judgment by saying that the case there was different. The case there was that they had not put in the requisite stamp duty, and hence the registration was not done. But kindly, again, my lord, with the deepest of respect to Mr. Mitro, kindly come to the paragraphs that I have referred to. And possibly, my lord, that, my lord, will not change the ratio. Whatever Mr. Mitro has pointed out will not change the ratio as has been held by this decision. Kindly, my lord, takes paragraph, my lords, 17 and 18, my lord, of this decision.
Yes.
The first question that arises is whether any alienation or transfer was effected after the order of 8th May 2014. The submission of the alleged contemners is that the conveyance deed was executed on 4/4/2013, prior to the order, on which date the entire consideration stood paid by the transferee and was credited to the account of the company, and as such, the title passed in favor of the transferees well before the order of 8th May 2014. This is exactly what they are saying, that 18 July I have executed. And what was done on 2nd July 2014 was a mere ministerial act. According to the alleged contemners, the documents presented for registration in April 2013 were not accepted for want of adequate stamp and registration fees. Exactly what I had said. This infirmity was removed and the documents were then presented for registration. In such circumstances, the order of 8th May 2014 was not in any way violated by them. Exactly the defense. Now, kindly see what the Supreme Court has said. The order of 8th May 2014 had directed that capital assets of the company shall not be disposed of without taking permission of this court. The expression shall not be disposed of in the context connotes action or process of sale of assets. Going by section 54 of the Transfer of Property Act 1882, transfer of any tangible immovable property of the values of rupees 100 and upwards can be made only by a registered instrument. The expression only in the section is significant. The transfer, kindly mark this, the transfer comes into effect and becomes valid and effective only by a registered instrument. It is true that the document was sought to be registered in April 2013, but the registration is in question was duly effected only on 2nd July. In the eye of law, it is this document registered on 2nd July 2014 which alone effectuates transfer of interest in Katihar property in favor of the transferee. The transfer was thus effected on 2nd July and not in 2014, well after the order of 8 May 2014. In Suraj Lamp Industries Limited versus State of Haryana, court has observed, and that is quoted. Then, my lord, again, my lord, see paragraph 19. The document dated 4th April 2000 did not by itself create any interest, nor did the title pass upon execution of such document, but it was only after registration on 2nd July 2014 that the title in Katihar property passed from company in favor of the transferees. The submission of the contemners, however, is that by virtue of section 47 of the Registration Act, the document in question would operate from 4th April 2013. Kindly mark again, in our view, the principle embodied in section 47 of the Registration Act is completely for different purposes. Insofar as the issue of transfer is concerned, section 54 of the Transfer of Property Act is governing principle, which is quite clear. It is a date of registration of the document which is crucial, inasmuch as the transfer is effected and the title passes only upon registration. Viewed thus, it is clear that Katihar property was transferred in the teeth of the order of 8th May, and especially there has been violation of the order passed by this court. This is the finding, and one has to correlate the finding with the facts. This is exactly what the contemners have tried to tell your lordship, that we had only executed. We do not know when the registration authority will give effect to it, so it is beyond our control. No. The actual transfer takes place as on the date when the registration is given effect, that is admittedly after, and most important, one has to read this decision and the conduct of the contemners with the fact that even 30th they had the opportunity to tell your lordship that do not pass any orders. I have already signed on 18 July. They did not do so. Then, my lord, kindly see, my lord, I have relied upon 2017. I'm sorry, I have relied upon 2017 to SCC, page 456. This is, my lord, on the principle para 42 and 43. There is also no answer to this because I have said by Seward's principle, although the grandson is not a party in the suit. Paragraph 42 and 43. I'm not repeating.
Yes.
Your lordship has seen that.
Yes.
That Seward's principle, even a person who is not a party in the proceedings, if he is otherwise aware of the order and is actively abetting the contemners in violating it, they are also equally bound. I'm not repeating this decision. Now, the last most important decision that I had cited, and I don't think there is any distinguishing of this proposition, that is reported in 2006, 1 Calcutta Law Times 355, the division bench judgment of Justice Ashok Kumar Ganguly and Shailendra Prasad Talukdar, as the Honorable
2003 SEC online.
2006, 1 Calcutta Law Times 355.
Okay, since.
This is for the principle that court's arms are so long, and my lord kindly takes, I'm sure your lordship has the notes, but some time has passed. Let me just, my lord, at the cost of repetition, indicate to your lordship the paragraphs I had cited. Paragraph, my lord. Paragraph 45 to, my lord, paragraph, my lord, 67. Paragraph 45 to 67, which, my lord, essentially, my lord, just to digress for a moment, all the decisions that your lordship, my lord, or we also come across from Supreme Court, saying that bring down this structure, do this positive act, orders of injunction, those are all under Article 142 and passed by Supreme Court under Article 142. My lord, the question arose whether the high courts also have a power under the contempt jurisdiction to not only, my lord, implement, but also, my lord, take the clock back Say, my lord, somebody has been subjected with an order of injunction not to construct. The person, being aware of the order, constructs. Whether the court's powers are hands are long enough to even bring out that construction. You know? উড়ে গেছে? উড়ে গেছেন কেউ? হ্যাঁ? তুলুন, 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 তুলুন। তুলুন, তুলুন।
वकील है
পত্রগুলো রাখা থাকে না জিনিসপত্রগুলো রাখা থাকে
No, no, it's fine. Just strip ties.
yes
So, my lord, the question arose whether the high courts have similar powers to even not only, my lord, sorry. Now, my lord, the question arose whether the high courts have similar powers to not only, my lord, punish the contemners by sending them to civil prison, but also undo the act that they have done in teeth of orders. My lord, here is a clear case by the division bench citing, my lord, English authorities, the test laid down by Justice Kakevich and Justice Lopez and Lord Justice Lindley, the Honorable Division Bench, and also looking at, my lord, the decision rendered by Sir Ashutosh Mukherjee in the case of, my lord, Israel versus Shamsher Rahman. This division bench has categorically held that in appropriate cases, the high courts also have a power to actually undo the act. So, my lord, in a broad sense, my lord, now the last point Mr. Mitro had argued, if I remember correctly, was here is one son trying to send the aged father and mother to prison. My lord, let me be very clear. I'm not wanting. I'm not wanting. Two things I want, my lord, that these deeds be set at naught. I do not want my father and mother certainly to go anywhere, let alone prison. But, my lord, the acts that they have done at the instance of the grandson and, my lord, the other son, that has to be, my lord, set at naught. The deeds have to be undone. Your lordship's powers are there. This judgment categorically says that whatever deeds they have done in the teeth of the order of court, the court's powers are there to undo it. Number one. And number two, the grandson,
yes.
my lord, is absolutely behind it. Your lordship has seen that he has aggravated the contempt even after orders being passed and, my lord, the contempt petition being filed. He has gone ahead and asked the, my lord, association to again, my lord, further transfer and mutate the property in its favor. This is a person who is belligerent enough to be, my lord, visited with some consequences under the Contempts of Court Act. My lord, what should be the punishment? I leave it to your lordship. But certainly the act of contempt is lying writ large on its face. My lord, those are my submissions. I will not take up any further time. If your lordship, my lord, requires only if your lordship requires, I can come with a short notes. Otherwise, my lord, those are my
that's all.
My lord, I argued before your lordship long back. Now, my lord, the last point, my lord, in fact, my lord, it may come back to your lordship's mind, my lord. There is an order, my lord, where undertaking was given that, my lord, the letter written to the association shall be withdrawn, and that was done.
I'm seeking for the cancellation of the deeds.
Coming to that.
What will happen to the deed registered?
Sorry, my lord.
What will happen to the deed registered?
Yes. Now, my lord, as I submitted before your lordship, my lord, two orders have been relied on before your lordship. The first order, my lord, of 30th July.
Correct.
My lord, at page 322. My lord, volume 3.
Volume 3. Volume 3.
Volume 3. At 323.
Yes, 323.
My lord, it is submitted that, my lord, it's a contemptuous statement. My lord, did I gain anything by making this submission, my lord? If I may ask myself the question. My lord, had I said that, sorry, the document has already been registered, this situation would not have changed. My lord, I did not gain anything. I could have understood, my lord, that after making this submission, I went and, my lord, registered the same document on the same day, had presented the document for registration on the same day, my lord, the situation would have been different. That is the situation, my lord, which arose in case of 2006 1 CLT 355, relied on by my learned friend. Paragraph 20, Lordship will see the order was passed and thereafter, my lord, step was taken on the same day.
Yes, you have to, you pointed out with regard the rules, what is the procedure of this registration?
No, my
how
lord,
the-
I had nothing to do, my lord. I could not have, my lord, done anything. My lord, that was, and my lord, 2017 1 SCC 599, the, you know, Ghanasham Sharda case. Now, my lord, there again, my lord, I had demonstrated before your lordship. I had
Yeah, you already given report, I will take a note of it.
I had given, my lord, reply, my lord. I have said that, my lord, there again, steps, positive steps were taken for registration of the document. Because stamp duty was not paid earlier, it was kept pending. After the order, stamp duty was paid. My lord, nothing similar has been done here. Now, my lord, under the circumstances, my lord, in my respectful submission, there was no contempt, my lord, on the part of my client. Mere statement, my lord, recorded in the order of 30th July, my lord, that is not and cannot be, my lord, contemptuous. As I have said, my lord, I had, my lord, no, my lord, I could not have changed the situation by making that submission. My lord, those are my respectful submission, my lord. If your lordship wants, my lord, I can
file the return notes.
Very well. We shall.
Counsel for the parties have concluded their argument. Understood. Parties are directed to file their written notes of argument within a week. Within a week. Within a week. List the matter on 18th February under the heading to be mentioned for filing written notes of argument. 18th.
19th or any other date.
Okay,
I know
20
it's a
got-
very bad habit. I
20
myself, I
20th February.
detest this habit. In interim order till that date at least.
Interim order is extended till disposal of the contempt application.
Lordship.
Yes, call them.
शांति हो चैप्टर रोज करके दे
फोन किया था वो भी 3 PM
My lord, item number 4,
I appear for the petitioner.
and for the respondent number 4, 6, and 7. There was a previous direction upon us on the last day to file the affidavit in opposition. We have filed, my lord, and served a copy.
Lord, we have also used a reply. My lord, I have prepared a synopsis and list of date for my lord. I'm handing it over to your lordship. My lord, I'm giving my learned adversaries copies.
Kindly have a look at the size of the synopsis and list.
No, I have made a compilation so that my lord doesn't have to look into the other documents. So whatever documents, what I will rely, my lord, it's a part of this compilation. শুধু সিনপসিসটা হলে ভালো হবে।
Yes. My lord, at the outset, may I make one submission, lordship? For the respondent numbers 4, 6, and 7, I'm being led by Mr. Shundip Bhattacharya. He has been diagnosed with lymphoma, my lord, and he is undergoing treatment currently, my lord. So for our reply, my lord,
No, my lord, I'll
I
take
don't
the
think
rest of
Mr.
the.
Chakravarti will complete in a
yes,
day.
I cannot. But the
As
facts
per
are-
the volume of
I have. Let them take notes, my lord.
You take notes. If it will complete or also will give time to you, no problem.
But I told him that with the volume of papers, I'll read the brief with him.
compilation.
Other side এ copy দাও, compilation এ। Photocopy বানিয়ে।
আমরা কি compilation এ
না।
হ্যাঁ, photocopy বানিয়ে।
follow করতে পারি।
Not kindly take. Not kindly take note the. হ্যাঁ, চলো, চলো। সেটা তুমি বলো না, দর্শক।
My lord, I think well, it will continue.
Half an hour.
Other release.
Unless they underestimate Mr. Chakravarti. Then punish him.
Grateful, my lord.
But kindly take the first page, not the page 2. Lord, I have given, Lord, the details of the parties because, Lord, I need to explain who had a role, Lord, into the entire incident. Because I am challenging an order passed by the Clinical Establishment Commission, Lord, whereby the commission, despite observing that the institute is responsible for the untimely and unfortunate death of my daughter, Lord, let them go scot-free by payment of 5 lakhs fine. And Lord, I have made all the directors who are there in charge of the institute parties here. So Lord, just to explain what is their role in that, Lord, I have made this page 2. Kindly have a look at, Lord. Lord, West Bengal Clinical Establishment Commission is the respondent number 2. Lord, they have not filed any affidavit. They cannot support their own order also, Lord. It's a judicial order. We are challenging it. Lord, 3, Lord, is the Medical Enterprise Private Limited, ML Medical Enterprise, which is the owner of the respondent number 5. Lord, respondent number 5 is the clinical establishment where, Lord, the IVF was done. 3 was the owner, Goenka Nursing Home. 4, Lord, owner of the trademark Institute of Human Reproduction. Lord, Institute of Human Reproduction is the brand name whereby, Lord, me and my wife were treated. So 3 is the owner of the clinical establishment. 4 is the, Lord, the owner of the trademark of the clinical establishment.
Owner of the trademark means?
Lord, the IHL is the IHL is the trademark. The trademark is registered in the name of Goenka Nursing Home. Then, Lord, 5 is the clinical establishment. 6, Lord, Deepak Goenka is the shareholder and director of respondent number 3 and 4. Lord, Reshmi Goenka, respondent number 7 is the shareholder and director of 3 and 4. Pushpa Devi Goenka, respondent number 8 is the shareholder and director of 3 and 4. Neelam Agarwal, private respondent number 9 is the shareholder and director of 3 and 4. Surya Agarwal, respondent number 10 is the shareholder and director of 3 and 4. So 3 is the owner, 4 is the, and kindly turn the page. Respondent number 8. 11.
Embryologist.
11 কোথায়? কোথায় ভাই? 8 তো. 8 Milord is the, this should be 11. তোমার কাজ তো. This should be respondent number 11 Milord at page 3. I'm sorry Milord. Lord, she is a senior embryologist with respondent number 5, daughter of ML Goenka, and the person who is liable to respondent number 3 and 4. Page 3, my lord.
Yes.
Respondent number 11. Then I have prepared a synopsis for my lord.
Yes.
Or kindly allow me to place it for your lordship, my lord. Not all from the records, nothing from outside. The petitioner and his wife availed the service of respondent of 5 clinical establishment on and from 20th July 2016 to 23rd May 2018. In this treatment cycle, the respondent performed 3 IVF procedures on the petitioner and his wife. It was always agreed and understood by and between the petitioner and his wife and the treating doctors at the respondent clinical establishment that the self gametes of the petitioner and his wife will be used for creating embryo, which is to be used for the IVF treatment. On 12 March 18, the third IVF consent form was signed, on the basis of which the petitioner and his wife underwent the egg collection and TESA procedure. And on 23rd May 2018, the embryo was created with the self gametes of the petitioner and his wife and were transferred to the wife. The third IVF was successful and the petitioner and his wife were blessed with a girl child. Lord, I have annexed the copies of relevant document, which is already a part of the writ petition and here also. On 30th June 21, the said girl child was diagnosed with a form of blood cancer and the treating doctor suggested that the bone marrow transplantation is the only solution. The petitioner and his wife were the obvious donors for the child, but during HLA type testing, they were shocked to find out that there is a mismatch in their DNA and their daughters. Till then, we were given to understand that it is from the self gametes. So we went to for the HLA testing. There we got to know there is complete mismatch. Then the petitioner and his family thereafter approached the respondent of 5 clinical establishment when they were shocked to be informed that the clinical establishment committed some mistake, due to which the embryo created by the self gametes of the petitioner and his wife were exchanged and that of any other couple. We were informed then. The respondent number 5 clinical establishment provided the details of the female donor. Lord, kindly mark this. After they told us that, look, there is a mistake. Lord, There have been several stands taken by them. I'll take your lordship later on. Initially, they said there has been a mistake on our part. There has been some mismatch. Some other embryo has been transferred. We said immediately, please supply us the name of the biological parents so that we can save the child, because it was our own daughter. Whoever was the biological father, that was immaterial to us. That is why we are fighting till date. Now they supplied us, kindly see, the respondent number 5 clinical experience provided the details of a female donor, Rinki Das, who was later found out to be the biological mother of Isha Kothari, the child. They provided the name of the biological mother. The respondent number 6 and 7 immediately resigned from their post. Why I have made them party? As directors of the respondent number 3 company, they understood that they will be under trouble, they resigned immediately. But I have annexed the relevant documents. Can you turn the page? The stem cells of the biological mother were not enough, and the petitioner and the treating doctors requested the respondent to provide the details of the male donor. However, the respondent refused to divulge the details of the male donor. Lord, the lady came. We approached the lady came. We took care of the entire treatment expenses. She donated her bone marrow. But with that 50% bone marrow, the child could not be saved. I have annexed one document of the treating doctor who was treating the child. He said that he also has personally contacted with the institute and requested them, please supply the name so that we can save the child. But for some reason, they did not do. Initially, I'll take you also. Initially, before the commission, the defense of the institute was that we have never asked for. Before then, we went to the consumer commission. There they said, we have not formally asked for, but they searched. Here before your lordship, the defense is that we have not formally asked. We have not written a letter. But they themselves went out and searched. There is no document, nothing. I'll just take your lordship. I will be shocked. The girl child of the petitioner ultimately died on 9th March 2023 as a direct result of the gross negligence and malpractice of the respondent. The petitioner and his wife thereafter obtained the medical records from the respondent of 5 and were shocked to find that the third IVF form, as originally signed by them, were replaced by a forged and fabricated document, and thereafter they immediately lodged a police complaint being FIR number so and so. The petitioner and his wife also approached the respondent number 2, West Bengal Clinical Establishment Regulatory Commission, by way of filing a complaint dated 12th November 2024. In the meantime, on 2nd July 24, the police authorities filed a closure report in the FIR number 268. 268 of 2023 dated 2nd July 24, against which a Naraji petition was filed by the petitioner and his wife. Relevant document. Before the respondent number 2 clinical establishment regulatory commission, my lord may mark this. The respondent number 5 and 11 filed their replies and contended that the consent form dated 12 March 2018 is genuine, and the police has filed a closure report in the FIR. Now the Naraji is allowed and police is investigating. It was there before the commission. The petitioner and his wife never approached, Kali Mark, the respondent number 5 clinical establishment with the request to provide the details of the male donor. That was their specific case before the commission. That we have never approached.
Yes.
Then how could you give the details of the female donor? That's the question. The petitioner, then the Naraji petition filed by the petitioner and his wife was ultimately allowed, and the certified copy of the order dated 10th January 2025 was duly communicated to the respondent number 2 clinical establishment commission on 17 January 2025. The respondent number 2 clinical establishment regulatory commission, in spite of noting the opinion of its expert doctors and in spite of being empowered under section 31 and 33 of the West Bengal Clinical Establishment Registration, Regulation and Transparency Act 2017, allowed the respondent to go scot-free with a penalty of 5 lakhs. But the petitioner has challenged the impugned order before the Honorable Court for mod.
Yes.
But then, Lord, the contention of the respondents. The respondents have contended that all the respondents have filed separate affidavits except respondent number 1, 2, 3 and 8. The consent form dated 12th March is genuine, and the petitioner and his wife agreed to choose all 4 available options. Not kindly mark this, I'll show you. They have produced a form where, my lord, all 4 options were chosen. My eggs, my husband's oocytes, donor's egg, donor's oocyte. That is clinically, medically not possible, what they have produced. 23rd embryo transfer, it was decided that the donor embryo would be used by the couple, and hence an embryo was created but out of the donor gametes to be used by them. The respondents have further contended before the Honorable Court that even though there was no official request from the petitioner, the respondent suo motu searched for the male donor, and as he could not found, they could do nothing, and they had provided details to the petitioner during the relevant time. The respondent number 4, 6, 7, 10, and 11 have additionally contended that they have no role in the management of the respondent of 5 clinical establishment. Respondent of 4, 6, and 7 has additionally contended that since the Assisted Reproductive Technology Act 2021 does not have any retrospective operation, no manner of obligation arises therefrom in the facts of the present case. All the affidavits filed by the respondents are annexed. Petitioner's response. The petitioner's response to the aforesaid contention of the respondents. The petitioner has filed an affidavit in reply against all the respondents. The petitioner states that the contention of the respondents regarding the purported consent of the petitioner and his wife was obtained by consent form dated 12 March 2018 is completely bogus, and the document annexed at page 434 to 436 of the petition is forged and fabricated. The said document as it stands today is dehours all applicable rules and regulations. The relevant regulations are 3.2.5, 3.2.7, 3.5.15, 18 so on of the ICMR guideline 2005. Lord, the respondents admit that these guidelines is applicable to them. The statements made by the respondents on oath are false. The respondents have made baseless stories to somehow justify the illegal action. The respondents have stated in their affidavit that the consent for using donor embryo was granted on 23rd May 2018. That is the date of embryo transfer, but no document have been disclosed to support such claim. The first contention of the respondent, even if believed to be true, the respondents were under an obligation to maintain the details of the donor and were required to disclose the same in case of medical emergency. The respondent first claimed before the Clinical Establishment Commission that they were never approached by the petitioner seeking details of the donors. The respondents, however, changed their stand before the Honorable Court and sought to justify their stand by stating that there was no official communication at para 22 and 27 and 24 of the affidavit in opposition filed by the respondent 5 and 9. The said contradictory stand in itself shows the malafide and malice of the respondents. The petitioner has further disclosed the letter issued by Dr. Joydeep Chakraborty, who requested the respondent on behalf of the petitioner at 407 of the writ petition. A relevant document is annexed. The respondent number 6, 7, 10, 11 in their desperation has sought to make out a case that they were not liable for any act of the respondent number 5 establishment, and they have no role in the management of the respondent number 5 clinical establishment. The petitioner, however, disclosed several documents to that shows that the respondents are making false statement and that HR is a family brand of Goenka family owned by respondent number 3 and 4, which are in turn owned by respondent number 6 to 11. The relevant documents are annexed, page number 62 to 74B of the writ petition and so on so forth. The respondents have themselves admitted at para 7766 of the affidavit in opposition filed by respondent 5, 9, 10, 11, respectively, that they are bound by national guidelines of accreditation, supervision, regulation, assisted reproductive technology clinics under the Ministry of Health and Family Welfare, Government of India, 2005. And as such, the petitioner is complaining the violation of the said guidelines as far as use of the donor embryo without the consent of the petitioner and his wife is concerned. The respondents were, however, obliged under the Assisted Reproductive Technology Act to provide the details of the donor as mandated under Section 21E of the Assisted Reproductive Technology Act, and the respondents have neither addressed the issue nor raised any defense with respect to the in view of the action of the punished and in view of the West Bengal so and so. Lord, I have twofold submission before my lord. Lord, what happened actually on that day? Lord, we were visiting them since 2016.
Yes.
Lord, the first attempt failed, the second attempt failed. 12th March, the consent form was signed. 23rd May is the day when, my lord, the embryos are transferred. The embryo transfer form doesn't speak about that it's a donor's embryo. Doesn't speak about. Before I take you to this judgment, Lord, I will take you to the impugned order. Before that, I'll just take 2 minutes. Doesn't speak about. Now, what they have done, they claim, Lord, they have coming out with two defense. One is that we have consented. Now, that form, that consent form, bears only the signature of my wife. It is their case that only my wife consented, and she said that I will get the consent of my husband. And on that fateful day of 23rd May, on that very moment before the transfer, we said very well, look, don't transfer our embryo. You transfer the donor's embryo that you created. No document at all. 12th March, we signed the consent form. Lord, creation of embryo takes at least 3 months time or 2 months time. So it is their case that on 23rd May, suddenly I said that use the donor's embryo, and they immediately pushed in the donor's embryo. Very well. You admit that you have pushed in the donor's embryo. Let us, for the present, Lord, not go into the issue of consent. Even if, Lord, let us take a case that there was a consent. I will argue that there is no consent. It's not a valid consent. I have documents and the law in my favor. But even if there is a consent, today I go with my wife to an IVF clinic. I give consent. Please use the donor's embryo. What is the law? They are under an obligation to keep the details of the donor with them, and that they are bound to disclose in case of a medical emergency.
Correct.
Mr. Kaur's client, the institute, initially said that we have never approached them. If they had approached, we could have saved the child. But before the High Court, they say that not only they tried to save, they roamed around the entire city of Calcutta in search of that particular person. But the name of that particular person is not disclosed in the affidavit. Lord, the Clinical Establishment Commission, in its order, has categorically observed that they are responsible for the death of my child.
How you prove? Kindly come to page 7, para A.
Page 7, para 8.
Para A.
Para A.
Para A.
Consent form.
The contentions of the respondents. The consent form.
Synopsis. Lord, page 7, para A.
The consent.
The consent form dated 12th March is genuine, and the petitioner and his wife agreed. It is their case. It is their case that it is genuine. Consent form. Now, kindly have a look at that consent form. Now, kindly come to the page 16 of the compilation.
60.
Yes, 16, 1-6. Or page 15. Page 15 is the document which is appearing at page 434 of the writ petition.
Yes.
This is the consent form that they are producing in their affidavit. Now, kindly have a look at that. Lord, I'm so grateful my Lord wants me to place it. I, so-and-so, being unable to have a child of our means, by other means, have requested to staff working in the in vitro fertilizing unit in the Institute of Human Reproduction to help us have a child in IVF and embryo transfer. We had full discussion with Dr. M.L. Goenka, Dr. Anjan Chatterjee, and we understood that hormones and other drugs are administered to the woman to stimulate the ovaries for development of the follicles which contain the eggs. The eggs retrieval is performed by means of laparoscopy or ultrasound direct follicis aspiration. Eggs are fertilized with the husband's semen, donor semen. Embryos resulting from the fertilization are incubated in the laboratory until the time of replacement. The selections of most suitable embryos are done for replacement in the uterus. We consent, now kindly mark this, we consent to this procedure and to the administration of such drugs to the woman as may be necessary. 2, we consent to the mixing of the following. But kindly says all boxes are ticked. My oocytes, sperm of my husband. Anonymous donor oocyte, anonymous donor sperm.
Correct. That's why this 4.
This cannot go. That is contrary to medical science, that contrary to law, that contrary to the guidelines of the ICMR. And that contrary to clause C above. Eggs are fertilized the husband semen or donor semen. You cannot use 2 semen at the same time.
Correct. Anyone.
So the defense of the institute is that this is the consent form that we signed. Lord, kindly allow me to read further. We understand and accept that there is no guarantee of success and hence we will not claim refund of money. We understand that it is not possible to guarantee that eggs will develop in given cycle and that the occasionally cycle has to be abandoned before eggs collection. In that situation, we will be charged for the drugs used plus rupees 5,000 as cycle monitoring charges. We understand that sometimes eggs are not recovered at the time of egg collection from follices. We have been told of the risk of laparoscopy and ultrasound direct follicis aspiration. Our spare embryos can be donated to another patient used for research, should be destroyed, cryopreserved for the future uses. Because when they create embryos, they create either 6, 8 or 10 embryos. We do not give our consent for egg sharing with other patients. We understand that should a pregnancy be established, there is a risk of ectopic pregnancy and miscarriage. We understood that as in natural conception, there is a small risk of fetal abnormality. We understood that the chances of problems developing during pregnancy are greater if the multiple pregnancy occurs. We have been told of the side effects of the drugs in IVA PT clinic, so and so. Now kindly turn the page. Next page is the same page. Kindly come to page 17. We understood that more than one embryo are transferred in the uterus for better pregnancy rates. This may result in multiple pregnancies and its associated complications. In case of testing in tissues, aspirations, sperm may not found in the tissue extracted, aspirated. In that case, I would like to cancel the cycle. I would consent the donor for the purpose of advancing the medical and scientific knowledge and education. I consent to. Look, these boxes they forgot to tick. The admitted observations, so and so. Then 15, we understand that the doctor cannot be held responsible for physical and mental characteristics of the child. All types of anesthesia proposed, general, regional, so and so, has been discussed in terms of so and so. We have been given the time to consider the contents of this document and we have been given the opportunity to make such further inquiries as we wish. 10% of the amount will be deducted. Then kindly see signature. Wife Gunjan Kothari only signs. Then we give the consent for use of donor sperm. There is no signature either of the husband or of the wife. Lord, they are coming with a case that my wife, I'll place that portion of the affidavit, that my wife has taken the responsibility. She signed and she said, don't worry, I will convince my husband to sign. What is the law? The law is that the consent has to be informed consent and signed by both the parents and in presence of a third party witness. Lord, my lord would not find any signature of a third party witness who is not associated to the institute.
Yes.
Lord, kindly pause here for a moment and Lord see the guidelines for a moment with regard to consent. Lord, kindly take the page. Lord, kindly take Lord 574. Kindly take Lord volume 3. Volume 3 to din. Lord, I will rely on clause number 3.2.5.
573.
574. 3.2.5.
Volume में नहीं है, दूसरा चौथा, fourth volume.
Oh, sorry, volume 4. I'm so sorry, Lord. I'm so sorry. The guidelines would have been more than the writ petition, so we did not annex this compile. 574. The guidelines is not heavy. Now kindly have a look at 3.2.5. No treatment should be given without the written consent of the couple.
3.2.4.
3.2.5.
Yes.
No treatment should be given without the written consent of the couple to all the possible stages of the treatment, including the possible freezing of supernumerary embryos. A standard consent form recommended by the accreditation authority should be used by all ART clinics. Specific consent must be obtained from the couple who have their gametes or embryos frozen in regard to what should be done with them if she dies or becomes incapable of varying or revoking his or her consent. Then kindly take 3.2.7, use of gametes and embryos. No more, Lord, this is very important apropos to that 4 ticks.
Yes.
No more than 3 oocytes or embryos may be placed in a woman in one cycle. Lord, I had been through 3 cycles, 3 times, 1 cycle per IVF. Regardless of the procedure used, excepting the and under exceptional circumstances such as an elderly woman, poor implementation, so and so, so and so. Then kindly the next sentence. No woman should be treated with gametes or with embryos derived from the gametes of more than one man or woman during one treatment cycle. So if we now, keeping this in mind, see, Lord, that 4 boxes. There has to be involvement of 2 women and 2 men.
Yes.
The circular says that not more than 1 man or 1 woman.
More than 3 also it is.
Lord, first portion is not very relevant. Second sentence.
No woman
should be treated with gametes or with embryos. Gametes mean either the sperm or the eggs, or embryos, which is after the creating, from the gametes of more than 1 man or woman during any treatment cycle. These 4 boxes, when you tick and produce it before a court of law, then my oocytes mean 1 lady, donor oocytes mean 2nd lady, sperm of my husband, 1st man, anonymous donor sperm, 2nd man. So the institute, knowing this guideline, they wanted that the patient should undergo an IVF treatment where the mixing of 2 sperms of 2 men and 2 eggs of 2 women are allowed. This is the document they are relying on, not my document. Apart from the fact that this is forged according to us, there is no sign of my husband, but their own document, contrary to 3.2.7. But kindly consider this. The defense that they are coming with, that Gunjan Kothari has signed and she ticked all 4 boxes. This is not medically allowable, possible. That you take sperms from 2 men,
Possible.
which is not permissible. Perhaps, Lord, I don't know whether it is possible. The institute can say.
Not possible, neither possible nor permissible.
Yes. The institute would be in a better position. They are doing it day in, day out, mixing sperms, eggs, and the childs are dying. They would be in a position to say possible or not permissible in terms of 3.2.7.
Correct. No woman should be treated.
More than 1 man or woman.
Correct.
So you cannot prepare an embryo or create an embryo where more than 1 man and woman involved. Then kindly come. Yes, kindly come to the writ petition, that clause that I was showing, so that I could conclude on the consent today. Kindly take 3.5. No. Provide DNA mapping. Kindly take 3.5.
Police has filed the final report. Police has filed the final.
That has gone.
That has gone. Now, when they filed the final report, whether these documents have been sent to the CFSL.
What the police said, they said that they could not retrieve my signature, my wife's signature, which she has done at that point of time. Obviously, they are friendly police officers.
The only allegation was there was a forgery in the form. That's the basis of the FIR. So, my lord, it was sent to the handwriting expert and report was filed. And then they filed a Naraji.
But with a signature which was not obtained, they said that we could not obtain a signature of 2018.
No, I am not on.
Hello?
This form 1, where the 4 have been ticked.
Yes, now that has to be, whether that is my wife's signature.
Who has ticked that?
Yes, they must have.
But that is not the scope of the FIR. That's not the scope of the FIR. Only the signature.
I'll show
But
the FIR.
Directorate will, I'm sure, show.
I'll show the FIR. Lord, kindly come to now 3.5.15 at page 380, 580. যে তার আগে ওটা দেখিয়ে দিই নাকি? হ্যাঁ, 580 পরই 586, 580, 586. Yes. Kindly come to 3.5.15.
Yes.
না না, তোমারও তো তারা কিসে? Lord, kindly see when. Lord, I'll just conclude on this circular. Lord, just give me 5 more minutes time.
Yes.
Or should I come back on the next day, Lord? If my Lord gives me 5 minutes time, I can show the consent. Just have a look at quickly 3 clauses. 3.1.3.5.15. When DNA fingerprint technology becomes commercially available, the art clinic may offer to the couple a DNA fingerprint of the donor without revealing his or her identity. So in case of a donor, it is their duty to give me the DNA fingerprint. An art clinic will then have DNA fingerprint done of the couple and keep it with the DNA fingerprints on their record. Then 3.5.18. Semen from 2 individuals, Markali, mark this. Semen from 2 individuals must never be mixed before use under any circumstances. So this also nullifies the form. Then 3.5.22. The consent on the consent form must be a true informed consent witnessed by a person who is no way associated with the clinic. But kindly come back to the consent form again. You also will try and when to find out any signature of a witness who is independent.
There's no signature.
One more clause only, page 386, 3.12.2. 3.12.2 sir, 386, 586.
Yes.
Children, 3.12.2, 586.
Yes.
Children born through the use of donor gamete. Now let us take a situation on the second case that there was a consent donor gamete and their adopted parents shall have the right to avail medical and genetic information about the genetic parents that may be relevant for the child's health. So their defense is there was a consent.
Yes.
But if my lord accepts that, apart from that, the consent is not informed, not supported by any witness, that is not acceptable under this. I'll show the ART Act also. Even then, I say the moment they say there was a consent, it was their duty to keep the record of the donor and give it to me in case of a medical emergency, which they have not given. I'll Lord, if my lord allows me, I'll come back on the next day and my lord start from here, my lord. Joseph কবে রাখেন দেখ কাল কি রাখো
But the counsel for the
Lord, these
petition,
replies, my lord, may keep on record. They filed oppositions.
petitioner has filed the affidavit and reply. Let the same be kept with the record. Counsel for the petitioner has argued the matter at length, but due to paucity of time, hearing could not be completed. Date hai kya? 19th February at 3:45 p.m.
But that week, I am in little difficulty. Could we, Lord, week commencing from 23rd, Lord, any day, subject to my Lord's convenience? আমি বলছি না ব্রিফটা পড়বো তোর আর্গুমেন্ট শুনে
23rd 3:45 p.m. Your problem.
Oh, only on that day. I'm not in Calcutta on 23rd. 24th,
26 suffix hai.
No, I don't understand why the institute is so involved in the matter.
2nd March 3:45.
মাছ হবে আমি থাকবো না আমি থাকবো ঠিক আছে
Second March, sir, আপনি বলুন second March তো হোলি. Lord, 2nd March, my lord may take it from me. There will be no court on 2nd March. Take it from me. There will be no, we will do something.
No court since morning.
No. 3 o'clock onwards.
No, we'll try, Lord, that.
Because that next day is a holiday. That is
Continuous holiday. Only one day is the
Sir,
work.
Mr.
Chakraborty doesn't stay in Calcutta. আমি ওই 22 তারিখ অবধি নেই।
11th March,
March
3:45. Flood. 3:30, I will not.
Madam, may marks it part had Lordship is giving us.
Don't worry, nobody.
After Lord Justice Jamir, they have made.
Huh?
I don't know what will happen to them. I don't know. Mark is part had.
Jamir is different bench.
But just one indulgence, my lord. Just one indulgence at this time of the year, my lord, and seriously being reprimanded, my lord, making a very unreasonable request. Item number 10 of my lord's list, my lord. I'm praying, my lord, if the matter may be, my lord, given some precedence. The reason being, my lord.
I am giving precedent to all.
Yes,
that.
my lord, I know, my lord. That is why I said that I'm making a very unreasonable request. But
See,
circumstances warrant.
It is the 10, let it be 10. I will see. I will take the matter.
Because, my lord, I'm being forcefully evicted. I'm a statutory
That's why
tenant. That is
one fixed matter will not be taken, then I will take the 10 matters of the regular. If the fixed matter, it is different.
I'm at the threat of eviction.
That's why
Very
it has
well,
come on
I'll
10
not-
और ऊपर कर दो देखो टॉपिक में है वो तो और कहाँ जाएगा